Commission meeting will come to order today, and the roll call should show that all commissioners are present. The next thing on our agenda is the election of chair and vice chair. After 2 terms, I'm ready to step down. Madeline is ready to take it on, and Marilyn is willing to be vice chair. So if someone has another idea, that's fine, but we're open for nominations. Or a motion.
I'll make the motion
Mhm.
for those 2 nominations.
I'll second.
All right, so we have a motion and a second. Those in favor, voice vote.
Aye.
None opposed. Great. All right, then we're gonna make the switch.
There. I've already spilled it, don't worry.
Molly, is this something of yours?
I can pass it over, it's fine.
You get to see the board and everything.
Yeah.
So do we have a determination of legal notice?
Yes, we do.
Okay, everybody had a chance to look at the calendar. Does anyone have any comments on the calendar?
Looks good.
Do we have to vote on that?
I don't think so.
Okay, everybody's good with the calendar, okay. Is there a director's report today?
The director is available for questions, no report at this time.
Okay, so we have come to matters from the public. This is a time when the Planning Commission welcomes participation in commission meetings. And this item is limited to matters within the jurisdiction of the commission that are not on the posted agenda, and items which have not already been considered by the commission. Is there any member of the public that has an issue they'd like to bring forward? Yes, ma'am? Yes, please, come up to the thing and, oh, that was
Question
just a
for
speaker
Candace.
card, okay. There is no consent calendar, so we will move to the regular calendar. The first item is case MS 2003-0001.
Hello. Good morning, Commissioners. I'm Robert DOSTALEK, Staff Planner. And the project before you is the proposed wood minor subdivision. The proposed project is located north of Ukiah on Lake Mendocino Drive and involves the subdivision of an existing approximately 2.1 acre parcel into 4 new parcels and a remainder parcel. The project also includes a request for an exception to the 60-foot road width requirement and the naming of the private roadway Wood Lane. And the project site is currently developed with a single-family residence and storage structure accessed by a private driveway off Lake Mendocino Drive. From Lake Mendocino Drive, the property gently slopes southeastward here toward the rear yard, which terminates at the Russian River. Existing residential development surrounds the parcel to the northeast and the southwest here. Like much of the surrounding downstream area, the project site lies entirely in the Coyote Dam inundation area. And the zoning and general plan designations for the subject parcel are both suburban residential. General plan policy DE 13 directs that lands within the SR classification should be located within sewer or water district service areas, and ideally both. Parcels with the suburban residential classification located within water or sewer service districts may have a minimum lot size of 12,000 square feet for single-family residential dwellings. The parcel is located within a water district but not in a sewer district. Am I breaking up a little bit?
It's okay.
Is that okay? When the project was originally submitted in 2003, you probably noticed that the case number is 2003, so it's been some time. Water service was not available from the Millview County Water District. However, later, a letter dated November 18th, 2015 from the district indicates they now have sufficient water to supply the project. Therefore, the minimum 12,000 plus square foot parcels being proposed would conform to the minimum lot size for the SR land use classification. And there currently exists one single-family residence and storage structure on the property, right here, which would be located on the remainder parcel. The suburban residential zone district typically requires a front yard setback of 20 feet. However, due to the parcel configuration and the existing roadway, the existing residence would become non-conforming to the corridor preservation setback and front yard setback as a result of the newly created access road. Specifically, the existing house would be positioned approximately 11.5 feet from the edge of the proposed wood lane private road easement. That's right here. Otherwise, the proposed subdivision would be consistent with the general plan, including the Ukiah Valley Area Plan and other applicable zoning codes. The project was reviewed by the County Subdivision Committee on June 6, 2016, at which time conditional approval was recommended to the Planning Commission. An exception request has been submitted to reduce the private road easement width from 60 feet to 30 feet. The roadway easement location is significantly constrained, and it's positioned between two existing single-family dwellings. There's another dwelling right here. Accordingly, the easement width reduction exception to 30 feet has been deemed accessible by the Mendocino County Department of Transportation and the Ukiah Valley Fire Authority. An initial study was prepared for the proposed project and completed in accordance with the California Environmental Quality Act. Staff did not identify any potentially significant impacts to the environment which would result from the project that would require mitigation. Therefore, a negative declaration was prepared. And with the ability to make the required findings, the proposed minor subdivision is recommended for approval by the Planning Commission. And one last note I'd like to read into the record is a correction. Condition 26D on the resolution, page 7. The first sentence where 22 is spelled out should be 26 to correspond with the following numerical figure. And otherwise, that concludes staff's presentation, and we are available for any questions. And I believe we have DOT here as well, and the applicant. Thank you.
Are there any questions for staff? Yes.
I'm sorry, Robert, could you, that was page 7, so that's the last page of the packet?
That's correct.
And could you clarify where that is? I'm sorry.
Correct. 26, actually, the condition starts on page 6, but it trails over to 27, and it's D.
Mm-hmm.
Oh, excuse me. B. I'm sorry, I may have misstated that. So 26B at the top of page 7, the
First
second.
sentence.
Correct. First sentence where it says 22, the word 2 should be replaced with 6 to correspond with
Great,
the
thank you.
number.
And I had some other questions if
Sure.
any of the other commissioners do. On page 4 of the staff report, it's just a minor correction under item 4, environmental protection. An initial study for the proposed project was, I believe that word is supposed to be completed, not competed.
That's correct.
Okay, and then in the resolution, page 1, I could be wrong on this, but it starts out, whereas the applicant, Kenneth and Lynn Wood, I think that should be applicant, shouldn't it?
In which portion are you speaking?
The resolution, page 1, the first whereas, the applicants.
That's correct.
Okay.
Yes.
And I had 1 or 2 more here, sorry, let me get organized. 2, also of the resolution, the top paragraph where it begins, the proposed remainder parcel and the neighboring parcel due south. I think that's more like west, but maybe it's southwest.
Proposed remainder parcel in the neighborhood parcel due south. That's correct, yes.
So are you
That's-
making that southwest or just west?
Southwest would be,
Okay, thank you.
would correspond with some of the other descriptions in the report.
And then another one on page 3 of Exhibit A. Down at the bottom under biological resources. It reads California Department of Fish and Game. I believe that's now Fish and Wildlife.
Page 3.
Yeah,
And,
and I'm not sure on that, that's why I need to check.
excuse me, which portion of page 3?
Exhibit A, biological resources number 4, the bottom of page 3.
I want to make sure I'm looking at the same one. Is
It's
it
the Exhibit A.
the initial study? Oh, okay, let me see
The second line, would that be right, Marilyn?
here.
Third line. Oh, yeah, and second.
Page 3. That's correct, yes, so that should be
Fish
Fish and Wildlife,
Okay, I wasn't
correct.
sure on that, but. And then I had one more here, I think. I know I did. I was just curious, Robert, under the staff report, page 3, where it reads, a non-conforming configuration, and I think that's right in the middle, let me see here, yeah. Where the sentence begins, there currently exists, and it says, down in the middle, due to the configuration in the northwest corner of the parcel, the existing residence would become non-conforming. And I didn't know if that needed to be added to the exception findings. Maybe it doesn't, but I just needed to check with you on that.
That could be added to additionally support the exception findings.
Okay.
We could add that in there.
Okay, okay. And the only other thing I did want to disclose that I did meet with the applicant at the site. Thank you.
Question, Madam Chair?
Yes.
Would you remind me why the county requires that the well be capped, the well that is on the parcel?
Yeah, we don't have environmental health. We could call in, we have someone on call. Right. Yes, we do have environmental health here.
Oh, good.
One moment.
Catherine Gamble with Environmental Health, stepping in for Marlena and just records with the director Dave Jensen. And to the best of my knowledge, I believe that the 20-foot shallow well is just was hand dug, so not to today's standards, does not have the sanitary seal that we typically see to today's codes. So as part of one of our environmental health conditions, they requested that that well be abandoned and destructed per county codes.
Very understandable. Would there be cases where an existing well in a subdivision might be allowed to remain in use if it meets current standards,
If they,
even if they're in a water district? Do we know?
I'm unsure of that at this time. I have seen where if they could get a sanitary seal, but that's typically 20 feet. So if the well itself is only 20 feet,
In this
then
case.
that most likely is not
Of
going to
course,
work.
Of course. And it was just a curiosity. Thank you very much.
Yep.
Anyone else? Then I guess we could hear from the applicant if they would care to speak to the project.
And excuse me, I have one other
Oh, sorry.
correction. With the changing of the chairperson for the commission, we should correct that on page 2 for the signature area.
Right.
That's all.
Would the applicant care to speak?
I would like to especially thank the planning
Please state your
staff.
name for our record, if you would.
My name is Kenneth Wood. My wife is out of town, or she'd be here today, and I'm the applicant. I would especially like to thank the planning staff, the Department of Transportation, Ukiah Valley Fire, and all of their help in getting ready for today. I would also like to thank all the Board of Supervisors for showing up on this rainy day. The well that was mentioned is exactly what they said, and it would have been capped and sealed off a long time ago, but the person that's doing my water perk tests requested that the well be open, and we've been taking data on how low the groundwater is. We took it last year, and the highest it got was 22 feet. So the groundwater is well below the ground, the surface of the ground. Similar results are happening this winter. And that, as soon as we get that database, the well will be capped. So that takes care of the well. This project from the staff has no of 18 environmental factors potentially affected. That's kind of on your sheets that you have in front of you. The staff answered 90 items for environmental impact. 70 had no impact. 20 had less than significant impact. None had with less than significant impact with mitigation or significant impact. So that tells you kind of the status of this project. And when you look at the up there, the color photo of the project or the area, you can see that there's trees right there. You can see there's trees all over the place. There's an existing driveway that starts at Lake Mendocino Drive and goes all the way to the water for the Army Corps of Engineers, and that's going to be the road, the new road that we're proposing for the subdivision. And on that other map that he had, you can see that that existing easement is still in effect, along with several other easements for PG&E and water. There's water and natural gas in the road already down to, they'll have to be extended about 100 feet or so to fit the last 3 houses, 3 parcels that we're asking for of the 4 new parcels. I don't know how to proceed. I've given the planning department some recommendations of differences that I have with what staff came up with. Number 1 is okay. It's just something that goes on the map. Number 2 is okay. Something goes on the map. 3 is okay. Fish and game fee I don't like at all. I've discussed this with Marilyn, and there was no response whatsoever from Fish and Game, and I'm going to get charged $2,266.25, and I have to pay that to the county before 1/24. Since my wife's out of town, I kind of asked that maybe that could, if that date could possibly be extended a little bit for my Fish and Game fee payment.
We can take up that question
Now or later?
after you finish your presentation.
Okay, thank you.
And we've had a chance to discuss.
Number 5 was okay on the map. Number 6, okay, a letter. I think I already gave that letter to the county on 9/25/16. 7 was okay on the map. The floodplain is finally in the right place. They can't let enough water out of the dam. I'm about the 4th house underneath the dam, and the dam can't let enough water out of the dam ever to flood my house. So now the floodplain just runs right down through the middle of all those trees that are alongside the river. And it's halfway up at a channel, which the Army Corps of Engineers made a rock riprap channel coming straight out of the dam and behind my house. Right now, the highest the water has ever been is about halfway up the channel, and that is just the last few days. It's that high. It can never get any higher. And when they put the power plant in, that even eliminated some more water, because the pipe going through the power plant. for how much water can go behind my house. So the floodplain is kind of a mute issue right now for me. Okay, number 8 is okay on the map, number 9 is okay on the map, number 10 is okay on the fire district. I'd like to change the 2 letters. The one in April, I'd like to change to part of it, because the one in September addresses some things in that letter and changes them. Instead of all of that first letter being, and me needing to comply with all the first letter, the second letter changes some things in that letter. So parts of the first letter and all of the second letter by date. 11 is okay, environmental health notice. 12 is okay, environmental forms. 13 is okay, environmental forms. 14, okay, site plan from, 15 is okay. It's the water letter that allowed me to start, and I have a copy of it if you'd like to read it. The well, the 16 is the well, and we've talked about that. 17 is okay. If I need any Army Corps of Engineers permits, I'll get them. 18 is okay. Parcels are 12,000 square feet. I have Ron France is my licensed surveyor that I've talked about the property with, and Carl Ritterman over in Mendocino has seen the property and is preparing my septic system specifications. There's an existing structure setback on the site map. That's what we were talking about, the 11.5 feet. If you notice on that map there, it shows the property as being right along the edge of my house, which is right out by Lake Mendocino Drive. There's 3 things kind of wrong with that property, that map as it's shown. If we go back to that one that you had.
This one, oh, here. Here?
It's too close to my house. It needs to be moved towards the west, which is that way on the sheet there. And then that would leave me 11 foot 6 inches with a 30-foot easement over to my neighbor's property right opposite my house, which is the one kind of up the top, and which would be the one on the left of this here. And now you can see the 11 6-foot, and the wood lane is 30 feet, and then the property I don't own is to the bottom where the red line is. Then it makes a curve, and that was so my lots could all be pretty square. Otherwise, if it kept going straight, I'd have to do different size lots. And in the county code, the lots there's wording that would request that lots be kind of square and the road in the front and on and on and on. The circle, they show, almost all the other maps shows that curve going back up again. And when the curve goes, it goes straight. So now you can see the dotted line in there. There's a 15-foot easement for the Army Corps of Engineers that runs the complete line of the property. And that's where this new road will be. It'll be on the new road will be, that 15 feet will be under the new surfaced road. So close to my house, the easement that's not the road would be on that map to the top. And as you get further out after the curve, the easement for the road would be on the bottom. So the road proposed that I'm proposing and the T turnaround and everything would be in a straight line. And it'll use those parts of the easement to keep it straight. So the road wouldn't go like this. The road would go straight. And the easement would be up here and the easement would be down here. I don't think, and I don't know how much time you can give me, but I don't think I should have to pay the affordable housing. And I'll read why if I can go that far. I don't think, we've already, there's an exception to the 60-foot easement and it's down to 30 feet. So I don't have any problems with number 22. 23 is okay, 24 is okay, 25 says there's a natural drainage or a water course. And what it is, it's a man-made drainage ditch on the west side of the property. It's straight as an arrow. It drains properties to the north. The person immediately to my north put a 3-foot culvert underneath the road and has already been gone before the county to do that, calling it a drainage ditch and not a water course. At the end of it, where it dumps into the Russian River, it just goes out across all the riprap and goes down probably 15 feet to the river, across rock riprap. That's the face of the Russian River where it comes out of the dam. Then I get to 26A, and they want, and the Department of Transportation would like a 26-foot surfaced road going to my 4 new parcels. Lake Mendocino Drive is only 20 feet, and they want an additional 6 feet. And I'd like to talk to you about that and read some things later. Section B is in regards. 27B is in regards to the 26 feet, and if I can get that reduced to 20 feet, then number B needs to be changed also, which is the easement getting onto Lake Mendocino Drive. It wouldn't have to be as wide if the road's only 20 feet instead of 26 feet. 27C, encroachment permit, that's no problem.
26C, are you talking?
I'm sorry. 27C. I think it's 20.
26C.
Oh, I'm sorry. 26A, B, and C. The other 2 issues that I have are with Lake Mendocino Drive traffic. There's a lot of people looking to go to the river, and if this is a 26-foot wide road with a sign wood lane, people are going to think that can drive down it to look for the river. And during the summer, we have 4 or 5 cars a month, at least, that drive down that road looking for access to the river. I'd like not to put a sign wood lane, and I'd like to limit the width of the road to 20 feet instead of 26. And I will put the addresses out on the road, and if we call it wood lane, then there's been a request that the new properties have addresses for wood lane, and this doesn't make any sense at all. All the mailboxes are out on Lake Mendocino Drive for almost all the houses past the bridge, and not the big major subdivision before that. But and even those have mailbox. They don't have mailboxes on the individual houses. They have, big mailboxes. I'd like to just leave this alone and call. There's I'm 1021 and there's 1015. We could go above 1021 to 1031 and just list the 4 parcels with a Lake Mendocino address and have a mailbox out on Lake Mendocino Drive, just like everybody else. I don't know how much time I can give you.
Do you have any more to tell us?
I can give you specifications on why I'd like the suburban residential classification should have moderate to light constraints for residential development, and some of these constraints. Most of these constraints, if there's a section that says 1, 2, 3, 4, a lot of the constraints have chosen number 4, and I don't. The subdivision would these are things from the staff report. The subdivision would result in an increase in density, the 4 houses, I guess. Second resident units is unlikely due to constraints created by leach field requirements. In other words, what they're saying is there's probably only enough room in this 1,200 square foot, which is 1/3 of an acre, to have 1 house because of the leach field requirements for the river and the drainage ditch. So we're looking at only 4 houses and not the need to get ready for a whole bunch of other houses. The road dead ends and can't go past the river. It can't go to any other subdivisions or anything else. So that's kind of why I think the road needs to be only 20 feet instead of 26 feet on the surface. Then you get to Existing residential development surrounds the parcel in the northeast and southwest. Actually, residential completely surrounds the property. And they're probably at a third acre. They're probably at 12,000 square foot lots already. On the north, the west, and the east of my property, there's houses. This is what I'd like to do is I have a folder for each one of these that I'd like changed, but the main one is calling this a level C road and asking for a 26-foot wide deal. And I've already submitted all these exceptions to the county, and they weren't accepted as exceptions, but I'd like to read exception that I submitted to the county 1.3. Exception 1.3 to allow a 20-foot surface driveway, not 26-foot. DOT request 6916, recommended conditions for the Wood Lane private driveway. This driveway provides access to existing homes and will provide access to 4 new parcels. The existing road has an existing chip seal surface from 15 to 18 feet. Lake Mendocino Drive that has hundreds of cars a day going to homes, Mendocino Lake Clubhouse, and the south portion of Lake Mendocino is 20 feet between the 2 white fog lines, where Wood Lane will exit Lake Mendocino Drive. The fire department, Ukiah Valley Fire Authority, is in support of a 20-foot wide roadway surface. See attached letter dated 20 September 16. And the attached page with a figure. When I went to the committee, the road department was there and the fire department was there. And at that meeting, the fire department changed from 22 feet to 20 feet and initialed the map for me. So they've already, and that's for the whole road from Lake Mendocino down to the turnaround. And then in that last letter is all the dimensions on the turnaround. Instead of 120 feet that would allow a hook and ladder truck in the city of San Francisco to turn around, the fire department, thank goodness, came up with what their equipment and proposed new equipment would use for the turnaround. And that's what's in that second fire department letter, of the September letter. There will be no bike lanes needed on this private driveway. The 4 new parcels will have deed restrictions on the easement for ingress and egress that will not allow any parking on the driveway surface or on the turnaround. Once a month, a car will drive down our driveway looking for access to the river. It's way more than that in the summertime. A 26-foot wide private road with a street sign would add way more traffic to this driveway of 8 private property parcels. It's really only 7. One of the parcels only is on the road for 10 feet, and he doesn't really have an existing easement. It's just cumulative. He's been coming out that way, and so he can use the road. Then see exception 1.4, which is the street sign. So I've got one of these for all the things that I've asked for exceptions for. I'd love to read them all to you, but I don't know about time.
I think it's going to be kind of hard for us to keep track of this. I would rather kind of work through this with the commission and the staff at this point and have you stick around to answer questions if you would.
Thank you so much.
So, I forget where the first one was. Yes, I guess we should. Is there any member of the public that would care to speak to this project? Seeing none, I believe we could close the public hearing and take it back to staff and commission. Okay, so the Fish and Wildlife Commission, would staff care to respond to that? Or should you just want us to discuss it?
Madam Chair, Nash Gonzalez,
Yes.
Interim Chief Planner. I can go ahead and address that one. That is the state requirement. That's not something that can just be waived. I mean, it's applied to all applications that come through. And so, again, as staff has indicated to the applicant, some of these conditions cannot just be waived. And so as the commission has seen over time, this is a standard condition that is applied to every application that comes through where there's a negative declaration. And so the state imposes this condition, the county collects the fee on behalf of the state. And that fee, and that one of the questions that was raised earlier is, can this be extended out? The thing is that the fee has to be collected once the notice of determination is filed with the county clerk.
I think
Nash, am I right that he can appeal to Fish and Wildlife?
I'm not sure if there is an appeal to Fish and Wildlife. I don't have an answer for that.
I can speak to that. Mary Lynn Hunt, Senior Planner. There is a waiver process from Fish and Game, and we encourage clients to contact Fish and Game early on in the process to obtain a waiver. I think Mr. Wood spoke to the fact that he did contact Fish and Game and did not hear back from them. That leads me to believe that they will not waive it. We have not seen them waive this fee for any subdivisions. We've seen a waiver for subdivisions where all the houses are, the properties are completely built out. It's the only time we've seen them waive the process.
Okay. Did you have another question? Okay.
I thought this was a waiver request for the time of submission. Could we clarify that? I thought he was just saying that the date didn't work for him.
And
Whereas we're talking about a
I don't
waiver
know
of
if
the
we
fee.
can change that.
Didn't Nash tell us that the date was based on the filing of the
Notice of determination.
Right.
notice of determination? So
So
it
I'm not
doesn't
sure.
seem like we have authority
Yeah.
to change that date.
So that's the end, yes.
I just want to make one comment, which I've commented probably in the last 8 years I've been on this commission. I have seen this fee increased probably, if not on a monthly basis, every couple of months. I believe it started out less than $1,000 8 years ago. It continues to increase. I know our hands are tied to do anything. I actually talked to the applicant about it, and I really think that it needs to be addressed by the public. The packet is sent to the Fish and Game. Rarely, Fish and Wildlife, rarely do they ever respond. In this case, they did not respond. Yet they're still collecting over $2,200 and doing nothing. Again, the commission doesn't have any control on this, but I am encouraging people that perhaps this should be addressed with Fish and Wildlife because it increases continuously, and I don't think it's fair for applicants to have to pay this fee when the Fish and Wildlife is not really providing anything.
Well, I can kind of concur with that, but I hope the applicant will accept that this is not in our purview to waive or change in any way. Let's see, what was the next item? Was the item 10, I believe, was the fire. The letter is dated April 20th, 2016 and September 20th. I guess I'm okay if the fire department's okay with making that all go to the September 20th period of time.
Is there a person from the fire department here?
Good morning, Kevin Jennings, Fire Marshal, Ukiah Valley Fire Authority. What can I answer for you?
Well, I think the gentleman felt that between these two letters there were some discrepancies, that what he was told on those two different times were different.
If I recall the letters correctly, the first letter was our just general recommendations based on what he presented at that time. He came back with a request for relief to a 20-foot roadway. 20 foot's allowed in the California Fire Code as the minimum roadway width. If the county should decide that they want a wider road, that's not up to the fire authority. Our minimum requirement is 20 feet. We're fine with the 20-foot roadway.
Okay, thank you.
Thanks.
Any other questions on this topic?
I'm not really clear, so I'm not really clear what the applicant was requesting, I'm sorry. Was that to delete the April 20th letter or parts of it? I'm a little unclear on that.
I'm a
Kim.
little unclear on that myself.
There's parts in the April 20th letter that weren't addressed in the September one. Anything that's addressed in the September one, I'd like to leave in the April one, but I'd like to delete the ones in the April one that were restated in the September letter. But there's things in the April letter that need to stay in that weren't addressed in the September 20th letter.
And those specifically are?
You want me to?
Well, I mean, is it road width, or just give me the areas?
It's like sprinklers for all new housing and some other things like that. And that, some of those were addressed in September and some of those. But all that I'm requesting is the sheet that I read says you're gonna do everything in the April letter and you're gonna do everything in the September letter. And there's things in the April letter that were covered in the September letter. You see what I mean?
Chair Holtkamp, Chair
I can read them
Holtkamp,
to you.
yes.
if I may, in the condition, it states, or other alternatives acceptable to the fire district. So really, we put this back into the fire district and let them make a decision on whether or not he will be in compliance with their requirements. We don't monitor each condition for the fire district. We leave that in their hands. And I think by having that one statement, or other alternatives acceptable to the fire district, they could make some changes and be acceptable, as long as planning gets the final clearance letter from the fire district before the map is recorded. I think we're safe with that.
So I think we're leaving that to you to make that arrangement with the fire district.
Yes.
And if they sign off, it sounds like planning has not got an issue with that particular.
Yeah, we've already agreed. It's just the way it was written in there is a little confusing.
Okay. Do you feel it's resolved for you now?
Yes.
Okay.
Thank you.
Item 21, the Affordable Housing Trust Fund. I'm not sure that there is any way to waive that.
Madam Chair,
Yes.
if I can address this one. As you may recall, several years ago, we were going through a housing element update along with the UVAP, and there were requirements to address both the housing element and the lawsuits that we were involved with the housing element. This was a requirement that came out of the both the lawsuits and the housing element settlement. And so there really isn't a way for the Planning Commission to waive this condition. It's been applied to all subdivisions since that time.
And I guess the remedy for the applicant would be to build one affordable unit.
So, Chair Holtkamp,
Yes.
just as I was reviewing the ordinance while we were talking earlier, and the Planning Commission does not have the ability to waive a fee. There is a provision in the chapter about adjustments, modifications, or waivers. At this level, it would have to go to the Board of Supervisors, and a fee would be charged to process that. I don't know that this has ever been done, so I can't speak what that procedure would look like, but that section does contain certain provisions about what the requirements would be to show that a waiver is desirable.
And does the ordinance not require the fee for 2 new homes or more? So this subdivision is one house more than the minimum requirement to meet the fee standards.
I believe so. I mean, certainly the section on the waivers talks about a distinction at 2 units, which this is clearly over that, going to 4 units.
Excuse me.
Yes.
One more thing. So, I guess I'm asking you, Nash, and maybe there isn't an answer, but could he designate, and I understand you're saying this goes before the board, but could he designate one of the parcels as being low income? Would that help with the decision of the board?
I'd have to defer back to council, but I believe it would have to be designated. If he designates it, then that property would have to be deed restricted for the construction of an affordable unit.
So there are things that we could talk about in terms of what he would have to demonstrate to the satisfaction of the Board of Supervisors, but that's a process that would be outside of what we're doing here. And I'm not
And
sure
would
that, I don't know, I don't
incur
believe
fees.
that there is, at least, it states a fee would be required to process the waiver. I'm not sure how that process works. But those are things that, if we wanted to pursue that beyond the scope of this hearing, then that's something I think he could have the ability to do, but we'd have to go through that with him and see what he could actually present to the board for a rationale.
So then I guess we would have to leave 21, and the applicant would have to address it with staff and the board. Is that correct?
Yes.
Thank you.
And if I could comment on that, the fee is there for a reason. And affordable housing is such a critical need in our county. This barely helps, but it helps. So I wouldn't really want to see us waive it. But we can't anyway. Maybe the board will.
Okay, and then I have something underlined about the 26-foot wide road, which is now 20 or 22. He is requesting it to be 20, but all our staff reports say 26 and 22. So it's sounding like the fire department would agree to 20 feet. Could we hear from the transportation department and what their view is of this?
Morning. Jeff Burnett, DOT. So the standard for subdivisions is in this case, it's 26 feet because he already has a bit of a road there, and we want it improved for the people who buy the lots. So it's 26 feet of new rock. Any other subdivision in the county in this situation has the same requirement. You know, the fire department has their code. It doesn't necessarily, they need at least 20, but we're asking 26. And
there is sufficient space in that roadway for a 26-foot.
yeah, with that easement of 30 feet. So.
Okay.
Could I ask a question? The applicant stated that Lake Mendocino Drive is only 20 feet wide.
It's an old road. It's the old state highway. It was built a long time ago.
So you're asking for more in that driveway than there is on Lake Mendocino Drive, is that correct?
Yeah, that's correct.
Thank you.
Any other questions or comments?
Well, this is a minor subdivision in a suburban residential area. Sometimes, in certain situations, it should be a major subdivision, according to the general plan. But there are standards for the suburban residential development that they may not match all those old roads that are around the county.
Yeah, it could
I
have
don't
been an
think
old
that's a
logging road.
reason not to enforce it, though, myself.
So they're not really the same. You can't compare them. That's what I'm.
Because we're trying to upgrade to the modern standard.
Yeah.
When will the county be upgrading Lake Mendocino Drive?
It's hard to say. I can get back to you on that. Okay.
Thank you.
Yep.
Thank you. So, any discussion on the commission here?
Well, my reaction is we've already allowed him a 30-foot easement rather than a 60-foot easement. I personally stay with the 26 feet. I would imagine the easement for Lake Mendocino Drive is much wider, and at some point it'll be improved.
Yeah.
I didn't understand his request about the realignment of the drive, but it seems like a late time in the process to be asking for a redesign of the road. Maybe staff could answer to that.
Madam Chair, I think what the applicant is requesting is a realignment of this so that it's straight as opposed to this curve right here. But again, as Commissioner Warner has pointed out, it is a little late in the game. It would require a revised map. Mary Lynn?
Sorry.
Go ahead.
I'm Mary Lynn Hunt. I just spoke with the applicant, and from what he states, the easement will still be curved, but the developed roadway will be straight. We were confused. We were thought he was changing the entire configuration of the easement and the roadway. So I think we're good with what he has.
Okay.
And the roadway is existing.
Any other comments or questions? Yes?
About the road sign, the name sign.
I actually am quite sympathetic about that, and as long as, you know, the fire regulations would be met, my own feeling is, I don't care if you have the name sign up there, because I can see your concern about tourists thinking that's a road to go down to the river. But I do think, you know, all the signage for fire department accessibility would still need to be in place. That's my own thing about it. I don't care about the street name sign, but yes.
Legal staff has.
Yes?
Do you want to go first?
Madam Chair, I was just going to add, we understand where the applicant is concerned about tourists driving down, but one of the issues that can address this is you still would have the private road name Wood Lane, but you would just add private road to that, which is what most people do on these private roads, so that it distinguishes it between a county road and a private road, so that people don't go down these private roads. So that's what I would offer.
And I know it is an issue in our county that there is not good signage on roads, and when emergency responders try and find them, they are difficult to find. I think that is, the private road solution might be a good solution for you. Yes?
On the coast also, you often see no coastal access. So a sign stating, you know, no river access might help a little bit.
And
Yes.
just one last comment on that, Madam Chair. We recently redid or revised some of our ordinances regarding property addressing, and one of the requirements was now it's specifically required that all officially named private roads shall be identified by a posted road sign, and that's in part with the issue regarding emergency services.
So I guess you have your answer there, it's required. Any other comments, questions of staff or applicant? Yes?
I marked 25. I don't remember why, but.
Oh, that had to do with the change of if it went from 26 to 20 feet, I
okay.
believe.
Yeah.
All right.
I believe, but in looking at it, I'm not too sure, because I had a question on that too. Perhaps the applicant could address number 25, Ken? I had change, but I don't know what the change was.
Is this in the staff report?
It says natural drainages and water courses, and this isn't either one of those. This is a man-made drainage
Oh, okay.
that I explained. The neighbor above me requested that from the county and got approval, and has a 3-foot cement culvert underneath his property that this runs through. And it's straight as an arrow, and it was probably put in when the dam was built. So it's a man-made drainage. It's not a natural water course. It's not a natural drainage or a water course.
So would you just like us to change it to say man-made drainage?
Yes, please.
Okay. Okay. Anything else?
I guess I think we're stuck with the 26 feet, if I understand right.
Yep.
And if I understand right, I think we're stuck with the wood lane. So I guess my question would be, as far as emergency services, would then, and maybe ask two questions here. So the mailboxes would be on Wood Lane, or would they be out on Lake Mendocino Drive? And I guess
I think the applicant stated he wanted those to remain on Lake Mendocino Drive.
with the Lake Mendocino Drive address, though. So I guess they would be addressed out on Lake Mendocino Drive, or would the houses need to be addressed on each individual house on the lot?
They're going to be addressed to Wood Lane. They're going to receive new addresses and be addressed to Wood Lane. They can put their mailboxes, and I'm sure that's how the post office prefers the mailboxes be placed, but the addresses will all be new off of Wood Lane.
Okay. Thank you. So I guess you understand that, Ken, that probably the private road and the,
So there's 4 other houses that address this existing road right now. Are these people, I've lived in that house for 50 years. Now you're gonna want me to change it to Wood Lane with a new address? This just is not right, guys. There's, it's something that I don't mind discussing with somebody at some point in time, and not at this meeting. But, and there's about,
Well,
yeah.
your property, you live in the house closest to Lake Mendocino Drive, right?
right.
So your address would not change, only the new parcel addresses would change.
I don't know. They're asking that the front road, the front, 11-6 now be the front of my house. So does that mean that I'm gonna need the address on Wood Lane? This house here has been in existence since before the dam was built. Are they gonna change? And I got a letter from them saying that it might have to go to Wood Lane, and it's in the file, and they said that would be okay. This house here has been in existence since the dam was built with Lake Mendocino Drive address. It just makes more sense to make this 4 Lake Mendocino addresses. You have numbers to put on them, and have the mailboxes out in front, and the people that have lived around there won't be completely new with Wood Lane.
Well, I'm
And
not sure
the
what
exception
way.
is actually granted somewhat in the things, because they said an exception.
You need to come to the microphone,
I'm
please.
sorry. They said there was an exception for Wood Lane that was granted by the staff. And that Wood Lane means like all the things that we're talking about, changes of address, where the mailboxes are gonna be posted, the wood lane sign. I don't care, I can put private road Wood Lane on the map. I don't mind doing that, instead of just Wood Lane. So,
Excuse me, who did you say told you there was an exception to Wood Lane? Who did you say told you that?
it's in the staff report.
I think part of the issue here, in talking with the applicant, is he started this process in 2003 and has been through numerous staff members who have indicated different things. And that could be where the exception to Wood Lane may be in a previous staff report between 2003 and 2016.
Could I say, the very first page on the Planning Commission staff report, minor subdivision, exceptions to the 60-foot road width requirement and the naming of the private roadway Wood Lane. So I did submit an exception to the Wood Lane thing, and it's addressed on the very first page
Well, I understand about the.
as being an
I understand
exception.
about the width, but I don't know that refers to waiving the name.
Madam Chair, Commissioners.
Yes.
I believe it's just how that sentence reads, and so it could be construed that also requested is an exception to the 60-foot road width and an exception to the naming of the private roadway Wood Lane. So it might just be how it's being read, but it's actually requesting that the component of the naming of the private roadway is also included in the request versus also being asked for an exception. And that might be part of the confusion.
Okay. And I see what you mean. That is very confusing.
Madam Chair, if I may.
Yes.
So speaking to addressing, you know, we address for emergency services, and there is the potential for new residences out there. And at some point in time, there could be additional second residential units if the sanitation district were to serve those parcels, most likely. And so not knowing if there is a number range available to add more addresses to Lake Mendocino Drive, I would be uncomfortable addressing that without having the county addresser take a look at it. So if you were thinking of changing that, I would suggest that we continue this to another meeting in order for him to take a look at it. Just a comment.
Could I ask of you, Mary Ellen, did you say that the house closest to Lake Mendocino Drive could keep its address on Mendocino Drive?
The county addresser would take a look at that and see if it would be available to do that. I can't
So
address
we're,
it here.
we're really just looking at 3 new addresses on Wood Lane.
In addition
For
to
new
all the
addresses.
parcels,
Oh,
all the
okay.
parcels on Wood Lane that take
Right.
access onto Wood Lane.
Well, 2
Or
of them
maybe
already,
6.
3 if you want to count the one on Lake Mendocino Drive on the, what would it be, I guess, west side of the Wood property. Those already have Lake Mendocino Drive addresses, the existing homes that are there. So, yeah, we're looking at 4 new addresses on Lake Mendocino Drive if we did not have the Wood Lane.
But it does sound to me like only the new lots, which do not have current residences, would be required to change to Wood Lane addressing, right?
All residences taking access on Wood Lane would be assigned a new address.
Gotcha.
Does the existing house, will it use Wood Lane, or does it come straight out to Lake Mendocino Drive?
One of the requirements of the Transportation Department was that I block off my driveway and all the new, everything come on the Wood Lane. So I don't, and that's when then the front of my house would be on Wood Lane and I'd have to change my address. And the other 2 houses that are on this easement that the Army Corps of Engineers gave required a 15-foot easement, when the dam was built. So this road, this Wood Lane private road has been in existence since before the dam was built. And 2 of the other houses, so 3 of the houses right now, out of the 7, the one that's closest to the road I don't even have on that map, but it has a Lake Mendocino Drive address. So the 8 houses that would use this Wood Lane, 1, 2, 3, 4 of them have addresses on Lake Mendocino Drive. The 4 new ones, I'm requesting have addresses on Lake Mendocino Drive also.
Sounds like that's not really possible.
So it seems to me like we're down to a choice. Would you like to continue this, or?
How many other things are we going to continue?
Well, I mean, we can go ahead with it right now, and all the addresses would be changed to Wood Lane. Or we can continue it and do some investigation. So,
And see if there are enough addresses on Lake Mendocino to do what you ask.
Okay, if it's stated that way, I don't have a problem.
Madam Chair, Commissioners, if I may. The county addressor actually did review this. It didn't make it into the report, and there was a limited amount of addresses available for the subdivision alone. As it relates to some of the existing parcels, that would, as Mary Lynn had mentioned, it sounds like it would only be the ones that would be taking access off of Wood Lane. But it would be appropriate to have a private road in this instance because there were a limited range of addresses between here. And also, as Mary Lynn had mentioned, with the potential of new services arriving into the neighborhood, namely sanitation, it could increase the number of residents that would potentially be able to be built in the subdivision.
Madam Chair, if I may add, it's always been the practice of the department that the subdivisions are referred to the addresser early on to take a look at. And I believe in this case, if it had been determined that there was enough numbering available for Lake Mendocino Drive, then it would have been a non-issue. But in this case, it was probably felt that a condition regarding the private road name and Wood Lane for addressing was more appropriate. But this has been a practice that's been around for quite a while. Refer it to the addresser. If the addresser looks at the numbering, there's not enough there. And again, it all comes back to emergency services. Can they find these parcels? And is there the ability for additional units to be placed out there? And again, as noted earlier, it may or may not happen. But again, we have to be prepared for this if the sanitation district ever allows for those connections.
Well,
Thank you.
it seems like if the applicant wants to go through with a subdivision that meets all the county requirements, I would be prepared to approve it as it is. But if he is not going to be happy with that, Maybe he wants to withdraw the application.
Or continue it, although I'm not sure continuing it unless we have some specific objective would be.
Okay, just use Wood Lane. I don't have a problem with that. This was started in 2003, and there was huge changes in the subdivision laws in 2008 and the highway laws. I mean, in 2000, fire laws in 2013. So, you know, I'm the only one that has been sitting on the calendar with a letter from the county saying don't do anything until there's a lifting of the water moratorium. I'm the only one now that's waited 13 years to try and process this. And all I'm asking from you people is what's in the code. You have the authority to change some of these things. It's in the Department of Transportation's street design handbook. You have the authority to change some of these things. And I can read you the sections in the street design handbook that I have right here. And that's all I'm asking for.
I think we need a motion.
Yep.
Well, I'm not really sure if the applicant is considering wanting to continue this.
Yes, please.
So are you interested in discussing this with staff more to see about, I think the issue is the wood lane, the 20-foot easement. Those are the two things that I see. We don't have much control over the affordable housing or the fish and game, changing the fee for that. So are those the two things you would like addressed, Ken?
That and we haven't talked about the association, the road association for 4 houses, which we don't need a road association for four houses. Anything that needs to be in a road association is going to be put in the deeds. If that's a 20-foot road, the fire department wants no parking on the road, and it'll be right in the deed for these 4 houses that there will be no parking on the road or the T turnaround. And these are all kinds of things that all hook together to make the project feasible. I mean, for me, and after waiting a long, long time.
Well, I have to say, I don't see the road association thing, since these are not existing houses. I'm not sure that I think maybe deed restrictions could work. But the rest of it, I don't see much way around.
You know,
go ahead.
Madam Chairman, I'm a real proponent of road associations because we've been in a bind many times where somebody wants to do a building and the fact that there's no road association scuttles the whole thing. And I don't know that it's a major economic issue. I think there's boilerplate contracts for road associations, so I would favor requiring it.
Yes.
In regard to the road association, I think the biggest issue with that is that you've got 4 people using one road, and one of the biggest issues that comes up is who's going to do the road maintenance. And that is what's taken care of in the road association. And I don't think the road association has to be all that complicated. It just has to cover the pertinent issues, and maintenance is one of the biggest ones. Who's going to do it? How's it going to be paid for? Because that's a private road.
So even that one sounds like it needs to stay, but you don't have to do any big thing. I think you could probably download some
Well, right off the
boilerplate.
bat, the road association wording has to be submitted to the county council, and he charges a fee to go over that. And I have no clue what, $1,000 is he going to charge to go over my definition of that? And that's right, that's in the recommendations. And I've been a forester for 45 years, and we've had properties all over the county at the end of roads, and I know that it can be handled by deed restrictions. Anything with the maintenance, and there's also state law. If you take something to court, there's already court proceedings that have said that the first person in the road will pay more than the last person in the road. It's all handled through deed restrictions at first title. So that's my feelings.
But a road association, properly done, would end up avoiding having to go through litigation to find out who's going to pay for the maintenance.
I think it's, do you want to pay up front or do you want to pay down the line? I don't think you get out of it, though.
So did I understand you to say that you would like us to continue this so that you can discuss the addressing?
No, I'll just do whatever you say.
Okay, you'd like us to settle it today?
Yes, please.
All right.
Okay.
I mean, it's been 13 years.
Yeah, I feel bad about that.
And these meetings have been scheduled that I had no response, but I couldn't go to them. So it's just gone on and on and on.
So you're comfortable with pretty much all of the conditions as listed then?
Not comfortable, but I'll agree to them.
Okay.
One other question.
Yes.
Are we clear on what the applicant is going to do with the fire department in combining those two letters? Like, is the fire department going to come up with one new letter that would take care of both of those and have the final results of the combination of the two?
Mr. Jennings, would you care to speak? Oh, staff
How-
has the answer to that?
Well, I think the condition reads that, what's ever acceptable to the fire department. So, as I said previously, it goes back to them. Whatever the fire district wants to do, then they will just give us a final clearance letter. So he would be
Okay.
working with the fire district to meet whatever they need.
All right.
Okay, then I guess we're ready for the motion. Is that
Yeah.
correct? Okay, to adopt a negative declaration and grant the subdivision map for the project based on the findings on pages 1 and 2 of the resolution and the conditions of approval on pages 3 to 7. Changing biological resources number 4 from California Fish and Game to California Fish and Wildlife. And changing number 25 under transportation from the word natural to man-made. And I believe that was it.
26 feet of this.
I'm sorry,
Yeah, the
26.
26.
Oh, B from 22 to read the number, 22 to 26 feet.
Is there a second?
Second.
So I call the question.
Commissioner Kruger?
Yes.
Commissioner Little?
Yes.
Commissioner Nelson?
Yes.
Commissioner Warner?
Yes.
Commissioner Hall?
Yes.
Commissioner Ogle?
Yes.
Chair Holtcamp?
Yes. And I think on that note, we will take a 5 or 7 minute break here. And 10-minute break. 10-minute
We tried.
What was that over there?
please. We are now to case OA 2016-003. We've divided this for ease of presentation into 2 parts, although the recommendation will go forward as one item. But we would like to discuss the Williamson Act portion of the staff report first and take comment from people who want to speak directly to the Williamson Act questions, and then we will move on to the balance of the item. So with that, we will begin with the staff report on the Williamson Act portion of this question. Revisions to policies and procedures. Yes, sir.
Good morning, Mary Lynn Hunt, Senior Planner. So you have 2 memos before you today, and as Chair Holtcamp explained, at this point, we're just addressing the Williamson Act item. So this is the subject matter is revisions to policies and procedures for agricultural preserves and Williamson Act contracts regarding cannabis cultivation. I'm not going to go into a lot of detail other than to tell you that our policies and procedures for Williamson Act, the changes to be made would be that it would now be an allowable use within your Williamson Ag contract to cultivate cannabis. However, it would not be a qualifier for inclusion into Williamson Act or for continued support of your agricultural operation. And the other thing that's noted in this memo is that, you know, you're only allowed up to, I think it's a ½ acre in size. So as a qualifier, 10 acres, you would need to have at least 5 acres of qualifying ag operation in order to maintain your contract. So that is kind of the gist of the Williamson Act contract changes. If there's any questions.
Any questions from the commission?
None.
Are there any other people we should hear from? Maybe Mr. Morris before we go to the public, but do you have other comments you care to make about this item before we open public comment?
Thank you, Chair Holcamp. Chuck Morris, Ag Commissioner for the county. The changes that are reflected in the red line version that is also supplied with the memo here are a reflection of voiced board desires at this point in time. And it, as we've seen in the mitigations, that the proposed mitigations for the program in general, that this was one of the proposed mitigations. And so we're just bringing that forward. I have been in discussion with Deputy County Counsel as well, and I'm in agreement with the changes that are being proposed.
Okay.
So you're referring to your memorandum?
No, sir.
No? Something else, okay.
Does anyone from the commission care to say anything before we open the public hearing?
Not really, except that it seems reasonable, the changes. I think the qualifying and income requirements are proper.
Okay, at this time, we invite members of the public who would like to comment on this issue to step forward. We have 2 speaker cards. One is Frost Polly is the first one, and the second one is Corinne Powell. And we'll get to that one. Mr. Polly.
Thank you, Madam Chair and Commissioners. My name is Frost Polly. I'm the president of the Mendocino County Farm Bureau. And as a side note, I'm also a property owner and of property that is currently under Williamson Act contract. The Mendocino County Farm Bureau is a non-governmental, nonprofit, voluntary membership advocacy group whose purpose is to protect and promote ag interests throughout the county and to find solutions to the problems facing agriculture, business, and the rural community. Mendocino County Farm Bureau currently represents approximately 1,200 members. Just as a general concern, Farm Bureau is worried about the impacts to Williamson Act properties that will come from allowing cannabis to be grown on those properties. In general, because of the high value of cannabis, we see it as likely that properties that are allowed to grow cannabis on Williamson Act properties will likely come out of contract. Having said that, Mendocino County Farm Bureau agrees that permitted medical cannabis cultivation may be a compatible use on Williamson Act properties, but would not support medical cannabis being a qualifying use. The board, we recognize and recommend that the Board of Supervisors and the Planning Commission find that medical cannabis be allowed to be produced on Williamson Act contracted properties, but not be allowed to be considered as a qualifying use, and that there needs to be clear evidence that the properties are in compliance with the requirement that at least 50% of the property is being used for qualifying commercial agriculture. Any Williamson Act contracts for properties involved with medical cannabis cultivation will also need to be vetted to ensure that compliance standards are met and that the intent of the Williamson Act to support production agriculture and open space is protected. I want to thank the Commission and for their consideration of the addition of 9.4E, which covers our concern that if medical cannabis is to be considered a qualifying use for Williamson Act contract compliance, then any medical cannabis accessory structures such as greenhouses or processing facilities would also not be allowed on Williamson Act properties, as current requirements for accessory structures are to be incidental, related, and subordinate to a qualifying agricultural use. Thank you, the commission. I know you've spent a lot of time on this issue and for taking into consideration the Farm Bureau's concerns related to Williamson Act contracts. Thank you.
Corinne Powell.
Corinne Powell, I'm from Ukiah. My concern in reading the information in the staff report, et cetera, was just that the state of California is trying to define cannabis cultivation within the agricultural realm. And I'm skeptical that if we start limiting agricultural use, agricultural allotment, agricultural definitions, that somehow we're going to run awry of what the state intention is, for which we all are trying to work so hard to emulate and with which we want to comply. So that's my only concern, is that definitions be really clear and that we not confuse definitions as we move forward in other areas.
And Hannah Nelson is my next card.
Good morning, Hannah Nelson. I actually would like to replicate what Corinne just said. I think more than anything, my concern is about the confusion about different definitions as we go forward. We found in a different context that the term commercial cannabis activity in a tax context created misunderstandings about it in an enforcement context, and so I think that it's really, really important to be clear. Also, I was aware that the state actually issued an opinion about this, and although of course local jurisdictions have the ability to make a different determination, but the state's opinion was that it was not at all incompatible to have cannabis cultivation under Williamson Act. And so I'm a little bit concerned about why we feel the need to take it out of that. I recognize local jurisdictions' ability to make different rules, but it does concern me, and especially when we're trying to say, hey, look, this is agriculture. We want everybody to follow agricultural rules. It's quite disconcerting. And if the intent of the Williamson Act in part is not just to protect open spaces, but to protect agriculture, and this is agriculture, then it just seems inconsistent to limit it in this way. And perhaps if there's a goal, a specific goal behind this narrowing, that we could address the underlying desire, and maybe there's a different way to approach that and address that goal. Thank you.
Thank you. Is there anyone else from the public who would like to speak on this topic?
Devin Jones, Mendocino County Farm Bureau. Just to reiterate a few points. One, the Department of Conservation did send out a memo, and it did direct that each county, within reason, has the authority to determine how to deal with cannabis specific to Williamson Act. I think the Williamson Act could be used as a tool in this situation as we get into the ordinance conversation. Farm Bureau has concerns where we don't want to see impacts to range, we don't want to see impact to timber, but we don't want to see impacts to our prime ag ground either. And so the Williamson Act is a means of accomplishing both of these things. If it is an allowable use, but not a compatible, or excuse me, a compatible use, but not a qualifying use, then those properties, to maintain the tax benefit, will still need to demonstrate that they are in production agriculture. Therefore, for all the permits that are going in under phase 1 on range property, we won't see a bunch of properties getting yanked out of production for livestock. The purpose of the Williamson Act and the tax benefit that was put in place is to support agriculture and open space. So that is our concern in terms of the difference between a compatible use and a qualifying use. We went through with the Lands Committee a couple years ago throughout the county, hosting meetings to be willing to allocate the qualifications based on income. So we're still waiting to see those first compliance reports coming in We non-renewed 50,000 acres the last time those compliance forms went out. Farm Bureau is in support of that for non-compliance. We understand this is a voluntary program that the county maintains. We understand that the property tax is a loss, but we want to see the program maintained for agricultural production and open space. Thank you.
Any other members of the public wishing to speak to this topic? Then we will close the public hearing and bring it back to the commission.
Chair Holcamp?
Yes.
Deputy County Counsel, I just want to confirm, we're not closing the public hearing as to this item. We're just coming back to the commission to discuss.
Yeah, we're not formally closing the public hearing. I'm sorry, that was my misstatement. But we're going to stop taking comment for a minute. Anyone from the commission have any comments on this item?
I'll just say about the kind of confusing use of cannabis as an agricultural activity and then not, as in this document. The difference clearly to me is the size of the area that would be the activity, the ag activity, is just too small to qualify. And so in this instance, related to Williamson Act, it isn't a qualifying agricultural activity. And I hope that's clear to everybody. It seems like a good way to differentiate.
And I had the impression from the whole discussion that what, at least in Mendocino County, the Williamson Act has been intended to support a diverse agriculture. And so we kind of don't want this to take over from all the other agricultural uses, and that seems sensible to me. It can always be modified in the future if it ever needed to. But so, if there's no more discussion, is there a motion?
Well, considering that this is a excuse me, this really is a mitigation measure for our other one, should we do a motion yet?
Or maybe we don't need to, okay.
No, the item was idealized as having one resolution regarding all of the marijuana aspects, including the Williamson Act.
Okay. All right, then, we will move into Part B here, which is amendments to the Mendocino County Code to add Chapter 10A17, Medical Cannabis Cultivation Ordinance. Staff.
Mary Lynn Hunt, Senior Planner, and I neglected to introduce everyone at the table when we started this meeting. So Legal Counsel Matt Kudowski, Ag Commissioner Chuck Morris, Mike Nelson and Beth Burks, they're both with LACO, our consultants on this project. So we're all here today to answer questions. We've been before you twice now with this item, and this is for for recommendation on the zoning ordinance section, which is chapter 20.242. Certainly a recommendation can be made for chapter 10A17, but that's really something that's being addressed by the Ag Commissioner directly to the Board of Supervisors. Okay. They do go hand in hand, in addition now with the Williamson Act portion of this also. So we have, we've provided a memo regarding the, a lot of this speaks to the initial study that's been prepared, and we have a couple of things. So on the screen, you're going to see a highlighted strikeout version. Unfortunately, that didn't make it into the memo before you. All you're seeing is something with underlines adding information. So on the screen is actually the item that you're going to be looking at and speaking to. There's a couple of items that are going to be talked about today. I think Commissioner Morris is going to talk to his 10A. He's got a memo to you. He also has a strikeout added version of his ordinance. Beth will speak to the initial study and to this memo, and then we're going to also have a presentation from County Council regarding enforcement. So I want to emphasize not only for the commission, which I'm sure you're well aware, but also for audience members, this is for the cultivation of medical marijuana. We're not discussing the dispensary or the manufacturing, the production. That's going to come at a later date. So it's just medical marijuana, or excuse me, medical cannabis cultivation at this point. So with that, I'm going to let Beth speak to her changes, and if you have any questions at that point, please ask.
Good morning, commissioners. Thank you. Beth Burks with Waco Associates. So I did just want to walk through these changes. It does appear that there was a formatting error in the published version. So you see the underlines where we propose new text, but what doesn't appear in the published version is the strikeouts. So it makes it a little hard to follow. So I just wanted to be clear for everybody, you know, on the commission and in the audience, exactly what we are proposing to remove. So under air quality, we propose to remove the mitigation measure which prohibited burning. So that's just a wholesale removal of that mitigation measure, but it also meant that we needed to delete a little bit of the discussion in air quality. And again, this was going back to comments we got from the Air Quality Management District, basically saying there was insufficient evidence about the burning. We reviewed that again in light of the public comments and decided that based on the fact that another mitigation measure has a referral going to air quality, that we could address this there. So we are recommending removal of the mitigation measure and then this text from the CEQA document. Next change is under Bio 1. This was in response to comments we got from the Department of Fish and Wildlife. It's really a logistical change to how the referrals to Fish and Wildlife will be handled. So originally we had applicants going to them first and getting some type of clearance, and they said they would prefer to see that in a referral packet during the application process. So we've got the new language there underlined, but again, in your version, in the published version, it didn't show that this actually was the strikeout in between the two underlined areas.
Can you go back, Beth?
Yes. Ready? And then there was a clarification here. This is was in relation to if there was one dwelling unit if you could have multiple sites on a legal parcel and up to the maximum you can. So that is the change that needs to be made here. And then there's also numerous changes that would be made throughout the document to strike out site, you know, the singular version of site. And then this was a question that came up at one of the first commission meetings. The ordinance does refer to the fact that you should not be able to have plants visible rather than the whole cultivation site. So we have strikeouts here just to reference the plants. Then in terms of the aesthetics mitigation measure 1, this has to do with the covering of mixed light uses. So there's basically a blackout period during the nighttime. We're striking out new so that it applies to all structures. So it's not just new structures, but every structure that has mixed light. And then we've also added the provision to have security lighting shall be motion activated and fully shielded. I think that's all the strikeout that's missing from your packet. So if any of the other items you want to discuss in the staff report, I'd be happy to take questions on those.
Okay. Anybody want to start?
Start?
Okay.
Be happy to. Beth, I'm going to kind of go through each page here. A lot of it, I think, is kind of wordsmithing, but on page 2 at the top, the third sentence where it starts, measure area 2 will be applied to prohibit burring. I think that should be burning.
Yes. Carolyn, what are we working on?
We're working on, I'm sorry, I think.
Yeah, sorry, that is of course.
It's the memorandum dated January 19th from Mary Land to the Planning Commission.
We got a lot of paper, though. Maybe we should try and refer every time to which
You know,
paper.
you're right, and all I'm referring to now is that memorandum, and I agree. Boy, I'd like to see it all combined into one because I'm
Get lost.
Yeah, yes, I did get lost.
Okay, so just one comment on that is that it is, that what you just cited is part of the strikeout that you're not seeing in your version, unfortunately. I'm
And
sorry.
that could be, but it's a little hard to follow all that.
Yeah.
Let's see, and then under the bio one, maybe that was corrected too. I know you had the highlight to require, but shouldn't there be after to require referral permit et cetera, for each proposed cultivation site and to require? Should there be an and between site and to in your, or am I reading that wrong? Seemed like when I read the whole sentence, it needed an and there.
Yeah. So yeah, the first sentence read, Mendocino County shall amend the MCCR to require referral of the permit, to require referral of permit applications. The S should go to CDFW for each proposed cultivation site.
And to require?
That's all.
Oh, sorry. Yeah, that all the highlighted is the strikeout.
Okay, I'm sorry, it's, yeah, okay. Then going down that same paragraph, a cultivator that can, let's see, where is that? Maybe that was struck out, I don't know, it's confusing. Upon referral, got all that. Okay, a cultivator that cannot demonstrate, okay, and then to sensitive species. And I don't know if that should be after the word species.
Strike out.
Species, okay, thank you. I had a lot of confusion with the sentence, or the paragraph that begins with staff proposes changing MCCR. And maybe your strikeouts have improved that too.
I sure hope so.
Okay, so I won't even bother with that. And then in the next paragraph, there are numerous changes to be made, et cetera, et cetera. Second sentence there, refer to the legal parcel in some places, or it just didn't seem to, yeah. Second sentence there, refer to the legal parcel in some places and the cultivation, I don't know, just in places and the cultivation in other places. It didn't seem to flow right.
Mm-hmm. Okay.
And then I think that was in the paragraph that begins changes to aesthetics. I think that you did already probably improve that one. Because I had sites to plants. Okay, that was right. Okay. And then on page 3, under change to table 1 and 2, I think where the sentence begins outdoor cultivation.
To the table?
No, up above. Change, where it says change to table. On mine, it's at page 3. There, change to table. I think where it says outdoor, yep, just below the outdoor cultivation suite, I think that's site. Is that correct?
Yeah. Yes.
And then you changed that one already. Gosh, okay. I think that was all the wordsmithing, thank you.
So on the same document, I guess a little background to my thinking is essentially what we've been doing isn't working, so we're trying something new. and we want to encourage as many growers to participate as possible. So we want to have adequate health and safety measures, but at the same time, we don't want to be too burdensome. If we're burdensome, I think we're going to have fewer people to participate. So in that vein, I guess first on page 3, we talk about AES 1 and the encouragement of oak woodlands protection and grading ordinance. We discussed this thoroughly in the general plan. We adopted some ordinances to take care of these issues, and I would like to suggest that we don't complicate the process by adding more burdensome regulations to growers. That was the first one. And then down on the second bullet, maintain that parcels RR1 and RR2 require a residence. I thought, for one thing, our last discussion said that we were not going to allow grows in RR2. And also...
RR5.
Okay. Well, this...
That's what I thought.
Yeah, or RR5, well, and we were not going to require residences because we didn't want to encourage temporary residences or residents to just put in for the purpose of qualifying for a license. So, am I correct on this, or am I off in left field?
My memory was that we kind of did agree about RR2. RR5, I don't recall.
Yeah, I'm fuzzy on that one
For
too.
sure. I know it was mentioned. I don't know if that was part of a
I know
straw
I
vote.
mentioned it, and I know I mentioned that I would really like to see RR10 and greater, and eliminate 1, 2, and 5, but I don't think it, I think you're
I think
correct.
we
It was
did
only
not resolve
discussion.
it.
Yes, that's correct.
And the housing, I know we agreed to not require a house in upland residential. I don't know that we agreed to the rest. I think it's still
The
kind of up in the...
RR10 and stuff.
RR10, RR5.
Yeah, I don't remember either, so I'm
Yeah,
hoping we
I think
can
that's
get some
still up in the
clarification
air.
on it.
So, as
Staff?
staff remembers, the direction was only to eliminate the housing requirement for the UR, the RR10, 5, and then we're up. There was really not a lot of discussion that went that far. RR2 was, there was talk of that coming out of the grow site. I don't know, we provided a pack of maps on site. I think you all have them in front of you. I was going to ask if Beth would put up. We've, of course, got the entire county zoning map, which it's a little hard because the scale's not good. But we do have maps showing kind of the more populated areas. This really came from a lot of the public input at the last meeting regarding the Regina Heights area. So I wanted to show the commission. I think it might be the last map, Beth. When we talk about RR2 or RR5, some communities don't have a lot of that. I think it's the last one. Sorry, things take a long way.
That's all right.
load.
I really appreciated your maps. I know we
Okay.
all did. It was great. Thank you.
So this is this is the area, yeah. It shows you that the Regina Heights area, El Dorado area is R1. There is no RR right there. The El Dorado area, which is just north there, Beth, that's Deerwood, sorry, that's Deerwood there. And that's an RR1 district. I'll show you that to the north of Deerwood, there is RR5 designation, so they would have the potential for sites north of them. And also the Deerwood extension out to the very east, that also is zoned to RR5. So there could be growth sites within that extension of Deerwood. With that, you can see that, yes, there is areas adjoining ag land, but you've got a little bit of buffer, usually the river's the buffer. There's rangeland off to the east, public, so there's your rangeland areas. So with that said, there's not a lot of RR2 in the Ukiah Valley. There's the RR5, of course. If you go to Laytonville, the Laytonville map, I don't know, it's more towards the top, I think. Is that Laytonville?
That's it. You can tell by all the groves.
No, we didn't put an aerial up.
There.
Is that Laytonville? I think that's Laytonville right there. So if you look at Laytonville's zoning, it's, the majority of it's RR1. There's adjoining ag, there's some adjoining rangeland. I think there's a little bit of maybe RR10 to the north. I can't quite see. Oh, there it is. Yeah, so with that, even there's really not any RR2. So just
So by
to kind
eliminate-
of show you what the different zonings are in these communities and what you've been hearing, we didn't have those maps in front of you, so you couldn't really be, they couldn't be specific to them.
So am I hearing that if we eliminate RR2, we're not having a big impact?
You're having a big impact in, and I will show you, or we'll show you the map in Fort Bragg.
But-
So it's a colored map, and
That's
it
where there are
shows
a
the
lot of
RR2 along the eastern boundaries of the city of Fort Bragg, which is outside the coastal zone. There's a lot of RR2 there.
And which color's the RR2?
I think it's the blue.
It is.
I think it is,
The dark, I think it's the darker. It's actually the lighter blue. The lighter blue, it's all the blue. It's the blue.
Yeah, light blue on this is RR5 and dark blue is RR2.
Yeah. Yeah.
On the
Well, look at, there should be another map, a more specific map in there. So those are the areas where you see the RR2. That map was done, the board, they requested that map, they wanted to see that.
I guess my own thinking about this is I would like to see even RR5 banned from cultivation, but to allow communities like in Laytonville where they're established grows, to allow them to opt back in. In other words, I would like to have some mechanism where communities where they have not traditionally had this and don't find it welcome can assert themselves. But communities where this has been an ongoing thing, they want to stay doing it. It's working for them. They've got their agreements with their neighbors in place. And I don't think it's that difficult to just say, we're not doing it unless everybody there wants to. You know, that, I don't know, maybe the staff is going to tell me that is too complex, but it seems like a way that could work.
Yeah, I agree with you from the get-go. I said I'd like to see it all the way up to RR10, but, and I know what you're saying. One of these letters that came in, and I'm sorry, I should have tried to keep that one out, mentioned a new zoning, which I thought was an interesting avenue to take for areas like Laytonville, where there would be different zoning. I don't want to go into, well, okay, here we'll have RR2 and it's allowed, and here it's not. And I don't want to get into that. That's why I'd like to just see all the way personally up to including RR5. Not allowed, but having that opportunity of maybe looking at a new zoning, and I don't know if that's possible, but it was mentioned as a recommendation in one of the many letters we received, and I'm sure that probably goes to the general plan, and it's going to take forever, but that's an idea.
So with that, I would suggest that maybe we continue to go through our presentation before we have much more discussion.
Okay, so will we come back to this? Because I'm interested. Madam Chairman?
Okay. So with that, I'm going to let our Ag Commissioner Chuck Morris give his little take on his new document that's got the strikeouts and the highlights, and go ahead, Chuck.
No, I know I read it, but I don't remember getting one.
Thank you again, Chuck Morris, Ag Commissioner for the county. So I included these documents as well, just as pretty much a heads up. This has been a process that's been going on since November of 2015. And as new information comes to light, as we read through the document and we need to make some changes, I've done this 2 or 3 times with the board, and I knew that these proposed changes that I'm going to be bringing forward, that I would be bringing forward to the board as well. So I wanted to give the commission just a heads up on this and an ability to comment if they would like on any of these. So my memo spells out in a very summary form with capital letters by each one of the little edits or additions that I've put into that I'm proposing to add into the 10A.17 document. The vast majority of them are basically administrative. Some of them speak to some of the clarifying language as far as cultivation site and things like that. So it's exhaustive. It goes from A to W with all these proposed changes. So I really don't want to take the commission's time. I will be actually wrote this memo before it got confirmed, but I will be bringing the exact same documents forward to the board next Tuesday. For their consideration as well, literally what you're looking at right now. So if I'd be open to any comments, questions, suggestions that any of the commissioners might have relative to any of those points. But to save time, I'm not going to detail each point out in excruciating detail. There is a red line version of the current 10A.17 that spells out in detail what the summarized points speak to. So with that, I'd be open to any comments or clarification if needed. Thank you.
So with that, turn it over to Matt Krudowski. Sorry.
So this is coming kind of on the tail end of what Chuck was doing as well, bringing forward proposed changes on his part that he has ready for the commission's review in red line regarding administrative changes that he's been considering to the ag ordinance. In a similar vein, County Counsel's office worked with Planning and Building over the last several months to do some work regarding the county's nuisance abatement procedures. And the staff attorney staffed that was Deputy County Counsel Mike McDessie. He's in the back of the room, and we asked him to kind of take a look at the enforcement provisions in the ag ordinance. So this is kind of sections 140 to 160 of 10A.17. And what we're looking at doing is kind of specifying the levels of the procedure that would be involved in the termination of a permit, and also getting a little bit more specific in terms of how this would be considered a nuisance or not in certain circumstances. So I wanted to make the commission aware that we're considering changes. I think these will obviously all have to go before the board for their review and comment, and that we don't have red line language available. But I wanted to put it out there, and Mr. McDessie's here. If there's a little more detail we can give you if you're interested. Otherwise, it will be before the board at a future board meeting for their consideration of specific language.
At some point, it would be kind of interesting, and it doesn't certainly have to be today, to get kind of a flow chart of how Mr. Morris's department is doing their part of enforcement, what air quality is doing, what the sheriff's doing, what the third-party inspectors are doing, just to have some sense of it, but certainly not today.
Well, as for today, we're looking at doing potentially a report and recommendation. So if the commission's interested in a future presentation after the board has taken its action on how that process might look, I think Chuck and I have a general idea as well of how the inspections go between the third-party inspectors, then to the ag commissioner and its inspectors, and that's where we get into the language that we're looking at. If once we're in the permit world, the permit's not being lived up to, what the procedures would be and what that process would be. So we wanted to make sure that the commission knew we were working on that language, and if there's concern that they want to see it or just get kind of a general idea, the commission is fine with us going forward with those changes and to present those to the board when they're ready.
Madam Chair?
Yes.
I would like to hear about those proposed changes today if we have time.
Oh, okay.
So I can see if Mr. McDessie can make his way up, and we just have kind of general notes about what we think we're looking at in these various sections.
Did you have something you wanted to say before?
Yeah,
we
I just,
started?
I think I'm addressing Mr. Morris on this one, but I'm not really sure. This is for the Chapter 10A17, page 8. Item F. This is a real simple thing, so.
Is this item F on the memo? Capital letter
This
F on
is
the memo?
item
or-
F on the draft, 10A17.
And this-
Maybe
and-
it's in the memo too, I don't know.
Is this this is the red line version that I supplied for this meeting here today?
It's attachment B, as in boy. The bottom one, yeah, it's dated PC meeting December 15th, 2016.
Go ahead and just give me the code
Okay.
and letter, and I'll speak to whatever you would like.
Okay, it would be section 10A.17.040. F is in Frank. It starts out, all cultivation of medical cannabis shall not utilize water that has been or is illegally diverted from any spring, wetland, stream, creek, or river. I'd like to
Yes.
add irrigation canal, please. Good thinking.
Are you from
No, so that would be, you're requesting that at the end of the day, that be one of the recommendations that would come forward from your commission?
Yes, adding the words irrigation canal.
Thank you.
Okay, sorry.
Good morning, Commissioners. Thank you.
Yes.
As Mr. Kudrowski said, I'm Michael Mactasy, Deputy County Counsel, and for the last few months, I've been working with Planning and Building and other departments to revise and update the code enforcement procedures and mechanisms, including, as was stated, the nuisance abatement, but also adding an administrative citation ordinance and clarifying the use of hearing officers. And so what I was asked to do was take a look at sections 140 through 160 of 10A17 to see how maybe that works with what has just been recently updated and approved, and it's still waiting to be codified. The second reading was just this month, a week or two ago. And so from my perspective, to give you an understanding, as was asked, about what changes you might see here, very generally, what we were looking to do was to take what had been done and incorporated into 10A17 in the way that it was kind of already written, but more specifically. So now we have chapters and sections to cite to. So instead of alluding to an administrative citation ordinance for specific enforcement procedures, we can cite to chapter, I believe it's 1.08. And so making it very clear what we're going to be using, how it's going to be used by incorporating the proper language and eliminating the language that didn't make sense now that we have these new code enforcement mechanisms that will be codified. In addition to that, as was stated, it's providing details and clarification about how due process will be given. Right now it says that due process will be given, but what changes I would be suggesting would be to really be clear on that. So to give a little bit more detail, we would be providing details about how notice is to be given. And let me take a step back, actually. With enforcing the code itself, I think already in 10A17 is reference to administrative citations and nuisance abatement. The details for due process are contained within 1.08, which is the administrative citation ordinance that's already been passed, and it's also contained within the nuisance abatement chapters, which are now going to be 8.75 and 8.76. The details for how due process will be given have already been in there, and so reference to those chapters is all that's needed. However, with regard to 10A17, there's something different, which is in a situation where a permit is to be terminated, there's nothing that addresses that. So there's due process that was suggested to be given in that particular case. And so my suggested language would be to detail how notice would be given in that situation, what details are important to be included in the notice, not just how it's given. Then to clarify how hearing officers will be used in providing the due process, and then detail the hearing procedures itself and the determination after the hearing and what that would look like. So there's, you know, going to be some language that really clarifies what due process and how that will happen in the situation where a permit is intended to be terminated. All the other processes in the other sections. In addition to that, as Mr. Kudarski said, we're looking at the declaration of the nuisance section, which is 160, and my suggested language would be to clarify and limit the basis on which nuisance will be declared, especially in light of the likely time gap that will exist, at least at first, between the applications for existing grows and the actual issuance of permits. So in general, those are the details. If you had any other further questions, I can try to answer them.
So how do you measure whether the nuisance comes to a level that needs enforcement or not? And I assume you're talking about odor.
I'm sorry, I didn't hear the
odor.
last word. Odor?
Yeah.
I'm not talking about anything in particular. See, so what I was asked to look at was process, not details of what would or wouldn't be. To the extent that there's some detail with the nuisance, it's not about whether a particular provision has been violated. The way that it would be divided is more like, do you have a permit? Do you have an application for a permit with other conditions, or do you not have a permit? And that's where the declaration of the nuisance lines would be drawn.
Thank you.
Yep.
Any other questions? Thank you.
Thank you.
Moving along. To what? How much more presentation? Would you like to make some more?
So we're pretty much wrapped up. We do have some changes to the resolution, some little corrections. If you want to do those now, we can do them at the end of the
Maybe we
meeting.
should have our discussion and
I think
then
that would
do
be
all
good.
changes at the end.
So with that, I would just like to say that, you know, we're looking for direction from the Planning Commission to forward this on to the Board of Supervisors. So we're going to try and keep track of what those are as we go through the process, and I know you guys are pretty good about keeping track of them also, so thank you.
Anyone care to begin?
I started. I've already done
Okay.
it. Go to somebody else.
Anyone else?
Where do we leave off?
Well, Commissioner Ogle really was addressing the 10A17, but I think we do also need to move on to addressing our own recommendation to the Board of Supervisors. And I think there are some topics that remain undecided. I guess we should, and then we could take a lunch break. So at this point, I guess we will resume the public hearing on this topic. We do have we will be using our timer, our 3-minute timer. And I don't know if the bell part works anymore, but the lights work, and oh good. So hope you'll respect everybody's time. I'll give a couple names, and then, you know, hopefully we can get a queue going. My first person is Chris Brennan, second Donna Mecca, and third is Pat Hartley.
Hello, my name's Chris Brennan. I'm a cattle rancher from Laytonville. Everything I say is my personal opinion. Number one, marijuana is not a row crop. It is a specialty crop. It's still a Schedule I drug, and in California, it's a drug for recreation or medicine, and you have to be 21 years old to be in the crop. And people don't get shot in the face at carrot fields, but they get shot in the face in pot fields. My main issue is rangeland. There's a group that is pushing to open the rangeland. I want a protection for the rangeland, no new grows at all. And if you want your EIR to go through, I think that's going to have to be a mitigating factor. The AdMac Ranch on Bell Springs, 14,000 acres, which happens to be a neighbor of mine, is pushing to open rangeland. A perfect example of what shouldn't happen is they filed for 5 permits last year. Mrs. Kelly, which was one of the permits from the Herbal Blainer Inc., Co-op or dispensary in Napa and Marin filed, she's one of the permits. She had no pre-proof of cultivation. She had no notification of legal ownership. She planted more than 99 plants or the square footage. She stated she moved no earth. She bulldozed acres to put in 10 hoop houses with who knows how many plants per hoop house. They were short crop. And the other, there's way more than that. I can't get into all 5 of them, but all of them had this problem. Only one had pre-proof of cultivation, and this is a big issue. We need satellite pictures, not pictures of empty greenhouses where you say, this is my pre-proof, or receipts from spare time. That's baloney. I am, through the Freedom of Information Act, I will have all the pre-proofs that were submitted under the special application of the 9.31 program. Big problem we had was enforcement. Our undersheriff, Randall Johnson, did an incompetent job, or corrupt, or both. And I have the proof to prove that. He wouldn't talk to me or Woodhouse. He wouldn't talk to the county council or John McCallan. I mean, he would, but he wouldn't give us any information. We were trying to report violations. He still wouldn't deal with it. He let them. All the other 99ers had to jump through all the hoops and pay all the money. The 5 permits on the AdMac Ranch were protected by the undersheriff. I didn't get any of my Freedom of Information paperwork until December. I have filed a complaint with the sheriff. They will not respond. I am now going to the Department of Justice and FBI because this is RICO. This was a protection racket that Tony Soprano would have liked. So I'm going to leave these with you. I know you're not law enforcement. And protect the rangeland. Thank you.
Thank you, sir. Donna Mecca, please.
Good morning, supervisors and planning commissioners. Excuse me. I'm Donna Mecca, and I'm one of a group of people who are residents in one of those RR1 neighborhoods that have been recently greatly impacted by the influx of grow houses. So our group is called the Rural Residential Concerned Neighbors, and we understand that the development of new marijuana regulations is very complicated and the Planning Commission is inundated with diverse opinions. We also understand that we who are primarily concerned about the neighborhood impacts of commercial marijuana cultivation have been virtually silent until recently. However, this has changed once the draft ordinance got to the Planning Commission, and since then neighborhood concerns have been well represented by numerous speakers with community members in attendance to show support. The negative impacts of commercial marijuana cultivation in residential neighborhoods has been well documented in individual letters and petitions from neighborhood groups that are now included in the public comment file. We were heartened that the Planning Commission and many of the marijuana growers heard and understood the gravity of our complaint, and that we bought homes in quiet residential neighborhoods to enjoy living and raising our families in a peaceful environment. We now feel we are under attack and that we're being forced out of our homes, in some cases after 30 years or more of living in the same house, basically in harmony with our neighbors, because of the negative impact of grow houses in our area. The defeat of ballot measure AF was an overwhelming rejection of the ideas that the commercial marijuana cultivation ought to be a principal permitted use in virtually every zoning district in the county, or that existing neighborhood protections should be weakened. We strongly support regulation of marijuana, which is long overdue, and we believe regulation must limit the harmful impacts that arise when commercial marijuana is grown in residential neighborhoods. I have other people who are in this group who want to address the commission, and that's the extent of it, except to enforce the fact that we are presently living with grow houses that have moved into the area, and the negative impacts are incredible. And I just want to impress upon you and ask you to strongly think about what you're doing to neighborhoods that have been in existence for a long time and have to deal with this change. Thank you.
Pat Hartley, please.
Hi, I'm Pat Hartley, and I'm just going to continue. What we're doing is reading the letter that we sent to the Planning Commission, and just reiterating it so others can hear it as well. Based on comments from commissioners, the Planning Commission understands that commercial marijuana cultivation simply does not belong in residential neighborhoods. Many in our community have asked for the elimination of cultivation in RR5 and lower. We believe we clearly heard a majority of the planning commissioners advocate in favor of excluding commercial cultivation in RR1 and RR2, including sites with existing grows. And there was at least some support for the exclusion of cultivation from RR5, including for existing grows. There was also discussion of creating overlay zones for specific neighborhoods like Laytonville, where a less stringent standard might be consistent with existing conditions and the preference of the local residents. We support allowing exceptions of the rule for local communities where doing so makes sense. This allows the Planning Commission to provide direction to the municipal advisory councils for determining the location of these overlay zones. However, the default position should be zero commercial cultivation in residential neighborhoods. The Medical Cannabis Regulation and Safety Act has exemptions to allow limited cultivation for patients and caregivers. Proposition 64, the Adult Use of Marijuana Act, allows for limited cultivation for personal use. Except for these limited individual allowances, which are still subject to local regulation, all marijuana-related business activity, including cultivation, is defined as commercial cannabis activity and requires both a local permit and a state license. It should be obvious that an activity like commercial marijuana production with a well-documented history of negative social and environmental impacts simply has no place in residential neighborhoods. The analogy has been used that anyone may eat bacon or ham, but no one thinks they can operate a pig farm in a residential neighborhood. Thank you.
Thanks. Carol Hester. And after her will be Candy Dickinson.
Hi, you guys are really brave. So we're moms and dads and partners and men and women trying to protect where we live. We're neighbors. This is not in your letter. We're a community of neighbors. We love one another. We have a disaster plan in effect. So please listen carefully to what we say. To continue with the letter, to reiterate, marijuana cultivation and production is incompatible with the rural residential zoning districts. A majority of planning commissioners have voiced support for the elimination of all cultivation on RR1 and RR2. Just because a neighbor may have previously tolerated a thoughtless grower does not justify allowing the situation to continue, especially when all the rules are changing and appropriate zones are being established for commercial cultivation. We strongly urge the Planning Commission to eliminate commercial marijuana cultivation in RR5 and lower for existing as well as future civilization cultivation sites. Stuck another C word. There was also discussion of a phase out for existing neighborhood cultivation sites and a transfer provision to allow growers to relocate to more appropriate zones. We believe a combination of these concepts can be used to resolve neighborhood issues and help shift commercial cultivation out of residential neighborhoods to more appropriate areas. And as an aside, I know you know this, but just bring it up. When a person moves into and pays cash for a home and grows, then he has enough money to buy and pay cash for another residence. So pretty soon, there's 3 of our neighbors. There's 5 of our neighbors. This is happening now. They are not neighbors. They don't care about anything that's happening in our neighborhood. They only care about what they're growing. And you just saw in the news some dogs that killed and maimed. Thank you. Oh, I have a minute left. Kindergarten children. We have dogs who are protecting these grows. It's not just happening in Laytonville. It's not just happening in Covelo. It's happening here. And it's very disheartening. So thank you for listening. Next.
Candy Dickinson, and then after her, Philip Boynton.
Hi, I live in a neighborhood, a rural neighborhood, which has I think there are 2 left, but 3 grow houses. So I have some experience, but I'm supposed to read this in 3 minutes, so I'm going to do it. We believe the following points address concerns of most residential neighbors. Number one, prohibit all commercial cultivation of cannabis, including existing grows. Number two, prohibit all commercial cultivation of cannabis in RR5, except allow a transition period, preferably 2 years, for existing growers who are otherwise legally compliant. Cultivation in RR5 should be eliminated, except for the current growers who are otherwise compliant. They could be given 2 years to relocate to a site appropriate for zoning, where they can meet all the conditions and not disrupt residential neighbors. Any existing cultivation sites in RR1, RR2 that are compliant with the existing regulations could also be allowed to relocate. If in 2 years transition period is chosen, all commercial, I'm starting with the C words too, all commercial cultivation would be out of RR5 and lower no later than 2019. This is my favorite. 3, prohibit all indoor commercial cultivation of RR1, RR2, and RR5 on the same basis as discussed above. Allowing, even encouraging indoor cultivation as an alternative to outdoor cultivation defeats the purpose of excluding cultivation in residential neighborhoods, lots of C words. Indoor cultivation presents virtually all the same threats to neighborhood peace and safety as outdoor cultivation, including increased risk of home invasion, decreasing property values, and limiting house availability. And I see that happening where if somebody knows that there are a couple of grow houses and they're trying to sell their house and they can't sell their house, they may have to lower the price, but also there's also another grow person that's willing to do that. And so it just kind of gets rolling. Okay, I'll go through number 4 really fast. Prohibit commercial cultivation of cannabis, including in all residential zones, including R1, R2, R3, SR, and RC. The focus of this discussion has been the rural residential zones because there are some few zones where future commercial cultivation of cannabis is allowed under the draft ordinance. Obviously, it makes sense to preclude commercial cannabis cultivation in RR zones. It makes it equally or greater sense to preclude it in residential zones where the average parcel size is smaller. Am I done?
Yes.
Okay. I have a lot of other good things to say, but I think I'll be sad anyway. Thank you.
Okay. And after Mr. Boynton, there will be Phil Gary.
Good morning to you all. I'm Phil Boynton. I am a resident of Regina. I think we're R1. I have 2 grow houses in my immediate area. But my concern is to kind of do what I used to do, which is to teach a bit of history. So I'm going to generalize a bit. In this room, there are 2 groups of people. One group, or their progenitors, came to Mendocino County to grow an illegal crop, which is now in the process of being made at least semi-legal, depending on whether you look at the federal government or the state government. These people grew their crops and they devastated the environment, social and natural. They produced a very profitable crop that raised a considerable degree of crime, and it overwhelmed law enforcement to the effect that the gentleman from Laytonville alluded to. They've created a set of circumstances with indoor growing, which now leads to upset in neighborhoods where we have children. That certainly is something to be of concern to those of us who live in rural neighborhoods, and I think Regina is one of those. And they obviously didn't pay taxes because it was not a crop on which one could pay taxes. So their interest in rules and regulations was nil. And now we are dealing with potential regulations, and their response to that, given their history, will probably be close to nil. That's my take. On the other hand, we have a group of people, myself included, that came to this county to enjoy the environment, natural and social. We were teachers and lawyers and doctors and nurses, people who worked in the various levels of government. We are also farmers and ranchers, for that matter. We paid taxes. We obeyed the law. We raised our children. We hope to live here and enjoy the fruits of our labor for quite some time. And now we find that that's becoming increasingly difficult by the changing rules and regulations that have to do with one crop. One. It is immensely annoying to us. I'm sure it's more than immensely annoying to you to have to deal with all of this, but it is a matter of law and order, life and death. It truly is. And it's not something that's got to be taken lightly. It has to be judged on the basis of who is speaking and to what degree their history speaks that they did obey the law, will obey the law, which theoretically you will help to make. Thank you.
Mr. Gary? You don't
Commissioner
look like
Steele
Mr.
Gary is
Gary.
my husband, and he had to leave for an appointment at 10:30, so.
All right. Let's see, we have Barbara McLean or McLean, and Paul Hansberry after that.
Hello, I'm Barbara McLean. I've been here before to speak to you, and I'm going to be very brief. I strongly support prohibiting all commercial cultivation of marijuana in any of these rural residential areas that have been under discussion, including existing grows. And I agree with looking at the 2-year transition period to relocate those that have been compliant and only those that have been compliant. And also urge you to prohibit the indoor grows, which has been spoken about before. And it does defeat the purpose if we allow indoor grows. I strongly urge that that not be something permitted. And finally, because I understand how complicated this is, I applaud you for the effort you have been putting into this. But I ask that you take the time that's necessary to review all of this, to consider all aspects of it. You have been inundated with piles, inches, feet of material. Please don't rush into this. Take the time and get it right the first time. Thank you for listening.
And after Mr. Hansberry will be Susan Tibbin.
Good morning. I'm Paul Hansberry. I have a couple of issues that I want to bring up. Number one is the provisional licensing. There are the regulations. I think most of the people in this room feel that it is a necessity. You know, and the bureaucracy behind it is a fact of life. But there are other facts of life that are a bit more pressing, especially to the licensee, not the least of which is the grow season. It doesn't respect the bureaucracy. It happens regardless of how long it takes to get the license. Other things like mortgages, these sorts of things are very pressing, and getting, especially out of the gate, having a provisional license is essential. The second thing that I wanted to bring up which you were touched on already, is having a mechanism or language. Someone told me one time that if something isn't in these regulations, if it isn't specifically included, it's specifically excluded. I don't see any language that allows for a mechanism for appeal or a variance or discretionary review. This would be another way where towns like we're using Laytonville as an example, where they might be able to appeal the zoning and get a variance, or worst case scenario, conditional use, but some sort of a variance that they would be able to appeal that zoning and get the thing. And this would apply not just to cultivation, but also to different other licenses as well. If I were a lavender farmer, I would be allowed to cultivate the lavender, harvest it, extract essential oils, make shampoos, soaps, salves, whatever, and sell it to individuals and retailers. My partner and I, we make medicines that are life-saving, and it's specific to the individual, where the dosage is critical. Other large manufacturers may consider this, but they don't cater to it necessarily. And having the small cultivators to be able to make that medicine is crucial. Thank you very much.
Susan Tibbin.
Good morning. Susan Tibbin, founding member of the California Growers Association, representing approximately 1,500 small farmers in the area. Between the last time I had the honor of addressing the commission and today, a little boy celebrated his second birthday, outliving his initial 1.5-year prognosis. Working with his UC Parnassus physicians, we have already made a new batch of cannabis-based medicine because the child has gained so much weight. Small farmers and medicine makers desperately want to continue our passion, our work, and to support our families. And we respectfully ask you to provide for zoning for cottage tier, not zoned industrial, allowing us, like the lavender farmer that the previous speaker mentioned, to go from seed to finished product, grossing perhaps under $50,000 a year, with all activity taking place on our own land. We ask for different tier structures for medical versus recreational for all license types. We ask for language, as the previous speaker mentioned, which gives variances, discretionary review, or exceptions for special cases for all license types. For instance, some Laytonville gardeners. And perhaps most crucial, given bureaucratic timelines, provisional licenses, since nature, the seasons, do not abide by our human bureaucracies. Deviating from my notes for just a moment, and perhaps to cast a more realistic light on people who came to Mendocino to grow pot, my partner and I have been here many decades, and we gross under $50,000 a year. We grow fruits, vegetables, medicinal, and culinary herbs, and only 24 cannabis plants as part of our sun-grown garden. And we ask you to continue to take our concerns seriously, and we very deeply appreciate your hard work. Thank you.
Julie Baucom, and I got a lot of these that have two cards. It's very confusing. And then Sandra Hognestad, I believe. These are my Williamson acts. Let's get those off the field.
My name's Julie Baucom, and I again want to address, I feel that the commercial cultivation is now going to be moved into upland areas, as the gentleman in the Spy Rock area talked about. Grading, we need a good grading ordinance attached to this. We do not have one right now, and a group of watershed professionals that are concerned about the damage resulting from unregulated grading have gotten together, and we're in the process of producing a document that may help you. We want to help you with your regulations, a grading ordinance associated with certain types of grows and certain sizes of grows. I've worked in Mendocino County for 30 years, and I have two examples I'm going to leave with you here. 2007, a gentleman in Willits graded 6 acres on steep slopes, moving almost 19,000 cubic yards of fill without any permits on Canyon Road above a county road. It was taken to court. This is the PowerPoint of the court case, and successfully it had to be remediated before the following winter, and it at a cost of $422,000 to stabilize 18,000 cubic yards of material. The owner declared bankruptcy, so guess who had to pay for it? The taxpayers. They did put a lien on the property, but I don't know, this was in 2008, and I don't know if they ever collected any money from this gentleman. Another problem that I've seen, I've had to address numerous times, are agricultural ponds that have no permitting. This one, I just gave you a report that I wrote for the Director of Planning and Building, Raymond Hall. This was in 2008. And they asked for mutual aid from the state. I worked for the state at the time. And they built an agricultural pond in a nice depression area that had springs. Guess what? It was an active landslide. I've seen this numerous times. This was on the McNabb Branch, and it threatened a lot of lower homeowners that were below it. And I've gone to at least 10 of these in the time that I worked for the state. So this has to be addressed, and we are going to work on it, a group of professionals, and we're going to be presenting that either to you or the Board of Supervisors, I'm not sure. But here are two examples. I hope that you look at them.
Thank you. Sandra Hognestad, and after that, Sean Trainer.
Good morning. My name is Sandra Hognestad. I own a 300-acre parcel down in Hopland. I wanted to address what happens in reality when cannabis is allowed to be grown on rangeland. I'm here today to ask the board members not to continue to allow cannabis for any reason in rangeland. I live next to what used to be a beautiful 3,000-acre ranch with certificates of compliance that allowed it to be cut into 17 160-acre parcels. It can never be restored to its original intent. All neighbors of this subdivision have suffered greatly. I do not understand how the developer of this property was allowed to create the subdivision without improving the county road that leads to the area. Rangeland parcels are away from populated areas, and the roads weren't designed to carry the higher traffic counts. They are not as wide as they should be, and as a result, many of the neighbors, including myself on 3 occasions, have had their fences ran into and destroyed. Department of Transportation doesn't have the funds to maintain the county road that leads to this area. I would invite Jeff Burnett from DOT to just drive down Felice Creek Road. It's horrible. I bet it's the worst road in the county. We have learned to drive defensively, and apparently people that are involved in cannabis feel it's extremely urgent to get to where they're going, because I've been run into the side of the road having someone passing me doing more than 50 miles an hour on a road that's hard to drive 20. Someday will be a serious injury on that road, and in fact there already has been. I would ask who ultimately is responsible when the roads aren't designed to adequately handle the traffic and the speeds that they allow. When somebody's in a bad accident in my area, they leave by helicopter or by a coroner's van. There are several miles of private road. The new owners don't help the road association to pay for their share of the cost of the roads. They ignore all laws, all rules, period. Leaves it up to the property owners to try to enforce the collection of homeowners' fees. People want rangeland for cultivation because it's out of the public eye. They can do what they want, and believe me, it's hard for the enforcement to enforce. It's a difficult. Hopland has now become another Laytonville, and it's sad. It's sad to see. Nobody talks about the disappearing wildlife. I remember the beauty of seeing a lot of animals roaming the areas. I had a person have the audacity to tell me, brag about the fact that he shot 84 pigs off the land. I mean, we see the reduction in deer and small animals. I mean, we have people guarding gardens with pit bulls, and it's scary to have guns up there on the hills. And we used to ride our horses on our own property. I don't do it now. It's too dangerous, too dangerous. If someone wants to operate a commercial cannabis operation, restrict them to commercially zoned property, period.
Thank you. Sean Trainer and David Drell after that.
Hello, good morning. I'm going to come at this with a little positive approach and try to maybe offer up a solution. The county can provide a solution by providing possibly a preferred destination site for cannabis cultivation. This mitigates environmental and social challenges, which you've heard a ton of this morning already, while providing a positive economic impact to the county. Currently, there are 300 plus applicants per 9/31. If we multiply that by 5,000 square foot, you're over 30 plus acres of cultivation that's already been applied for. It is possible that more than 50% of this applied for activity will not comply with the standards for the water board or your neighborhood problems that you have already. This develops the need for someone that's growing to relocate to a compliant destination parcel. Other existing cultivators may want to relocate to a preferred destination parcel in order to take advantage of attributes that this destination parcel may offer. However, these relocators are forced to either purchase another parcel or continue to invade into the beautiful forests that surround Mendocino. This places undue financial and environmental stress on the community and the social stress. These folks may result in the growers not even participating in the spirit of the ordinance, creating more, basically they're on strike from coming forth to even participate, which creates more social, economic, and environmental challenges. However, the Planning Commission may provide a preferred destination transfer site, which could allow the congregation of these relocators on a compliant site pre-qualified using the parameters set forth in 10.17.040 and 20.242.070. The Commission may consider further destination parcels to allow the efficiency operations of a co-op style of environment, allowing the aggregated relocators to mitigate the environmental impacts. This application process would be more efficient. The regulatory oversight could be successful and efficient, mitigates public nuisance, mitigates the security challenges you've heard already this morning, reduces grower costs by providing aggregated compliance options. Taxation is easily done, certification, track and trace, and the administration of this project could be done. It is possible preferred third-party contractors could assist the Ag Department in this process. There are many other positives I can share with you regarding this if you'd like to meet, including the commission and positive action that helps mitigate all the concerns contributed by the public's input in the county so far this morning. Thank you.
Thank you. David Drell, and after him, Tom Rodriguez.
Good morning. My name is David Drell. I just want to briefly say that I think the ordinance and as written and the negative, along with the negative declaration, provides a good start for this process. And I think the commission should go forward and approve the ordinance with the mitigated neg deck, and and without without trying to complicate it and make too many changes right now, I think what you have is good. Go forward with it. If changes need to be made, there's plenty of time to do that.
Tom Rodriguez, and after him, David Troxel.
Thank you. My name is Tom Rodriguez. I've been a Mendocino County resident now for 16 years. I'm a landowner, a grape grower, and a small winery owner. I sit on two boards here, the MWI board, which is the Mendocino Wine Growers, Inc. We represent 548 vineyards and nearly 100 wineries. And I also sit on the MCIA board, which is the Mendocino Cannabis Industry Association. So I'm in a unique position where I have one foot in each pond, which is kind of interesting. So this is some information I've just sort of gathered, and I just wanted to share. There are 58 counties in California, and many have embraced the cannabis industry. Mendocino County is the 12th poorest county in California, but yet 70% of our economy is generated from the cannabis industry. 70% of the grapes grown here in Mendocino County are sold outside of the county. We only use 30% for local wineries. Humboldt has embraced cannabis and are now reaping the $1+ billion annually from that industry. Sonoma County has embraced cannabis, and they are setting up programs, permits, and events around the cannabis industry. Monterey County has embraced cannabis and are making money reviving the greenhouses growing cannabis. Coalinga sold their prison to Damian Marley for $4 million and brought the town out of debt, and they are embracing cannabis. My point here is that prohibition of cannabis is ending, and the counties and communities across the state are benefiting by licensing and permitting farmers and big corporations to expand. Let's face it, it's about the money. The industry is the fastest growing industry we may ever see in our lifetime. Mendocino County wineries have fallen behind by not organizing themselves and promoting our wines. Mendocino Cannabis, however, has been marketing its products for decades and has built a reputation of being the Napa Valley of cannabis. We have a chance here to bring Mendocino County off one of the poorest counties list to one of the more successful. But we cannot wait. If we wait and sit on permitting and not allowing these farmers to cultivate and comply, Big Pharma, the mafia, and guerrilla grows will move in and take over this cottage industry. This will happen if Mendocino County does not act soon. The growing season is near. It's time to act. Let's not fall behind and give up something that we are already the best at. We grow the best grapes. It's where Napa and Sonoma shop for their grapes. And we grow the best cannabis. It's where America shops for its medicine. Thank you for your time.
We're going to take David Troxel and Valerie Edwards, and then we're going to take a lunch break.
Good afternoon. I'm David Troxel from Laytonville. First, I just wanted to re-stress provisional licenses. I think there's a misconception that every single cannabis farmer has a sack of money buried in the woods. And I think that the truth for most of the farmers in this room who are doing things properly is that that's not the case. We're one season away from losing our farms. That could be because of powdery mildew. It could be because of chopper lands. It could be because we're not allowed to set out seed in time this year and we don't get a grow season. I also I want to re-emphasize who's in this room, and we heard earlier that there's two types of people in this room. That's true. There's growers and there's people who don't like the growers, I guess. I want to point out, though, that I would feel there's two types of growers, and we keep hearing about guerrilla growers, people destroying the environment, mafia, people making millions of dollars. That's not the people in this room. The people in this room, we're not stupid. We know where North Dakota is, and we know what FedEx is, and our flowers sell in North Dakota for $6,000 a pound. We're lucky to get $1,200 to $1,500 a pound in the legal market in this state, and that's what the people in this room are choosing to do. And the people in this room are choosing to let the sheriff know where we are, our names, our addresses, pay money for licenses, pay money to grow properly and the right way, and that's what the people in this room are here to talk about today. I just want to emphasize that because I know a lot of my neighbors have sacks of money buried in the woods, and I know a lot of my neighbors go and ship out of state, and I know that that's common. I know that that's probably the stereotype of a cannabis farmer in this state. But the people who are applying to grow legally are not those people. And you're going to be giving out licenses in 2020. That's the theory here. That's what we're talking about. So people are going to be getting those licenses. If we have 1 or 2 seasons where we can't grow or we can't grow effectively, nobody in this room is going to be applying for those licenses. We're going to be in Southern Humboldt, or we're going to be working at Safeway. So I would like you guys to understand that people who are wanting to work with the system needs to work with them as well. And there's going to be so many people coming in from all around the country. Come 2020, they're going to know exactly what they're shopping for as far as land. We're going to basically know what a leaky roof looks like on a house in Mendocino County. And if there's an unpermitted pond, if there's a problem with the creek, that's going to be a toxic property. Talking about somebody can sell their property and relocate in 2 years. That may not be realistic if they're not able to sell their property because their property at this point is worthless. So I would just emphasize that people who are sticking their necks out, who are wanting to do the right thing here, that you allow them to continue doing the right thing, that you work with them, and that you understand who you're working with here. And we're not the bad actors. We're not the people growing in the woods and dumping rodenticide in the rivers. We're mostly hippies who, I heard earlier, moved here to enjoy the environment, to farm, to raise our children, and to pay taxes. Thank you very much.
Edwards, and then that will be, and then lunch.
I'm Valerie Edwards. I'm from Laytonville. I'm a farmer. I wanted to also address the suggestion to eliminate RR1 and RR2, even up to RR10. I can understand the concern of the neighbors that have voiced their concerns for their neighborhood. And it sounds like they've got housing associations to address those kind of things, or that they could come together, like it looks like they have, in order to address the situations in their specific neighborhoods. I'm not hearing, from a lot of different neighborhoods. I'm hearing, from this one particular neighborhood, and I know that they might represent some that are having problems, and yeah, that does need to be taken into consideration, the safety of some people who don't want it in their neighborhoods. However, being in Laytonville and living on RR1, my neighborhood is safe. My neighborhood does work together. We do know each other. We do help each other. And when you eliminate this, I'm assuming that it might be because, well, it makes it easier. I don't know, there might be other reasons, but you are also making it to where neighborhoods like mine that cannot afford to go and buy something more, and especially if you eliminate RR5 and RR10, I mean, I can barely afford the RR1 right now that I'm living in. And so to say, well, move where, move someplace else, move where? And when you are also devastating the livelihood of the most financially vulnerable constituency in this county. We have families too, and we can't afford to get busted, go to jail, pay the, whatever fines. But when you eliminate the small guy, then you are left with the big guy, with big money, with big attorney firms that can come in and pressure the county to do what they want and cost big money to the county. Keep us little guys. We've been here. We do want the environment right. We do want to take care of our neighborhoods. We do want to be good neighbors. We are here, like the person before me said, we are sticking our necks out to be regulated, to be concerned, to talk to our neighbors, and to have an industry that truly works. The little guys here have been responsible for creating the most amazing genetics that are known throughout the world. The big growers will not be concerned about that. They will be like the gallows. They will be like gallow wine. They're not going to care. And exactly. But the little guys do care. The little guys on the RR1 that are in neighborhoods like mine, RR2, who are concerned about the environment, RR5 and RR10, who do concern themselves with all the things that we are going through. So please consider us the small guys. Don't let the big guys come in and ruin it all.
Okay, I think we're going to take 1 hour for lunch. Mr. Larry Desmond will be the first up after lunch. I was understanding there was a person here who needed some kind of an accommodation because of illness, so if that person could be ready to come up. The Planning Commission is back in session. We are continuing with our public hearing on the cannabis cultivation ordinance. And our next person was going to be Larry Desmond, but...
He's the person who doesn't feel quite right either, so I'll speak, please. I am Larry Desmond.
Oh, okay.
Yeah.
That's fine.
Yeah. It's a miracle how things happen. Anyway, I'm just not 100%. First of all, are we starting?
Yes.
Okay. My name is Larry Desmond, and I want to thank the board, the planning board, the commission staff, and LACOPE consultants. Thank you for your work on this. This is not an easy issue. I think we got a good team to figure this out, and the public input, regardless of how, it's a diverse group, and that's fantastic. So we're getting a lot of ideas how to move forward on this. And the county needs to do, as I mentioned last meeting, we need to do a great job on this. Mediocre is not going to work well. I don't want to rush into it. Personally, I think we should slow down a little bit. And on the precautionary principle, not to overstate that, but to move deliberately into this. I want to also support, I scribbled this out pretty quickly. I support the mitigated negative declaration as written with a county grading ordinance and woodland protection by 2020. I was finally speaking in the mic, sorry about that. I do water development in the counties, have for 30-some years, and the grading ordinance has been so out of place. I mean, it's something we need to have so people have the tools and the knowledge of how to move forward. Because the egregious development of water that I see and erosion from roads and from pads could certainly be improved, to say the least. I do support this, the provisional license for growers so they can get started. The people that are here are offering their time and efforts also on this to move forward, and I want to keep them in the group here. That sounds odd, like that the other group. I don't mean it that way. It's just that I want to keep this team. We have a great team of people. And that is it for me, so thank you.
Thank you. After that, we have Kate Marienchild, and after her will be, I think it says Park Steiner.
Thank you once again for tackling this endlessly complex issue. I hope I can figure out all the scribblings on here. There are arrows pointing everywhere. I want to reiterate my support for AG2, the rangeland exclusion, that you retain it in the mitigated nec deg with as written, because we really need open wild areas with uninterrupted wildlife corridors. At the last hearing, you voted unanimously in a straw vote to adopt or include the Willits Environmental Center's proposed mitigation measures, one for a grading ordinance and the other Oak Woodlands ordinance, with the provision that they would be adopted by 2020, not 2018, as originally stated in the WEX comments from November. And as geologist Julie Baucom stated, we do not have a grading ordinance in this county. We have best management practices in the general plan, but we need a grading ordinance that is much more comprehensive than that. What we have in the general plan applies to parcels that have been of 1 acre or more that are developed with structures. It does not apply to roads leading to pot grows or, anything other than areas with structures, ponds, for instance. One thing that would be accomplished by having a comprehensive grading, countywide comprehensive grading ordinance is, in addition to protecting habitat, that it would provide inspectors with guidelines for recognizing and closing down environmental violations. And many people have said that the lack of a grading ordinance could lead to the county needing a CEQA review. Lake County has a grading ordinance, and it's working very well for them, and it's been posted on your website, and I hope you all acquaint yourselves with it. So the same, much of what I said also would apply to a grading ordinance as far as providing guidelines with which inspectors would be acquainted, and it would be able to make decisions about environmental practices that were bad for our oak woodlands, as well as our streams and our fish and our chaparral, all of our wild habitat. So I'd like to encourage you to do something stronger than encourage the Board of Supervisors to adopt Oak Woodlands Ordinance. I'm done, finished? Oh, okay.
Finish your thought.
Okay, so I think we need something really strong to, stronger than just encouragement of the Board of Supervisors, and I urge you to include Oak Woodlands Protection and Grading Ordinance in the mitigated neg deck. Thank you.
Park Steiner and then Ellen Drell. Pardon?
Good afternoon, Commissioners. My name's Park Steiner. I'm a fisheries biologist. I have worked in the county for 36 years doing fisheries projects. And at lunch, somebody said, well, you got to talk about, and I said, I'm not sure. But the two words that I'm going to throw out are salmon and steelhead. And the reality is that Mendocino County supported a very viable economy back before the 1960s in recreational and commercial fishing for salmon and steelhead. For the people less than 50 years old, they probably don't even know what I'm talking about. Thousands of people used to come to the Russian River on a regular basis to fish on weekends. We had an entire commercial fleet over at Albion that was productive and strong economic base for the county. Those have all but disappeared. Realities are pretty straightforward. First, dams and diversions are highly responsible for the loss of those fisheries. But on top of that, land use practices, erosion, clearance of riparian areas, any number of factors that would be covered by a grading ordinance. And coming into Mendocino County from Santa Rosa Drive, welcome to Mendocino County. First word underneath there, wilderness, and instead we're seeing clearance of hillsides here and there and losing a lot of that quality. So I'm fully supportive of anything you're planning to do that would bring necessary protections to our natural environment. Sounds like that I'm not fully up to speed with the ordinance that you're working on, but sounds like the grading ordinance is a significant part of it. And I'd just like to say that protection is a whole lot cheaper than repairs. I don't know how many hundreds of millions of dollars have been spent in Mendocino County on restoration. The only reason we do restoration is because it got broken. And if we were to protect it up front, we wouldn't have to pay all those hundreds of millions of dollars. So strongly support moving towards a grading ordinance that will protect the hillsides and forests of our county. Thank you.
Thank you. Ellen Drell, and then after her, Linda Gray.
My name is Ellen Drell, and I'm speaking for the Willits Environmental Center. I just wanted to say that after listening to this morning's testimony, I have sympathies with the people on the smaller RR parcels on both sides of the argument. And I think we're talking about both environmental issues and social issues. And I just, to help myself sort it out, I'm reminded that we're looking here today at a draft ordinance based on an initial study and mitigated negative declaration, and we're looking at environmental impacts as a result of this ordinance. Some of the social issues, I think, cannot necessarily be solved through this mitigated negative declaration, but perhaps there are other ways to solve that issue. So I think we shouldn't cumber ourselves with attempting to use this ordinance to solve every problem that's confronting communities, though they are there and they need to be dealt with. I strongly support moving forward with this ordinance. I think the structure of it is sound, and with the existing mitigations, I think it can go forward, and if we don't move, we're just looking at another chaotic growing season. So I think if we can move forward on this, it would be beneficial. Now, just read very briefly from the comments that I sent in on behalf of the Environmental Center most recently. Unlike Measure AF, the purpose of this ordinance was not to create a blueprint for the widespread expansion of the medical cannabis industry, but rather to bring existing growers into compliance while implementing environmental protections and putting limits on the expansion of the industry. The resounding defeat of Measure AF at the polls last November affirms support for this direction, and I think support from both growers and non-growers. By focusing on bringing existing cannabis cultivation operations into compliance during phase 1, the ordinance will arguably correct many, maybe even most of the worst environmental impacts and move all cultivators seeking permits toward responsible agricultural land and water use practices. If the regulations are based on good science, common sense, and an honest assessment of what is doable, phase 1 should result in improved environmental and community conditions. In addition, the draft ordinance and mitigated neg dec, with the proposed mitigations, and in particular mitigation AG2, which will limit phase 3 permits to ag, rural recreation, rural residential, and upland residential zoning districts where agricultural and property development impacts already exist, such as land clearing, road networks, infrastructure installations, water use, and power supply infrastructure, etc. For these reasons, it's the position of the Willits Environmental Center that this mitigated negative declaration, along with our proposed additional mitigations, is a legally defensible document. And I would just add that we also, the Willits Environmental Center, urges the Planning Commission to recommend to the Board of Supervisors that they adopt an oak woodland protection ordinance and a grading ordinance that would be in place prior to the issuance of any new cultivation permits. Again, I think we're in a good place, and I look forward to moving forward. Thank you.
Linda Gray, and then Fred Marshall.
Hi, I'm Linda Gray. I live on Greenfield Ranch. I've been there for 40 years in April. I didn't come here to say this, but I do want to say I support the Oak Woodland ordinance and the grading ordinance. I think they're both really important. You know, it's important to protect our wildlife and our wild places. But the reason I'm here is to speak for Greenfield Ranch, which is zoned UR 40s. We've never, except for maybe 3 parcels, the majority of the ranch has never been subdivided below the original 160 plus acres. Some of them are as big as 250 acres. So yesterday, I know Melissa Sanchez, attorney from Harvest Law Group, sent a letter by email to, I believe, to all of you, in which I have right here. And in it, representing Greenfield, she asked that a change be made to section 10A.17.070, regarding tenants in common, because that is how Greenfield was established and has continued to this day. And I'd also like to point out that Greenfield has been very little trouble to the county over the years. We just sit up there and do our lives, and we don't sue the county and, you know, all the kinds of things that could be happening. We've been pretty content up there. And we get along pretty well with each other for the most part. What is troublesome about the way this is written right now for tenants in common is that we're on perhaps a 250-acre parcel with maybe 4 to 6 houses and limited to 10,000 square feet among all those people. So we're asking that you change the wording so that it, you know, and I can give you this rather than to try and read it in the however many seconds I have left, but to allow each tenant in common to grow 10,000 square feet as they would be able to if they had 40 acres, you know, because we, you know, those, you know, 4 people maybe on 250 acres with growing 10,000 square feet on a whole 250 acres is not much of an impact and not much of an income. And we also would like that all the owners not have to participate in the process. The way it's written right now, the people who don't grow would still have to submit some kind of letter to the county, and we don't have to do that to get building permits. We don't have to do that to buy or sell our property. We don't have to do that to put in a well or put in a pond. You know, we have to get permits, but we don't have to get all of our neighbors to go along, you know, say, yeah, it's okay with me or not okay with me or whatever. So we're just asking that this be consistent with the way things have been with other permits. And that's all I have to say. Maybe I can give you this.
Fred Marshall, and then Frost Polly after that, if this is separate from the Williamson Act.
Hello, I'm Fred Marshall. Thank you for this. It's wonderful to see what our community is like. It's an incredible group of people, and thank you for your hard work. I've been doing organic farming in this county since the early 70s, and taught in agriculture in the county schools and at the college, and I'm currently making tinctures out of high CBD cannabis, which was developed here in this county more than anywhere in the world, getting the THC out, getting the CBD in, finding a true medicinal cannabis. It's happening here. The people that I buy my supplies from are they're small families, and they grow vegetables. They have, you know, some little bit of livestock, they have orchards, and they've established themselves here. They're civic minded, they're environmentally minded. They would love to see a good grading ordinance. They would love to see a good oak woodland protection, and I'm glad to see the Environmental Center is coming out strong for that. And the thing I'm asking for is to make it possible that we go into this in a way that will protect ourselves, our environment, and our economy, and not pull the rug out from the people who are currently working and currently growing. The reason is how easy that would be, because it's also new, and there's so much to do. But if some of these people are left in the dust without permits, without this or that, or maybe there's one little kink here where they're out of business because it wasn't foreseen, that would be very detrimental to the county and to the agriculture of the county, I believe, because these are the people who are the basis of responsible action and the demonstration of how to do it in the model. I think slowing down new growers coming in is a really good idea, and keeping the experience of the people that we have here. When I first came into the county in Covelo, there was a lot of people 15 or 20 small dairies had just been closed down in Covelo because of regulation, which of course in this case was very highly influenced by the dairy industry. And all these families that had been, you know, making butter and cheese and feeding the skim milk to their pigs, they were poverty stricken. You know, it changed the whole economy up there. So I just am begging you to please be very careful about how you do this. And thank you.
No, could we not have any of that? It takes way too much time.
Thank you, Frost Polly, Mendocino County Farm Bureau. The number one issue for Farm Bureau is that traditional ag resources need to be protected. And we have questions of whether those questions have been, that there are questions about the impact to ag zone properties and whether those impacts have been fully addressed. A question like, how does AG2 mitigate for the potential pressure for subdivision of larger ag parcels in order to allow for the ability to have increased cannabis cultivation permits in phase 3? How does AG2 mitigate for potential short-term or long-term conversion of existing ag commodities and loss of production on ag zone properties? And one fear is that cannabis may be a temporarily high value crop, but in the future we could see a reduction in value, which could lead to long-term substantial impacts. For example, if existing tree or vine crops are removed in the near future for cannabis, it could take 4 years for replanted wine grapes to come back into production. It could be 8 to 15 years for replanted pear crops to come back into production. And those impacts go much further than whether any of us in this room know what the value of cannabis is going to be, more than just the short term. Also, we haven't fully addressed the impact to adjacent farms and ranches. One example of that has, to my knowledge, has not come up is wine taint. We haven't discussed wine taint at all, and that's not a figment of our imagination. That is a real problem. Another question, has there been consideration for the potential that limiting cannabis cultivation permits to ag zoning in phase 3 would increase ag property values and impact the ability for historical and multi-generational agricultural operations to acquire or lease property? And that's already happening, not just in the future. I have a director on my board right now who is losing a lease this year to a cannabis grower. Their lease is not getting renewed, and that's going to hurt their family business. Their family's been farming that land for a long time. Another member in Little Lake Valley who is halfway through the process of buying additional rangeland for their herd, and during the process that a cannabis grower came in and bought that piece of property out from under them, and that's going to affect them long term. And these are people who may not be here for the long term, we don't know. To reduce the impacts to ag properties, Mendocino County Farm Bureau encourages the placement of medical cannabis cultivation, processing, and manufacturing facilities on industrial or commercial zone properties. This could alleviate impacts to ag zone property, improve security, and help avoid negative interactions between neighboring property owners or the general public. Thank you.
Devin Jones, and then Alan Harris. Harris? No, it's Alan something. Oh, okay.
Okay, I'm wearing a couple hats today, so I'll see if I can cover both comments in one 3-minute section. So Devin Jones, Mendocino County Farm Bureau. Continued some questions that we have that may be beyond the scope of the Planning Commission, but they are concerns that we have in terms of sort of this regulatory creep that we're seeing with cannabis regulation. We've always been a proponent of equal regulation, whether you're growing wine grapes, cannabis, carrots, but we're seeing some efforts to increase those regulatory pressures, which most likely would not be beneficial for those individuals in the room here who are trying to come into compliance, or for existing agricultural operations where these might transition over into in the future. So for example, under Bio 1, you know, this is coming from the Department of Fish and Wildlife, and there is a place for that. We agree that there has to be some involvement with this process, but in terms of what is the definition of sensitive species, is that specifically limited to the scope of the jurisdiction of the Department of Fish and Wildlife? We've seen regulatory creep working with these agencies in terms of where their jurisdiction is and where they think their jurisdiction is. And so if they expand what they think their jurisdiction might be within the cannabis realm, it could creep over into other permitting processes. Under Hydrology 1, watershed assessment. Again, we're not arguing the baseline theory. You know, protecting our watersheds is important. All of my members deal with it on a regular basis. However, what is a watershed assessment? What does that look like? If that's under the fact of AB 2121, the North Coast End Stream Flow Policy, good luck. That's all I have to say. We've been trying to find out within the water rights system how that is even going to work. The state board is just sort of now coming to some movement in terms of how to help streamline some of these permits through for water quality and for water rights. So just to give you a heads up on that. We do have a grading ordinance. We've heard multiple times today that we don't. Our county has an existing grading ordinance. It's not really well marked on the Planning Commission website, and I've notified staff of that. If you just do a general Google search, it pulls up documents that are not related at all to what we're even looking at. But it is there. It's Appendix J of the California Building Code, and Chapter 18.70 to regulate grading activities in the county. So it's there. The county's adopted it, and that could be applicable to cannabis production or any other grading activity. We also have Chapter 16.3, Stormwater Runoff Pollution and Prevention, 20.492, Grading, Erosion, and Runoff. The Regional Water Quality Control Board, through the cannabis program, deals with everything related to water quality and grading. So again, we have a grading ordinance. Enforcing it equally is important, but expanding the jurisdictional regulation without the enforcement component is really only going to impact those people that are willing to come to the table. Thank you.
Mr. Harris and then Jeanette Iglesias.
Hello, thanks for having me. My name is Alan Harris, and I've lived on the Mendocino coast for 14 years. I'm married, and I have 3 children. I have a degree in biology and biochemistry. I'm a licensed building contractor, and I'm a cannabis cultivator. And I lived in the same house. I bought it 10 years ago, and it's zoned RR2. And I don't see a land use compatibility issue in my neighborhood. I'm on a first name basis with all my neighbors. So I want to reiterate 2 issues that are important to me. Cannabis cultivators need provisional permits so they can continue to make their mortgage payments, put food on their table for their families, and build a business that will create revenue for Mendocino County in the future. And the second one is the current draft ordinance should be adopted and put into environmental review. I grow cannabis in RR2 zoning, and it is accepted by my neighbors. And there's instruments in the current draft ordinance that requires cultivators to get conditional use permits. This would allow neighbors to decide which cottage industries would be allowed to operate. And lastly, if the county planners can't imagine a world where cannabis production is accepted as a cottage industry, give the neighborhood cultivators a sunset clause so we can figure out how to remain useful and productive members of Mendocino County. Thank you.
And after Jeanette Iglesias, I think it's Jamie Ward or Worm.
Good afternoon. My name is Jenny Iglesias. I am a member of the Small Farmers Association. I am requesting an exemption to cultivate cannabis on a portion of my rangeland. It has had agriculture, namely vineyards, of 21 acres since 1957. So for 50 years, you have allowed agriculture on this rangeland. Now you are discriminating against the agriculture of cannabis, but not the agriculture of grapes. There has been prior cultivation on this property from the previous owners, but for some reason, there's no visual evidence on Google Earth or Parcel Quest. This is a problem that not only I have, but numerous other people I have talked to. I have been organic for 28 years, very proud of it. My vineyard is organic, and the adjacent vineyard has been organic as well. I'm extremely environmentally conscious, and I will still provide a preserve for this precious land. Thank you very much.
Jamie Warm, and Ashley Oldham after that.
Good afternoon. Jamie Warm, Artifact Nursery. I guess this wasn't really my intention at the beginning to speak on this, but I feel like the cannabis community has been painted with one brush so far this morning. And I just like to tell you that, I've lived here a dozen years. I have a wife, 2 children. We are property owners, and we both operate the natural food store in Laytonville. So we're tax-paying citizens. We love this place, and we call it home. And I guess what I really came to speak about is 3 items. Particularly no residential requirements on UR. I think the last I read, it's leaning that way, but I think it's important not to have housing development in areas that are unnecessary, and these are large spaces where cultivation currently exists, where small farmers currently exist in 40 up to 160 and beyond. I guess the second thing is I operate a farm that has a vineyard on it. It's zoned RR2. We raise sheep on it, and we were enlisted in the program last year. We permitted the farm, and I guess I wanted to stress the importance of still leaving the avenue open. I understand the concerns of the community and particular neighborhoods that don't want to see this here, but the community is broad. It's not just one-sided. And for those who have been through the process, who have permitted their farms, who have applied with the North Coast Regional Water Board, and have done the necessary steps that the county asked us to do last year, there still must be an avenue for us. I have to believe we can all get along. And if there's areas in this county that homeowners associations feel that they don't want it, perhaps we can compromise. But to eliminate folks that have already gone through this process, I think we're marginalizing a group of the community that currently exists and raise families here in Mendocino County. Thank you.
And after Ashley will be Valerie Edwards, Ashley Oldham, and then Valerie Edwards.
Hello, my name is Ashley Oldham. I was born in Mendocino County to a family that cultivates cannabis. I've been active in the industry for 15 years. I am a single mom with 2 children and support my children as being a cultivator. I have been compliant state and county-wide, have applied and received permits every year that it has been allowed. I would like to thank everybody for being here today, and it seems to me that there's a lot of people in this room who are very anti-cannabis and very anti-cannabis growers, and I would like to point out, like some people have, that there's very different kinds of growers. We're not all bad guys. We're not criminals. I have a family. I'm environmentally conscious. I get along with all my neighbors. I'm not a disrespectful human being. And I think that with this regulatory program that's coming on, it's gonna weed out a lot of those people. And I hope that you consider keeping RR zone properties in place. As long as they abide by all the setbacks and regulations and they were previously permitted, we all have a lot of investments into them. And I think to ask us to pull those out and to lose all that money and to lose the income for our family is really unfortunate. It makes me really sad. Something else I would like to touch on is, I think that there is, I hope that everybody can be empathetic and understand the major changes that we're being faced. We are an industry that would like to move forward into a regulated and above board business, but we're overwhelmed and we're nervous, and some of us are possibly even scared. And my request to you is that you simplify the process as much as possible and give reasonable transition periods to become fully compliant with all the regulatory agencies. Not only will many of us need to make substantial changes to our businesses, but these changes can be costly, and many of them require a learning curve. One aspect of this is the track and trace. As an industry that has never been used to tracking anything, we need to teach ourselves how to do this, and I hope that you can be patient and helpful in this process. I hope that we can make this process as simple and straightforward as possible, and I hope you can provide adequate help and direction and clarity in doing so. I would also like to point out that the state is establishing their own track and trace program to be done online. I feel like participating in the state track and trace programs would be significant, and it seems to me that implanting a county track and trace is not only redundant, but also adds unnecessary and repetitive steps, which is exactly what we don't need in this situation, and therefore is also a waste of our county's funds. I also want to point out that this ordinance is here to regulate existing cultivation sites. Existing meaning they are already there and the environmental impact has already been done. I'm not saying that certain cultivation sites don't need cleanup, because I'm sure they do, but I think that most of us that are here and are participating in the program feel very strongly in respecting the land and the wildlife. We're lovers of the land and we want to keep it in a good place, but the process, I feel like, can be more streamlined and simplified. I think that the sites that are regulating and are already in place, I hope that you can be patient with the changes that we need to take place in, and that the environmental, all the environmental things have already been done. I think this process can be streamlined. I want to touch on provisional licenses before I run out of time. I think it is extremely...
You have already run out of time.
40 seconds? I think it's extremely important that we keep those. Our farmers cannot afford to take a year off. I'm a single mom. I have 2 kids. I don't have hundreds of thousands of dollars buried in the ground. In order for us to be able to move forward with this, I think that we don't want to scare people away. I understand the concept of shaking the tree and seeing who falls out, but I think we need to be careful not to shake it so hard that we lose all the good fruit and rip up the very roots in which this industry was founded on. Thank you.
None of that. Valerie Edwards.
Okay, Valerie Edwards, Laytonville. I'm wanting to specifically address section 10A.17.30, section D, concerning qualified patients or caregivers. They are exempt from permit requirement and track and trace. They are required to comply with all other aspects of the ordinance, and they are required to register with Agricultural Department. That's what they are supposed to do. However, what I want to specifically speak to is zip ties. That is a voluntary, that section is actually 10A.17.050B, zip ties, from the Sheriff's Department. It says that it's voluntary and that it's to assist in enforcement and avoid unnecessary confiscation and destruction. The fees for zip ties benefit the sheriff. I'd like to know what the benefit to the qualified patients and caregivers are for those fees. When I lived in Africa, we had a 12-foot fence around our house. We were also encouraged to voluntarily hire a guard for night watch who had a huge gun. Now, if we said, well, if it's voluntary, why should we do it? Why should we pay for something that's voluntary? And we were told, if you don't, the company that provides the guards will break into your house, they will create destruction, and you will have problems. And so we said, then hire the guard. This sounds a little bit like Africa. I'm asking, is it extortion or is it service that the zip ties are being asked for? Plus, Measure A1 collects taxes for public service. for public safety. Plus, lastly, the fee that violates California Constitution Article 13D, which specifically says no fee or charge may be imposed for a service unless that service is actually used by or immediately available to the owner of the property. No fee or charge may be imposed for governmental services, specifically including police. So please consider removing this voluntary zip tie concern and get us out of third world country extortion tactics and bring us into a civilized rule of law.
Phoebe Smith and then Corinne Powell again.
Sorry, don't start I have to get my password on. Okay, thank you very much for bearing with me. Okay, so I've been to several Board of Supervisors meetings, and I have to just say I really appreciate your receptivity and all the time that you're giving to everybody to speak. My perspective and opinion resides from my background in growing up with my dad, who was a U.S. diplomat under the umbrella of the Department of International Development. And I also grew up with him during his career transition from agribusiness into small farmer fruit co-ops in the Central Valley, as well as Biggs County. I am currently a mother and caretaker raising my children in Mendocino County, and hold very passionately residing within communities that can foster my fundamental values of earth care, people care, and fair share. When I became pregnant with my first child, I woke up to the magic of plant medicine and homesteading, even more so than ever before. My 4-year-old daughter is epileptic. I see that we live in a time of major transitions across the board in our global and local economies. Lifestyles are evolving due to the clear fact that there is something fundamentally wrong with how we have been relating to ourselves, each other, and our environment. Collectively, we are waking up to the healing process that is absolutely necessary by breaking the patterns programmed into our system by the military-industrial complex. Sorry, it's my little rant. I understand that there is a stratification of folks and their practices here in this room, and I agree with the concerns with environmental groups wholeheartedly. But I don't agree that it would be very fair to completely withhold the opportunity for a family in their communities to cultivate a crop that is compliant and complaint-driven. I agree, I encourage you not to neglect the fact that there is a movement outside of the cannabis, your normal cannabis culture, and that is the application of permaculture principles towards life altogether. And I encourage you to give your attention and faith to the education process that is necessary and inevitable to play out now that California is opened up to recreational use. I encourage you to consider the time and work that it has taken to interest humans, people, to care about how we consume all commodities, and how those conglomerates choose to scale up. I continue to be disgusted by what agribusiness and pharmaceutical industry is doing to our system, and while many groups are associating cannabis as an agricultural crop and product under a negative light, I see that cannabis actually has the potential to encourage individuals and whole communities to become curious of how they consume and control the quality of those products, which returns back to the fundamental process of how we do it. And I just encourage you to allow our small farmers to show you how we do that. Thank you.
Corinne Powell, and then Jude Tillman or Thilman.
Corinne Powell again, Ukiah. Just a couple general remarks, and I'm not quite sure where all to find them in the text of the ordinance, but conceptually I know you can make the association. First thing I want to do is again support the recommendation that upland residential not require legal dwelling units for all the reasons that the previous speakers have given you, but mostly the degradation and blight that would be required to put in substandard housing where it's not really needed. I'm concerned generally about all of the leaps to abate and eradicate and have processes for all those things without a single mention of how we protect the legitimate growers, the compliant growers, from frivolous complaint. And I know that that will happen. I want you to be prepared for it, and I think some of it might be improved with language in the ordinance. So far, we've got a couple of words here. What is a sensitive receptor? What is a large number of people? I mean, to me, that's like thousands. I'm sure that a neighborhood representative may not think that that many complaints are required for something going on in their neighborhood that they don't like. But we need to clarify those issues so that we're not constantly just fighting with each other over semantics. I want to echo, I don't remember your name, but what you said about the California Department of Fish and Wildlife and the watershed assessment processes required in this ordinance. Does anybody know what those are supposed to be? Does anybody know how long it's going to take? I know Hannah addressed that issue, and I completely support her argument that we need to resolve these things in advance before we just blanket rubber stamp them into the code. So can somebody please, in staff, define those requirements for us? What is a watershed assessment going to look like? When is it going to be done? Who's going to do it? What's it going to cost? How many people are involved? Can a neighborhood get together? What are the parameters? And the same thing for when an application has to go to Fish and Wildlife. Another important thing, as I always harp on, is applying these regulatory concerns equally to all kinds of agriculture. Somebody else has a problem with lavender just like I do. Track and trace is mentioned in Chuck Morse's redlined version of his chapter, and I don't have a clue what that's going to be yet. He talks about monthly fees. I don't know what they are. I'm curious to know. And lastly, it's very important that we also define how parcels that have permits for cultivation are transferable. Because if we've gone, just like anybody who invested in their property, you want those investments to be of value to you. If I die, I want my children to be able to sell the property if they want to, and I want it to be worth something to them. So please keep that in mind. Thank you.
Jude Thilman. My stack is not going
Good
down,
afternoon.
it's going up.
Good afternoon. My name is Jude Tillman. I'm a resident. I've been in Mendocino County since the late 80s. I want to echo what Corinne was just talking about. The devil is kind of in the details, and you're dealing with a very complicated construct of regulating cannabis, but it's mostly been made complicated by a lot of fear that's been brought to the table. The fear that had got expressed this morning in painting many folks in the cannabis community with the same black brush. And it's sort of analogous to the way local news happens in our country. We only see the most egregiously horrific stories, but the vast majority of people that are living their lives peacefully and as contributing members of their community, we don't get to see them. And that's who I have seen for years. I'm a medical cannabis educator and patient counselor. And the medicines that I help my patients stay alive with, help them control their children's epilepsy, fight cancer, those medicines and those raw materials come from members of the cannabis community here in Mendocino County who've been working diligently for decades to develop the cleanest, best possible and world-class medicines out of cannabis, high CBD, a lot of incredible medicines. These are good people. They're family members. They go to the same churches and the same schools as some of the speakers that were worried about rural residential this morning were talking about. They don't have vicious dogs that attack people. They don't have guns that attack people. These are decent, regular people. That's the silent majority that's been behind the growth of a beautiful cannabis industry in Mendocino County for many, many, many years. I also, the second point I want to make is that these very same small farmers who are in RR1, RR2, all those rural residential districts, small their cottage industry that's very small. We're not talking about big grows. They need to be able to stay alive. They're going to need provisional permits to be able to have a crop this year. So that's very critical as well. Just remember that back in the days of alcohol prohibition, it wasn't alcohol that created the gangsters and the illegal activity. It was prohibition. So thank you very much for your time.
Joshua Kahn, Ben Anderson. After that.
Thank you for taking the time. My wife and I live in Redwood Valley.
Could you say your name?
Oh, my
just
name's
for a
Joshua.
record?
Joshua Konkanian. My wife and I live in Redwood Valley in a rural residential 10 zone. We are cultivators of cannabis. We were attracted to this county, just to sum it up, the fact that it was the very first county to ban GMOs was very a huge deal for us. We believe in the powers of agriculture and healing through food and medicine and as a crop. We don't have any dogs. We don't have any guns. We're very quiet and respectful of our neighbors. And I'd like to touch on the way we cultivate. I know people have touched on different growers, if you will. There's the type of growers that only grow cannabis and they have a monocropping style. And they'll take the winters off and they'll come back. We've taken a regenerative approach to cannabis, and we treat it not necessarily as an agricultural crop, but we are sort of taking an approach of land stewardship, where we are sort of reducing the fuel load in the forests and using that as our garden beds. And we believe that the regenerative model of smaller farms can sort of change the approach that larger farms of larger agricultural enterprises can approach in order to sort of heal the land and regenerate resources such as water and carbon. There are a lot of cannabis farmers who have taken the approach of sequestering carbon, and I believe the fact that Mendocino County is part of the Emerald Triangle, and it is, as some people have touched on, the sort of epicenter of cannabis, I believe that we have a big opportunity to sort of showcase certain permaculture or agricultural styles that can be demonstrated and be an example for the entire country, and especially at a time where cannabis is coming into the light, and there's really nothing that this county can even do because it's already happened. It's already been legalized. I'm sure lots of other counties are coming on board, and I'm curious if there's a way that the agricultural section of all this compliance and everything with the water board, if there's a way that we can sort of look at the practices, the way that a farm is practicing. I think that's a crucial element of everything. Thank you.
Thank you. Ben Anderson and then Geraldine Harris.
Hi, Ben Anderson, Comp Chief. First and foremost, thank you all for your hard work and dedication. This is an impossibly difficult situation for you guys, I'm sure. My purpose here is to address the disqualification of responsible farmers who didn't get their applications in before the Black-tailed Deer Association settlement. My question is this: why refuse permits to existing farms that were unable to get their permits in under the emergency ordinance due to the lawsuit? Doing so would be unfair to those of us who missed the boat on the emergency ordinance due to the settlement. I personally did everything in my power to prepare for getting a permit under the emergency ordinance, only to find out the applications were no longer being accepted after I had finished the construction of the required fencing. The mitigated negative declaration already assumes illegal activity exists and will continue. It also refers to the legal precedent that protects the mitigated negative declaration findings from dispute by the opposition. Then what is the purpose of even more onerous restrictions on who can participate? You said yourselves that you want to encourage us to participate. The board expressed the same sentiment on multiple occasions. Regulation will reduce negative impacts. That's the bottom line here. Please allow us to come into compliance. As the board had previously determined, the county should allow all those who can prove they were cultivating at their locations before January 1st, 2016, to participate in the permit program. They repeatedly stated that it would be unfair to exclude farmers based on participation in previous SIP-type programs. This is the same scenario. The emergency ordinance application window closed with 1-day notice, poorly publicized notice at that. This is unfair, and there's no benefit in excluding those of us who want to play by the rules. At very least, let those of us who can do so without irritating our neighbors grow the 25 plants we always have. Think of the consequences. Small family farms put out of business by the time permits reopen in 2020. County revenue lost because fewer growers paying permit fees and taxes. Small farms lose their land, and big businesses step in. Those large players will not participate in the local economy the way that we small farmers do. This county needs cannabis farmers to survive economically. Please keep that in mind as you move forward. Thank you.
And after Ms. Harris, Johanna Martz.
I'm sorry, guys. I was sort of hoping I'd let you off the hook this time and you wouldn't have to listen to me. But I have to tell you that the concerned neighbors, we're not experts in zoning. We don't know what the different zones, other than an R means residential, and we've been pushing for RR1, RR2, RR5, only to call the planning department yesterday or the day before and find out that we're R1, not 2 Rs. Regina Heights and Deerwood and El Dorado is mostly R1, R2. But we're also pushing for those R5s because we've got different zoning all around, but we're residential and we're rural. So please understand that that's where we're all coming from. And you got the letter from everyone, the most recent one, and I know many of you know the names on these lists and the people who live in our area and how strongly we feel about maintaining the safety of living where we do. And my last point is I've heard over the last 3 hearings references to lavender, and I grow lavender in my front yard. And even the deer don't eat the lavender. I don't worry about anyone breaking into my house because of the lavender I grow. So it is because this crop is illegal federally. Also, we don't want existing residential, the people who are there now be able to transition out, but existing grows and future grows. And once again, I'd like to thank you for all you do here.
Johanna Martz, and then Maricela de Santa Ana.
Good afternoon, Council. Thank you again for hearing us. My name is Johanna Mortz. I'm from Willits. I am a resident. I'm a taxpayer. I'm a voter. I'm a licensed cosmetologist, and I'm a regenerative cannabis farmer. As I sit here today, I listen to everyone. And one thing is for sure, that there's a complaint about cannabis in every zoning that we can come up with. I think that the whole point of this ordinance is to try to weed out those people that are being complained about, because the people that are here, the people that want to be a part of this ordinance, if you allow us, are not the people who don't care about our community or our town or our neighbors. We are the people that desperately want to be included in this community and stop being seen as this horrible, horrible person. I live in rural residential 5. I take care of my land. I grow other crops other than just cannabis. I'm friendly with all of my neighbors. I introduced myself when I moved in, and I am part of the permitted process right now, and it would really be a shame shame to not be able to continue to be a part of that process. There has been talk about moving to other land that's more feasible, and to be honest, I've looked into it. My property's not perfect. We have a large tree coverage that is not really that great for growing cannabis. I don't want to clear cut my land, so I've looked into what it would take to move my property. Unfortunately, I can't afford to move my property. I don't own my property fully yet, and that's just not really a feasible option for me. So, and I don't think it's an option for a lot of other people that are small farmers that make up this community. I would like to also address the environmental impact of moving property and having to redo everything. I think the biggest thing that needs to be talked about is enforcement. How do we get these people that don't want to be a part of this program out of here? Because along with all the other residents in this town, I don't want them here either. They're disrupting my community, my town, and my business as well. So I think that finding a way that the people that want to be a part of this program can be a part of this program, and then differentiate between the people that don't, and let's figure out a way to get them out. Let's work together. There was one thing mentioned in the last meeting about the timber industry and how it's gone. Now all the small farmers are gone, and it's pretty much in the hands of the big guys. I think instead of saying that negatively, we should be seeing that in a positive light and being, what can we do to be different here? Because we do have an uphill battle with the state and the regulations coming down, and it would really be nice to not have such a battle within our own county, because we've got a rough road ahead of us. Thank you for your time.
Marcella, and then Cyril. That's all it says. Okay, Cyril. And after him, Sandra Berman.
Hello, my name is Cyril Guthridge. I also live on Greenfield Ranch, and I just wanted to address the tenants in common. It's pretty important for our community out there to have a separation between residents and parcels. That's kind of all I wanted to say. I guess the other thing I'd like to say, since I have 2 minutes, is like Joanna said, we do have an uphill battle against us, and one of the things that we need to do as a community of farmers and growers is work together and prove to you guys that we don't need to allow big ag to show up and grow hundreds of acres of cannabis, because we all can do it in a small scale. So that's it.
Thank you. Sandra Berman, and then after her, Hannah Nelson.
Hello, I'm Sandra Berman. Thank you again, commissioners. Thank you, everybody in the room, and to many of those who aren't in the room, for all the hard work. My husband and I have lived in this county for 6 years. We recently purchased 22 acres, zoned RR10 in Redwood Valley. Among our neighbors are grape growers and livestock farmers. I want to reiterate my support of cultivation on RR10 land, and the provision on the memorandum removing the requirement of a permitted structure at this time. So I read that. I'm not sure what exactly the status of that is, but like I said last month, my husband and I are excited to build a permitted house on our property. We don't currently have the funds. In the meantime, we are living in very close quarters in our 1976 Airstream and carport kitchen. Also, I wanted to spend time looking at the odor clause under 10A17-040, stating the outdoor, indoor, or mixed-light cultivation of medical cannabis shall not subject residents of neighboring legal parcels who are of normal sensitivity to objectionable odors. I'm not sure exactly what that means. We will abide by all the limitations. Our garden will be at least 100 feet from our neighbor's house. We want to plant other fragrant plants like jasmine, lavender, lilac, etc., to mitigate odors. But will we have other protections? We are going to be investing thousands of dollars in all the fees, et cetera, in order to be a permitted cultivation site. And if my current neighbor has no objections to the odor, what's to say that the next neighbor will not? So will we be protected under the right to farm or other protections? So yeah, clearer language would be appreciated. Thank you so much.
Hannah Nelson, and then, my God, we're at the end of the stack.
No.
Hannah Nelson, I'm going to refer you both to the memo that I submitted, and I want to make one comment. I made an error, so please disregard my comments regarding bullet item number 5 regarding the I-1 and I-2. I found an old thing that it did have it the correct way. So anyway, just disregard my comments. And I'm not going to address every single one of my bullet points because I have some other issues as well, but I really urge you to go and take the time to read my memo because I put a lot of effort into being detailed and hopefully coming up with concrete suggestions. The other thing that I want to start out by saying right away is that many of you might not know, but I've been involved in this process for a really long time. I don't charge anybody for the time that I do this particular policy work. Yeah, I have clients and I practice law, but I spend this time writing these memos and looking at the issues and meeting with staff and going to the board meetings completely because I care about sensible regulations on all aspects. When I used to be a litigator, I was an environmental litigator as well as a litigator of other issues like civil rights issues. Some of my little stubborn issues have to do with due process because I was a constitutional lawyer. I consider myself still a constitutional lawyer, so you might hear me whine about some of those things. But I really am taking the time to look at all of these issues, and I have a breadth of experience in not just a limited area of the issues that are coming up. Anyway, so some of the connections to the other ordinances that have been passed with regards to nuisance and abatement that are specific to cannabis, I came up with some specific examples in my memo of why paying attention to the detailed language that we're doing now is so important, because if it triggers expedited procedures in another ordinance that eliminates any, basically only gives a few days notice and immediately imposes huge fines and all kinds of processes that just happen before people even know it, I think it's important for us to be clear about what actually triggers those things and make sure that we are doing so responsibly. So some of the issues and specific examples that I give have to do with, like, the motion sensor light thing really makes sense to me. But how could you have a fully shielded motion sensor light that's meant for security? I'm sorry, maybe I don't understand I see a contradiction where there isn't, but to me that seems contradictory. Or, the other issue is with respect to referral to other agencies. I think there needs to be a time limit by which those other other agencies or departments have to review things, because how do people, keep moving in the process? There are additional items in the memo, in the staff memo, that were raised that haven't really been addressed except for the provisional permits, which, as you've heard from me before, I feel very strongly we need. And I think that we need it separate. If you're going to deliberate more about various particular concerns before making recommendations to the Board of Supervisors, then perhaps we need a separate resolution regarding provisional permits that can move forward quickly, because we're going to be up against it here, and it's going to be the same kind of mess that there was last year. In addition, there's questions regarding whether permits run with the land or with the person, and all of that stuff that really need to be very specifically enunciated. Any overlays or suggestions of how to deal with these differing neighborhoods, can't be delayed by referral to the LMAC. I've had some experience with LMAC stuff, and oh my gosh, it could take forever. And essentially, we'll be putting everybody who we're trying to get into compliance and into regulation that we can then inspect and regulate and tax and make sure that they're doing everything required of them, are gonna disappear from the process and not come back in. And it's just gonna go away forever, and then we're gonna go back, I fear, to the old days where everybody's gonna go back underground and do more detrimental things than are currently occurring. And so I think that there needs to be an urgency. I hate to use that word because of the urgency ordinance, but an urgency about some of this and creating a system that we can, if you're gonna take more time to deliberate about things, then we've gotta have some way of moving forward very quickly in a sensible way. Also, to address some of the comments before with respect to how long this has been going on, I've been, and I know Chuck has been working on this for a year. It's not so quick. Okay, I will wrap it up. I just really request that you take the time to look at my memo. There are one other thing. The RR, I think, is a critical issue, and the people that are already the CEQA, we have to remember the context that we're in. We're in a CEQA review, okay? And the CEQA review was looking at the project with the current cultivation, all of it. And so it's not like, oh my gosh, this is now gonna expand. We're just trying to get these people into regulation. Thank you.
Anybody else from the public wishing to speak before we close the public hearing? Or are we closing the public hearing, or are we just putting it on hold? We are?
That, in my opinion, is everybody's had 2 or 3 chances before.
Okay. Last call. Okay, public hearing is closed, and we will bring it back to staff and the commission. Oh, we have a break request, so we're going to take a 5-minute break, and then we will resume our deliberations.
2:30. Back at 2:30.
This back to the commission, and I'm not sure whether we want to go through the ordinance and decide how we want to make modifications. Do we want to discuss a recommendation about provisional licenses separately from these things? What's the commission's pleasure?
I might suggest that we focus on the memo from Mary Lynn, but that we certainly include concerns that other commissioners have that may not be stated in this. I know there have been a few. And just sort of see how it goes, I guess.
Yeah, wing it.
Molly, are you referring to today's memo? The one dated
the
today?
memo, January 19th from Mary Lynn.
Today, thank you.
Yeah. I mean, we may want to add more to that or whatever,
Right.
but.
So I guess the first question would be the recommendation to remove mitigation measure AIR2.
Not sure whether there's 2 memos, right?
Yeah.
January 19th.
And for anybody's information, in the initial study, that is page 44, is the air quality stuff.
I'm looking at the memo.
I know.
Okay.
But
So this is
that's the initial study, just if anybody wants to refer to something in there. So the consultants are recommending, and you can correct me if I am wrong, that this is already pretty much based on the Air Quality Management District's position that this is already required, or, regulated, and so we don't necessarily need to have this as a separate mitigation. Is that the gist of it?
Yes, that's the gist of it. That we'll cover it with the mitigation, with the other air quality mitigation measure, which is a referral over to air quality.
So, and this would be consistent with other agriculture in the county.
The air quality just already has that
You have
covered.
to, you have
We
to get a
don't
burning
have to-
permit.
Yeah.
Exactly. You would get a burn permit and be limited to certain days.
And when we further discuss this part, we might want to refer to the revised changes to this memo that was presented by LACO this afternoon with the strikeouts, just so we...
Maybe, yeah, we might need to get that back up there, because I
Maybe
don't
so.
think we have a copy of that. So if that could come back
The
up here.
strikeouts?
This, the air quality mitigations are on page 44 of the initial study. You
Well,
know,
I could just say that I don't have any trouble with that one, with changing it.
I don't either. I've actually been, myself, on this one and on a couple other ones, I've been thinking about the difference between phase 1 and phase 3 and wondering if maybe a way to make this easier and to kind of test our ordinance as time goes on. If instead of having people have to do the whole agency-wide thing right at the outset, I would just like to ask Commissioner or Director Morris if he felt like, could you, with your third-party inspectors and your own inspection staff, would you be prepared to look over the existing ones first and make referrals to the bigger agencies if you see a need to do that? Is that feasible for you at all?
Chuck Morissette, Commissioner for the county. Not through the third-party inspector program, no. Quite frankly, these referrals go out just for that reason. The level of expertise at the specific agencies is really, it really is what's needed. It's appropriate, I feel, but definitely not the third party. They're not, they're not positioned to make that call up front. I think the referral process as proposed is seems appropriate.
So, in my experience, I needed to put in a major main line, and before I could do that, then I had to have a biological assessment done. But if you aren't doing any major earth moving, then you don't have to do this until there's actually a risk. So I'm wondering, is that the way this is going to work, or do the growers, the cultivators, are they guilty to begin with, and they have to prove themselves innocent, or is it required when they do major earth moving?
It's my understanding that the proposal at this point is that a referral will happen, and that decision would be made at the agency level. So they'll look at if the plan calls for installation of a main line or something that might require an actual biological assessment. I think that's actually written into the mitigation as an example. But, and again, that's another reason why it seems appropriate to go down that road, to go that direction. It seemed like the proper level of analysis up front could be, assessment could be, done at the agency level.
So will they have to pay an upfront fee for this, even though there isn't any reason for it? So it sounds to me like they have to go to this, say, Fish and Wildlife, before they plant a seed or before they get their permit. Maybe I'm reading it wrong.
The original verbiage was for the cultivators to actually engage with the individual agencies. The proposed change or the mitigation at this point is to have, once the application is in our office, to put referrals out so that the agencies can make the assessments.
And this will be, pardon me, and this will be for every license, or just the ones that appear to have issues?
It would be for every application at this point, yes.
Well, I'm erring on the side that I want more people to apply, rather than scare some people off. So I have a concern about that, that tactic. If they have an issue or a potential issue, a stream crossing or a culvert, or they're going to do a major growing, yes, they need to go to the agencies. But if it's flat and the road's already there, I don't see why they have to go to every agency if there's not an issue.
And I guess what I was asking to tag onto that is there the capacity in your agency to be that first look at these? As you go out and meet with these folks, can you look at that and say, no, this is definitely a property that needs to go to the full regulatory panel and get everything lined up because we see problems, versus this is a 20-year established grow and there's no problems and nothing's running off? Do they have to do that? I mean,
I would defer to Lako to explain this more thoroughly,
Okay.
the
Beth?
concept.
Yeah, thank you. So the concept is that at some point, Department of Fish and Wildlife will get confident enough in the county's resources and staff that they will basically turn that process over. So what they want is the opportunity to make sure that the county's got the appropriate mapping, that staff have the appropriate training, and then they would like very much, and if you read the very last part of the mitigation measure, which is up on the screen now, that basically the county may eliminate this requirement at such time that CDFW authorizes the county to perform this function. So that's the goal, absolutely. And we just need to see that handoff happens. And the way it's going to work, it's a very common referral process. So you guys are familiar with a lot of discretionary projects. All of those get referred. Those typically have a response request. So it'll say something like, please respond, and Mary Lynn, here's at 30 days. So if we don't receive a response within that time period, we would move forward, assuming that they don't have a comment. That's not to say that something else wouldn't pop up later, but the vast majority, they're going to be kind of working in a triage mode too, to look through that stack pretty quickly and make sure they're picking out the ones that are sticking out to them as a potential problem. Additionally, if somebody has a stream crossing or something like that, they're going to be in a separate process with DFW, so they'll be getting their lake and stream bed alteration agreements. That could be subject to its own CEQA process that the county really doesn't have any role in. So they may be on site anyway for a totally different reason, but the referral process is a pretty basic way. It does mimic other discretionary permits, although this one isn't particularly discretionary through the ag office.
So I'm sure my questions come out of ignorance, and so because I can't quite visualize the process.
Mm-hmm.
There's so much to put together here. So when they apply, they have to get a permit from Regional Water Quality Control Board. Well, then what? What happens with that? Is that just put in a file, or does Regional Water Quality Control? And I assume when they apply with them, they have to show their plan and their location and all these details. Wouldn't that be a point where a referral would be made if there's a question?
I'm not sure that Regional Water Board is interacting with DFW that way on this particular rare plant level that we're concerned about, in terms of sensitive species. They may be doing it if they see something like a lake and stream bed alteration permit is needed, but the Water Board order, and Chuck, maybe you know more, but I think it's crafted to be relatively autonomous so that they can get maximum participation and get the erosion control issues taken care of. So yeah, they do have annual monitoring through the water, but they have their own set of third-party inspectors that can be involved. So there's a lot going on there, and very much so the cultivators will have parallel systems they need to navigate.
Okay, I just, I want to keep it, we've had a request to keep it simple, and hopefully it'll be as simple as possible so we don't scare people off.
So are we pretty agreed to remove mitigation measure AIR2, but leave the rest of them in the AIR section in place as written?
So, we're just talking about page 1 then.
Yeah.
Yeah.
I'm okay with it.
Okay.
I had one comment. Let me see if it makes any sense here. Under A, air quality DE, let's see, the proposed MCCR provides several mechanisms to prevent air quality impacts, particularly odors, from impacting sensitive receptors, which is another question, and large numbers of people who may object to the strong odor associated with cannabis cultivation during the flowering phase. How about the processing phase? Is that not a part of that odor, possible odor objection? So I was adding in the flowering and processing phases. I don't know how anybody else feels about that. I mean, it isn't just the
I don't
flowering.
know enough about it to tell you the truth.
Well, that's because you live in the city of Ukiah, right? But there is certainly odor during the processing phase as well.
Oh, okay.
That's all I'm getting at.
So there should not be any processing, this is just.
Trimming, is that processing? That's where I'm coming from.
What's your view of it?
You might call that processing, but it's not converting the product into a
Right.
concentrate or causing some sort of process to occur that would
Change it.
cause significant additional odor impacts, I guess is what I'm trying to say.
Why not drop the reference to phase?
Yeah.
If it's an odor, it's an odor regardless of when it occurs.
So who
Yeah,
may
if
object
we
to the
just had
strong
the
odor
period after cannabis cultivation in that
I
sentence.
think it would only be during that phase, but not being a cultivator.
That sounds good to me. Put a
Okay.
period after cultivation, thank you.
Okay.
Can I ask
Yes.
sort of a naive question? Mightn't it be possible, given that there are several state agencies and county agencies working, that might it be possible to set up a workshop that goes for several days, and all the applicants come to the workshop and go around to various tables, and in a cooperative spirit, just sort of
Get everybody
take
through
care of all the
everything.
stuff together, and it seems like it would be easier for everybody.
Like a job
How's that
fair.
for naive?
Well, I did really like the idea of in neighborhood areas, if the whole neighborhood could get whatever assessments are done together, since they're in one land group. Maybe that would, and everybody just contributes to it, it would probably accomplish the same environmental protection at a lower cost for areas where there's an enclave of cultivators. I don't know, it just seems like,
Well, I think
it's kind of like Steve's idea of having a group way we go at this.
I think it's a good idea, and I see staff furiously writing, so hopefully it can be implemented.
Yes.
Yeah, I mentioned, Steve and I discussed this also. The people that are in this room all seem to want to work together, whether they're in Regina Heights, where they don't want the bad apples, as someone commented, or up in Laytonville, who all want to work together and have their grows up there. I really would like, everybody, or at least that I'm hearing from this room, wants to work together. They don't want to be against each other, and I really would like to see the groups work together and come up with responses. I'm hearing the R1 people in the R2 saying, hey, my neighbors don't care, they're not complaining. Then I hear Regina Heights saying, yeah, but, and we have RR2s in Deerwood area. There's got to be a way for us all to work together, because I think we're all after the same thing. We want to get rid of the bad apples. We certainly want to have an economy here that's thriving, and certainly at this point it is going to be cannabis. And I would really like to see that. I hate to put all this behind us, for yet another period of time when people meet, but gosh, I'd sure like to see everybody work together on this. And us 7 people up here don't want to be the bad guy for either side.
So,
Yes.
Madam Chairman, it seems like there was some confusion on fully shielded from the comments from the public. That doesn't mean 360 degrees around the light, does it?
It
Maybe
means fully
that could be
shielded
explained.
so it doesn't leave the property.
I think it maintains dark sky, meaning you don't want the glare up into the sky. It's going to
Yeah.
be focused down. Definitely, there's a different sensor that can pick up, and the light can come on, with the downcast of that light. So, yeah, not fully shielded is not 360.
And that's
They
pretty
would be
typical
pointless.
kind of lighting. That's not some weird new thing we're
Right,
asking for.
right.
It's what we
Right.
ask for with all our projects.
Can I make a suggestion here?
Yes.
We had a suggestion over here to go through the memo, and it seems like we're just kind of rambling around.
We are getting off it. I
Could
get
we
into
ju-
air quality and I got into air
Could we go through the
quality.
memo and then pick up all this fringe stuff? My understanding is we're gonna take AIR 2 and eliminate it. That was the first thing we're gonna do. And then in the second part of it, we had A, air quality, D, and we were gonna remove during the flowering phase. That was suggested. Are we gonna do that?
I think are we agreed about that? I mean, I don't know, do we vote on each one of these
So
changes?
I would make a
suggest
suggestion.
we kind of do a straw vote on, or
I
at least
would-
confirm it.
I would make a suggestion, if the chair hears no objection, then it's done deal and we move on. That way we don't have to
Yeah.
stop and vote every time.
That would be fine.
Okay,
So are we gonna remove during the flowering stage? That would take care of the
Everybody
odor issue.
Yes.
Okay.
Nobody complains.
And otherwise, we're gonna remove AIR 2. Okay, then we are going to look at rewording Bio 1. And, oh, no, wait, there's 2. Bio 2 and then Bio 1.
Okay, what page are you on?
This is page 2 of the staff report. Hello. I think when we're talking about the staff report right now, we're gonna just be talking about the January 19th,
The memo.
not July 19th.
Right.
Is it what Adrian just gave us? This
This
replaces
is, it's a memo, it's not a staff report, I'm saying. Okay, so we're to page 2 of the staff memo from January 19th. And the next bullet point at the top of page 2 is reword measure Bio 2 to be consistent with Fish and Wildlife's comments.
Excuse me, but that should read Bio 1.
Bio 1, okay.
You'll see in the next, and I think what Adrian just and what Adrian just passed out is the strikeout version that we've got on the board here. So hopefully that should clarify for you guys where we're at. So it's this Bio 1 mitigation measure.
So can you explain to me how this works? I keep reading it and it
I know, it gets less English every reading.
Okay, so yes, so the way this one works is that applicants will submit to Chuck. They'll go through the Agricultural Commissioners Program. When they receive the permit application, they will submit a referral to DFW, and it gives DFW a few options. One, there is a pre-permit inspection they could ask to be included in, so they could just go and walk the site at the same time that Chuck's staff is walking the site, and that might solve their issue right there.
No, I'm sorry. I'm applauding with my finger. Right?
Okay. And then they could just approve it at a desktop view. If they don't see anything causing them issue, that's an option they have. They could come to the pre-permit inspection, or they may request additional studies. If it's a sensitive area that they're aware of. These again are biological experts. They know the county really well. So those are kind of the three big options they have available to them at that time. And then if this is the really important part of this mitigation measure, because again, we don't have discretion on these projects. So they're limited in the options. So that basically, if they make a determination that there's an impact to a sensitive species, they basically have to require that operations plan be revised to eliminate that impact. They can't come up with mitigations. We can't say plant something over here or do some wetland mitigation over there, because that's in the discretion realm. So all they can really say is there's an impact here. It's a no-go. You need to put it someplace else so there's not an impact. So that's kind of the only options they have. And then in the long term or short term, depending on how it all works out, the ultimate goal is that DFW again will hand this process over to the county, and that they'll deem the county qualified to run with it. And so it's something, the verbiage here is something we worked out in close consultation with DFW. They really didn't appreciate our first wording where we were going to them first. That they felt like they were going to be getting overwhelmed with sort of cold calls. They like the referral process better. I think it gets us to the same outcome either way.
Thank you.
So earlier today, we dealt with a minor subdivision that had a Fish and Wildlife referral. How much did that cost?
How much would they have to pay the Fish and Wildlife?
How much did the subdivider have to pay Fish and Wildlife based on the referral?
It'll be $2,200 is what they'll have to pay. This is
No,
different.
I'm not saying that these people have to pay.
You mean
I'm
it's the
saying,
referral process?
I'm saying in the referral process that applies to minor subdivisions, the subdivider has to pay a fee to Fish and Wildlife Service.
No.
Yes. The subdivider pays a fee to Fish and Wildlife Service based on the fact that they are doing this review of the project, right? Didn't the applicant for the minor subdivision complain about the permit fee, the fee he had to pay to Fish and Wildlife?
That wasn't a referral fee. That's a fish and game fee in the code required for a CEQA document. Right. So he had a negative declaration proposed for his project.
So where I'm going with this is, how long is it going to take Fish and Wildlife Service to determine that they're going to have to charge a fee for the referral? No answer. And how many referrals?
Not very long.
How many referrals do we get back, actually get responses back from Fish and Wildlife Service?
Not many out, however, we do it within the coastal zone. We do have a lot of comments back, but typically inland, we don't have a lot.
Are you talking about legislative creep?
I have a question on that.
Well, I'm afraid everybody's gonna look at cannabis cultivation as ka-ching, and it just doesn't seem right, but.
So the intent is, in time, that we won't be making referrals to Fish and Game. We'll be making the decisions in-house.
That's correct, and really only sending over to Fish and Wildlife. What will happen ultimately is that they would remain involved if the county identified a sensitive species, which is appropriate to have them involved in those cases.
So will that happen in a year or 2 years? When is that going to happen?
In talking with the folks over at Fish and Wildlife, they also would like it to happen sooner than later. They are also inundated with cannabis issues from not just this perspective, but again all the lake and stream bed alteration agreements that are coming forward. They have their own staffing challenges. So I think it's really both parties are motivated to make sure this transition happens, and it's just a matter of getting everybody up to speed.
Thanks. That's comforting.
Yes.
I have a question in regard to, you mentioned the 30 days. If Fish and Wildlife doesn't respond within 30 days, is that an official time frame? I mean, is that part of your program, or was that just an about 30 days?
That's the typical amount that goes out with referral responses. So it's always a request to reply within 30 days. So if they came in later, I don't think it's good policy to just ignore their comments, but that is the goal, is to get their comments in 30 days. And you move on with your permitting. You can't wait forever for an agency, and I think everyone respects that.
So we could think that's an official number then?
I think it's the common number that's been used for all permitting.
Okay.
Well, if it works like the forest practice rules, they'll just recommend denial unless you give an extension. So the 30 days means nothing.
And I've been waiting close to 25 or 30 years for a water resources control response to my water application. So is there something, can we put 30-day limit in here and then we move on?
Well, we could definitely recommend it to
Well,
the
let's
Board of Supervisors.
Excuse my wording. Yes, can we recommend that to the Board of Supervisors?
that we'll do this referral, and if we haven't heard in 30 days, Commissioner Morris can move right along.
Yep.
So just Deputy County Counsel Matt Kudrowski, about the resolution, I'm kind of working on augmenting that as we go along. There were kind of 4 different sections of things for the board to consider doing. I'm going to lump in this kind of recommendations to continue, look into, can we make a 30-day referral period? I'll be adding that to our 4th section, and we'll
All
get
right.
those hopefully up on the screen before we're done.
Thank you.
Are there any other questions on Bio 1 that anybody has or comments? Then the next bullet point is change the MCCR to clarify its intent to allow multiple cultivation sites on a legal parcel so long as the total area cultivated does not exceed the maximum allowed for the zone and permit type issued. Everybody okay with that?
Yes, I would
Yes.
just think this is appropriate time to comment on the comments that came up about tenants in common.
Yes.
I don't know how that would work, and I would kind of hate to slow this up because of not knowing, so unless staff has a easy answer about how tenants in common might be handled, it'd be great if we have it now, but.
Well, I'll just comment that the board has set the maximums for the different permit types. That's been established and maintained through the majority of this process to this point, and it's always been that capped amount per legal parcel. So that's why the wording is reflected as it is right now in the draft cultivation ordinance. Going the direction that we heard from the commenter would lead to every single tenant that might be on that parcel could go up to 10,000 square feet. So that it would seem to be contrary to current board position, at least.
Right.
As the commenter, and. Just one second, do we have any more?
My understanding of the comment was that with multiple tenants on a single legal parcel, that the request or the comment was that those individuals be allowed to attain their own permits and grow up to the maximum of that permit, and that's not how it's, obviously not how it's worded right now. That was my understanding of it.
And we don't know how many tenants that means, so we don't know how many different sites that might mean. So I'd like to leave it alone for now, and they can bring it up with the board.
And I think, one recommendation that I'm gonna have for the Board of Supervisors is that whatever first cut we make, they need to be planning to revisit this, because we're gonna learn a lot.
Right.
After implementation.
There's one other option for the Greenfield subdivision. If you had, say, 160 acres and 3 tenants in common, they could do a minor subdivision and legalize all 3 of those parcels. Then they could be in complete accordance with the ordinance.
That's true. Okay, so we're gonna leave that one alone. Changes to the aesthetic section of the,
Chair Holdencamp,
Oh, sorry.
excuse me. So you were addressing the second bullet on page 2, is that correct?
yes,
So that bullet is actually just relative to a misunderstanding of the use of the term sites in the zoning code and things of that nature. So it's just clarifying definitional language in the 10A.17.
okay,
It's
so
not-
that isn't even in our thing,
it's not addressing, I think, what the commenter was actually speaking to.
right?
It was, we had seen in prior public meetings that there was just confusion about you can only have one site. Well, in the planning world, that can mean the whole location, and people were saying, well, we have multiple locations where we cultivate cannabis on our legal parcel, and you're saying we can't do that, and that wasn't the intent. So
Right.
that's what that bullet was all about, just for clarification.
Okay. And everybody's okay with that, right? Okay, so moving on to changes in the aesthetics section of the initial study. The visibility restriction is to apply to plants and not to sites, is my understanding of that. And again, that's a clarification, right? That's not
That's
something
right.
we have to.
And we had some comments about the viewing of the plants, and should it be from a distance or significant effect, or I can't quite remember the words. That's really hard to call.
It is. And hard to regulate.
I kind of feel like just because you can see plants, if they're way far away and you can't even identify what kind of plant they are, that maybe that's not an aesthetic impact that is significant. But if you, but I don't want to hold us up in minutia.
Yeah, it's a matter of degree at that point.
Yes, it is. It's a matter of degree. Is the reason, is the plant ugly because you can just tell it's a plant? No. Is it an aesthetic? Does it have an impact to aesthetics because you can tell it's a big marijuana patch? I don't know, maybe. So I just don't know what we do about that.
Well, I think that's one of those things that will become clearer over
Yes.
time.
Yes,
So maybe we can't deal with it now.
right. That's fine with me.
The next bullet point is the change to table 1 and 2, and Beth, would you like to talk about that? This is the first bullet point on page 3 of the staff memo.
Sure, this,
So you're just clarifying that in I-1 and I-2,
right, it's with a zoning clearance. So it was just something that came out, that we noticed at the published version, and it showed that there was a permit for medium outdoor cultivation site and would be allowed in I-1 and I-2 zoning districts with a zoning clearance. So yeah, it's just to clarify that was the intent of the board.
okay.
And just for clarity, I reviewed the previous documents that had come before the board, and it was consistently a not allowed situation, and then in the meeting on September 2nd, all of a sudden it showed up as zoning clearance at those two things. So we recognized that late in the game, and it was in the memo for our December 1st meeting, I believe. So we're just trying to, record it and codify it here and correct that.
So then, I think we've dealt with the second bulletin point, the fully shielded security lighting.
We may have dealt with it, but did we get a solution?
Well, I think we agreed that what that meant was not 360 degrees of shielding, but fully shielded is when the light does not go past the property.
Okay.
And that's pretty normal in all our subdivisions and constructions and things like that.
I'm with that.
And so with that understanding, is everybody okay with that one? Okay, the next one, I guess you're just wanting to check in with us, Mary Lynn, about these ones that you think you understood from December 15th.
Correct.
So we are agreed to eliminate dwelling units for upland residential parcels.
Could we go back one paragraph?
Sure.
We need, there's not a bullet point, but there's the previous sentence regarding the oak woodland protection and grading ordinance.
yes.
That was a recommendation last time.
They have the period 2020, and based on the pending level of ordinances that are going to go forward with not only this, but Prop 64 and that, I don't think it's realistic to think that this county is going to move forward with either of those ordinances in that time frame. So I would make a proposal that states that the permittee shall obtain a grading permit under section 1870.06 where any grading as defined in section 1870.05 and/or where the use of unsurfaced roads occur during the period November 1 to April 1. So essentially that would require, if necessary, a grading permit under the existing grading ordinance for the applicant. If they're not doing any grading, there's no reason. But I also included that a grading permit would be required during the period November 1 to April 1, which is basically the winter period, because of the use of these older unsurfaced roads that were not designed for year-round use is where a lot of the sediment and stuff comes from. So if individuals are using unsurfaced roads during that period, they should have a plan for maintenance. And so I would add that language as opposed to encouraging the grading ordinance at this time. If the soups want to do a grading ordinance, that's up to them.
Although I sure would like to see that.
Then I would also like to say that as far as the oak goes, and potentially an oak ordinance would be appropriate, but in the interim, that there be added that no true oak, and it be Quercus species, shall be removed or otherwise harmed in the association with any cannabis cultivation operation.
Pretty simple. Chief
A
to
lot of
administer.
protection.
Dead silence.
I know, I think that's good.
Yeah.
I still want to see those things in place before we go to phase 3, though. I'm telling you, I do.
Well, we can argue about that later.
Right. But I would like it to be in here as a suggestion to them that before we expand this beyond our existing cultivators, and I'm pretty willing to work with those folks because I think we have a big learning curve ourselves, but before we open it to Anheuser-Busch, I want those things in place, really. So what I would like to say to the supervisors is I don't care if it's 2020, but before phase 3 sets in.
Well, by 2020, we might have a better idea of the economics of cannabis in Mendocino County and how much pressure there is.
Until the first bubble bursts, though. Although that is my position.
Yeah,
I think
yeah.
the first bubble
Well-
should burst.
Well, I like
before
Jim's
phase
wording.
3.
I don't have anything to add.
I think there's more to an oak woodland protection ordinance, though, than just that regulation. That might be important. But
I think that suggestion is really good for phase 1. I just don't think that we should kind of say that's the end of it. I
Right.
think that we should talk about, before we start issuing new permits for new cultivation sites, that these things should be in place, or that we suggest they should be in place.
Agreed, but with the proviso that we understand that oak woodlands is more than just oak trees.
right.
Right. Well, and that's why I agree that we're not gonna get that ordinance by spring planting season, so I don't think we should require it now, and I like that language that Commissioner Little offered. But I also would like to be saying to the supervisors, no, we take this seriously, and we think before you expand this thing, you need to have really looked at these things, grading and oak woodlands protection, which are pretty intertwined in a lot of ways.
Yes, and I think that's important that we pass that on to them. Because more than just protecting each oak tree, an oak woodlands protection ordinance, as I understand it, would also possibly help to identify Native American sites and some other important features. So it still doesn't eliminate a look at oak woodlands.
So do we,
And we don't have an ordinance. I know Commissioner Nelson thought maybe we did, but we only have a policy in the general plan that says we should look at an ordinance.
No, there is an ordinance.
there is an ordinance. Yeah.
Well, there's a regulation.
It's just a
So
policy.
two things. There is a grading ordinance, right?
Yes.
It's a chapter of the building code.
Right,
But we do not have, so the
That's not
policy is in the general plan to create an oak woodland ordinance. But that does not exist. There is a grading ordinance on the books.
So Commissioner Warren brought up a question in my mind. Is there anything in this ordinance about Native American sites?
In the grading ordinance,
Yes.
I'm honestly not familiar with it, and
No, not in the grading ordinance. In this.
in this,
Yeah. 10, 17, 70, whatever it is.
no.
Only the discovery clause.
Is that something we'd
Discovery
like,
clause only.
is that something that we'd like to see?
Well, an oak woodland protection ordinance would help kind of get us there.
Yeah, but I don't want to oak woodlands. I have no problem with Native American sites.
So just, we're kind of gotten off the
Yeah, I
rail
mean,
again.
that's into the archaeology.
So why don't we'll come back to ARC after we get through with the memo.
So where are we about this the oak woodland protection ordinance and the grading ordinance? I am very willing to go with Commissioner Little's suggestion for phase 1 only. I would not be able to agree to it over the long haul. Then I think we really do need to look at, I know we have a grading ordinance, but it's kind of an embarrassment. And we don't have anything for oak woodland protection except a policy in our general plan. So,
are we unanimous on Commissioner Little's wording?
yes.
For now, that's fine.
Well,
On
with
protecting-
the exception of that until phase 3.
Protection of the oak trees? Protection of the oak trees?
Right.
Protection of the oak trees, and also that they have to get a grading permit if there is any ground disturbance between November 1 and April 1, is what you said. And I could agree to that if it's a time limited, that's all we're gonna do.
And then move ahead with the adoption
And then
of.
before the implement of phase 3, look to upgrade those protections with ordinances,
I think you're gonna have to call for a vote.
okay?
Oh, I support that.
So everybody who supports that idea?
Okay, so I support Commissioner Little's wording, but I don't support,
Would you like to separate those
Yes,
two
I would.
things? Okay, so Commissioner Little's wording on these bullet points.
Well, wait a minute, there's the oak woodlands.
And he said grading permit between November and April.
Okay, so you want to split it in half, one here, and 2 separate votes. Is that what we're on?
I want an agreement or disagreement on Commissioner Little's wording.
I
I'm
would
for it,
agree.
Yes.
For now, as for phase 1, right.
Yeah. Do you agree that that's for phase 1, that we're agreeing to this?
I don't.
Because otherwise, you might
I'm
see a
not-
different vote.
I wouldn't restrict it to phase 1. But if you want to discuss the grading ordinance, that would take precedent over Commissioner Little's wording in phase 3.
Right.
So this would apply, I mean, my impression is, this would apply, my wording would apply until a grading ordinance is in
Yeah,
place.
until there's a change, yeah.
And I agree with that. What I still want to say, though, is that I do not want to see phase 3 be implemented without those protections.
I agree with that.
I do too.
So, we taking a vote on it?
Okay, are we taking 2 votes or are we taking 1?
We already took one. We
Okay.
decided on the wording.
Okay, so now we are saying that before phase 3, we are suggesting that these be in place.
Yes, and I agree. So 4, I can't see over there.
3, 4.
Mm-hmm.
Okay,
4
so
to 2, I guess. I don't know. Are you
4 to
abstaining?
3.
I didn't vote for it.
Okay.
Okay.
Excuse me, can we have clarification? We're not really sure what happened.
We're saying that we would like to recommend to the Board of Supervisors the language that Commissioner Little suggested about requiring a grading permit.
Okay, so with comment to that, it should be known that a grading permit's required all year long. I don't think we have to be specific to timelines.
Okay.
Because if you do any type of grading that falls under our grading ordinance,
Well, what I was trying to get at with the application during that period was maintenance of the road during the winter period. They may not be proposing any grading or work on the road, but they should be required to maintain the road during the winter period. And the tool for requiring that would be through a grading permit that stipulates that, you know, culverts have to be cleaned, ditches have to be maintained, you know, discharges cannot be directly into the water course. I mean, somehow we have to recognize that the winter use of these roads that were not designed for winter use are causing a significant amount of sedimentation into the creeks. And there should be an avenue to require maintenance on those roads.
Boy, and this weather is proving it, isn't it?
Boy, even in town.
Seen it today, yeah.
I guess as far as staff goes, I'm just not sure where we're gonna catch that at. Beth has something.
I just want to say that we do have mitigation measures that put in place that, and it's built into the ordinance, and then we reiterate it for all permit types that everyone has to comply with the standard conditions applicable to all dischargers from the regional board program. And that does have a lot of specifics on road development and how you maintain them and preventing erosion from roads. So I think that is the catch in this particular case. It's not, you know, it's only relating to cannabis. Of course, a grading ordinance would be countywide and apply to a multitude of other circumstances. But the reason we didn't go that far for our recommendations in this ordinance is because we have the protections in place from the water board. So we found it slightly duplicative there. But that's our reasoning behind it. But just to know that there are things built in that do speak to road development specifically.
How is that enforced?
That will be, I think, primarily through, and maybe Chuck can speak to the enforcement of it better than I can in terms of
The water boards program?
Yes, for best management practices for rural roads, dirt roads.
So the water board has their standard conditions, and they also have a wide suite of best management practices as well that they codify that are enforceable. And it's the water board's responsibility to be enforcing those.
If in the springtime your inspectors go out and see considerable erosion on one of these roads, will that be brought to the attention of the Regional Water Quality Control Board?
That's something that should be brought to the attention. Well, ideally, in the design, the third-party inspector would be out there possibly seeing that. That information would be forwarded to our office, and we would forward that information on to the water board. Sure.
All right.
Well,
Thanks.
if that's good enough for regulating winter use of these roads, why isn't it good enough for all excavation, for all grading? You're saying that water board will regulate the use of these roads during the winter period, so they have regulations in place. Wouldn't they also apply to any other grading? So why wouldn't that serve the purpose for all grading and not need to further amend the county's grading ordinance?
I can't speak to the water board's specific intent or desires, but their order, their waiver and order is very specific to cannabis alone.
And isn't that what we're dealing with, is cannabis?
Right.
Isn't that what this ordinance is about, cannabis? And you're
Yes,
trying
yes.
to tie a grading ordinance to cannabis. And so I'm just saying, tie the water board to cannabis.
And can I make a suggestion here, since they're getting into a lot of specific details about the existing grading ordinance, which clearly was written before any of this came to light with the cannabis cultivation. I think perhaps rather than trying to get into those details of why does it say this or not say this, a recommendation to the board could be that they consider an addendum or an amendment to the existing grading ordinance specific to the cannabis cultivation ordinance. Then that puts it to the board to consider all these great points that everybody's bringing up that should travel with the cannabis ordinance itself. And it would be relatively straightforward to have an addendum or an addition to the existing rather than reopening the entire grading ordinance, but saying this is the new information we have now relative to cultivation and have an addendum to it. Otherwise, it's going to be very difficult to get into all the hypotheticals and how do we address it. And clearly, your existing grading ordinance did not consider these specific issues. So, just a suggestion
It
is.
seems to me that when we're talking about the grading ordinance, there's the Uniform Building Code grading ordinance.
Yes.
And there's the other grading ordinance, the elephant in the room.
No, the grading ordinance you have is tied to the building permit code. There's not a separate.
And would that be, is that of necessity the same grading ordinance you're talking about here?
I'm sorry, what was that?
Is that of necessity the same grading ordinance you're talking about recommending to the supervisors?
Yeah, so you have an existing grading ordinance which has no specificity towards cannabis cultivation whatsoever. So it would, I'm suggesting that your recommendation to the board could be to consider an addendum to the grading ordinance specific to cannabis cultivation to go with the cultivation ordinance, because it's not addressed in the existing grading ordinance specifically.
No, I'm not sure I understand you. What we have is not relevant or useful to the cannabis situation. It would have to be modified as a grading ordinance for this cannabis.
Yes, that would be a way to look at it in this specific context. So your grading ordinance, just like every city and county pretty much has a grading ordinance tied to building permits. So you go build a single family home, you put in a driveway, it's meant to be across the board for any type of grading.
Which isn't really useful, I don't think, in this circumstance, right?
That's what I'm suggesting, that some of the types of the winter operations, some of the things Commissioner Little is bringing up, could be addressed more specifically as an addendum to your existing grading ordinance specific to cannabis cultivation and the specific concerns associated with that.
And how do we address, because I think this is the big worry about the future. When recreational marijuana is implemented, growing recreational, and phase 3 for medicinal. A person can buy land, putting in a site to grow if they're not going through the permit process. And there's going to be so much more pressure for people to do that, that if we had a countywide grading ordinance that was stronger than just being tied to the development of a home site and a new road for a home, would somehow I don't know if it'd be a detriment, but it would at least be a tool. That's kind of what I'm concerned about. And I don't know how, maybe a more specific grading ordinance to go with this ordinance. But maybe it just needs to be countywide and not tied to cannabis.
Well, if I could add, I think, this comment in here that we put, we heard this as direction from all of you. It was not proposed as mitigation. And the reason we didn't propose it as mitigation is because we felt like between the performance standards that are already built into the ordinance and the way that the water board's provisions are built into the ordinance and the mitigations we have to incorporate the best management practices, that for cannabis, we're there, and so if, the options we're talking about are just sort of kind of spitballing with all of you to help get you to the recommendation, I guess. But the reality is, from a CEQA perspective, our recommendation wasn't really to mess with the grading ordinance because again, they will need a permit. Your grading ordinance, if I think it's above 50 cubic yards, if I'm not mistaken, you get a grading permit. Now there's things that happen that are less than 50, and you'd be out of, you wouldn't necessarily need a grading permit for that. So that's where, we have all these stopgaps built into our programs where the water board's provisions, they kick in sooner than that because they apply to roads. Even if you're not grading a lot for that road, there's still a standard on how to maintain it. So I think we're covered for this purpose, would be my recommendation at this point, but certainly, there is a question, and I think there's been a long history that I'm not aware of completely of what's happened with the grading ordinance and the last time it tried to get through in this county. So, that again, just to say, this is something we've heard from the public. That's why it's on your sheet. But I think we're okay from a CEQA perspective.
Well, I kind of then, Commissioner Little, do you think we should rethink your words for the grading? Or not?
Which part?
What you proposed today.
As far as the
grading.
winter period?
Yeah.
Well, if the staff has problems with it, that's okay. And if they feel that water quality has the mechanisms to deal with those issues, then I don't have a problem with deleting that.
No.
So would it be okay if we had the clerk read back what's been proposed?
I was just about to propose that. I'm lost.
Delete Jim's wording and back to
Grading permit required year-round. Ordinance implemented before phase 3.
I can read what I
Is
said.
No, I think just the time thing he was proposing, not the whole thing.
So what I
Pardon?
said was, the permittee shall obtain a grading permit under section 1870.060, where any grading as defined in section 1870.050 is done, if I delete the rest of it. So in essence, it requires them to get a grading permit.
You got that, Adrian? Okay. All right. Thank you.
I still think we have to beef this up before 2020, but I'll go with it.
We did have our vote though, right?
We
That was
haven't
4
had
to
a
3.
vote on the 2020 part. We've had a vote about going with Commissioner Little's recommendation of language, and that we agreed on. We have not had a vote on the other.
Oh, I thought we did, no, it was 4 to 3.
We did.
Oh,
We did.
okay.
Yeah, we did.
I lost track of which one it was.
I know,
Yeah.
it's a tough job.
So, are we ready to move on?
I think so.
The second bullet is where we have to go, right? So this is maintain that parcels in the RR1, RR2, and RR5 zoning districts require a residence. However, allow an exception in the RR10 zone. Yes.
I had okay.
So I understood that we agreed to something different. And the last time we discussed this today was debating whether we should eliminate grows in RR1 and RR2, or RR1, RR2, and RR5.
And R1. Well, that's already done.
Yeah, that's done.
That's not allowed at all. But now we'll be able to do something about abating it.
I think so, but we skipped one. We skipped the UR, so we better decide on that first.
Right.
It'll make it easier to go to the rest.
You're right. So are we agreed about the eliminating dwelling unit requirement from UR zone parcels?
Yes, I think so. Staff had the idea of requiring an administrative permit, right? Oh, where did I see that? We had talked about how to make sure that there was a site for a home. Was that in Upland Residential?
I don't know if we talked about that with UR.
I think it's the RR that
Maybe
that
it's
would
the
come in
RR.
place.
Okay,
Yeah,
I'm
UR
sorry,
was-
I'm sorry.
So, what I would like to see is that we do not allow grows in RR1 or RR2. And that a house, a residence is not required in RR5, RR10, or upland residential.
And there are some RR20s, so that would be included too, huh?
Yeah.
No, there's no R20s.
There is not,
No.
oh, okay.
When you say not
So we'll
allowed
cross that out.
grow in RR1 or RR2, do you mean, what about people who are themselves patients or caregivers for a patient? Who are,
Were you just trying to complicate things?
yeah, but they're not subject to this.
No, you're right.
So,
That's a different,
so that is allowed.
yes.
I'm sorry, I didn't.
So what Steve was correcting me on was that if you're using for patient care,
Yes.
then it is allowed.
Yes, for your personal use or a caregiver, it's everywhere.
It
We're
doesn't come
we're
under
not
this.
addressing that in our ordinance.
Well, I did, until I saw the maps today, I thought that RR2 should be eliminated from all the charts and the language as being available for a site. But looking at the maps, the RR2s really don't affect inland so much. They certainly do around my area, Fort Bragg. I don't know of a lot of complaints about those areas near Fort Bragg, but I'm not sure I would. So I might reconsider RR2, but RR1, I really do not think there's enough space in a 40,000 square foot lot to accommodate, even with setbacks, to accommodate odors and traffic and so on. So I would really like to see it out of the RR1. Now, for those that are there already and will be able to get a permit, what do we do with those?
Well, we haven't got there yet. I
Right.
think that's on the discussion board later, but we were talking about a phase-out period.
Right. So,
And so, I'll, when you're finished.
well, so it would mean that we would take RR1. Well, it's not in any of the charts. Right. So that makes it easier. If we were to take out RR2 also, then we'd need to eliminate reference points to all those permit types in section 10A 17080. And decide what about the ones that have already met the permit requirements? Do we have a sunset clause for them to leave in twos, or is it only for ones? And then, of course, we'd need to go even beyond for type C and type 1, that no new permits would be allowed in RR2. Change the charts in tables 1 and table 2, but you guys know all about it, where you need to make changes if we do that. So I would maybe reconsider the 2s, but I'm not sure. They're still also small, but the ones are 40,000 square feet, I just don't think is appropriate.
There's odor in RR2s, and, you know, I'm a homeowner in an area where they're I don't know if it's RR2 or not, but they're 2-acre lots. And the other issue is home invasion and dogs. And with those two, in addition to the odor, I have a problem with allowing the continued growing of cannabis in RR2s. So that's my background.
I
agree.
I have a question. Could you walk me through the allowance for cultivation on RR1? How you read this?
For RR1, no cultivation except for existing grows that they'll have to get a permit for an existing grow. In addition, personal use and for caregivers, for medical purposes, that can go anywhere.
Okay.
So in RR1, if there's an existing grow site now, they can stay there. R1, RR1, SR, wherever. If they're an existing grow, they're grandfathered in.
Okay, so I think I've gone through this before, but in the fog of war, I'm getting,
Join the crowd.
yeah, right. So under D, under 10A 1703,
10
D,
Wait a minute, I gotta get to that ordinance. 10A,
yeah, 10A 1703, cultivation permit
D.
required.
D, yeah.
D as in dog. Qualified patients or primary caregivers cultivating medical cannabis pursuant to this section are exempt from the permit requirements of B.
correct. But they have to register.
Okay, they're exempt from the permit, but then in table, whatever that is, 1, is it?
Yeah.
In table 1, it has no, oh, and that's under table 1
In chapter 20?
on chapter 20.
Okay.
There's no,
Well,
there's no indication that RR1 has an allowed use. So you're exempt from the permit, but you have to follow the zoning. And under your table, it does not show RR1 as there being an allowance for grow.
I think there's two things separately going on, because one is the qualified patient caregiver exemption, and that just means that doesn't get into zoning. The second thing in that table, the table 1 table, and what immediately follows that talks about if you're an existing site in a zone that is not listed in table 1 of 04.
Oh, okay.
That's D.
To make,
So D is where we talk about an existing cultivation sites.
all right,
Then you follow permit requirements, and the following page of the approval requirements.
right. I got it.
Since we can't even find what paper you're looking at, I hope you know if it's okay or not.
It was just in the code section 20,
Oh.
the 20 series code section.
I got that.
So, I'm interested in hearing what other commissioners think about eliminating the requirement of a residence.
We have done already on RR1, RR2, and RR5, right?
No,
Well, that's
those-
for
no,
growth.
it's only the upland residential that we said no residence needs to be built.
Maybe
Only
I,
R- sorry. So
I
only-
thought,
Only the UR
Mhm.
or the residencies to be built.
Right.
Yes, we've eliminated the
Right.
necessity on those RRs altogether. Yes?
go ahead.
I'd like to ask staff, what's the logic for requiring a residence before we eliminate that requirement?
And I know that Chuck has been part of the discussion. There's been lots of discussion through time. And I'm just remember going back to when Andy was here and talked about it. A lot of it had to do with maintaining a supply for housing, to maintain our housing element qualification, and also safety. If you just have a grow site without a residence,
Fires, danger.
who's going to watch over it? I know nowadays, there's all kinds of security stuff that goes on, but when you have a grow site in a residential smaller parcel area and there's no one there to maintain it or watch over it, there's a safety element to that. And if there's more to it, yeah. So there's two elements.
Yeah, but I think I
Housing
look at
and
the other
safety.
side. I mean, how many small grows are there where we have these problems anyway, and there are people living there, and people are getting killed or knifed or whatever. So I guess I look at it from the other side. I don't know. I'm with you. I don't think a dwelling should be required.
I'm sorry, a dwelling should
Not.
not. So then you're taking away from the housing supply, just to
Well, it doesn't
reducing
preclude,
it.
it doesn't preclude a house
Not
from
at
being
all.
built.
No.
So,
Although it would if they built a big greenhouse and, I mean, they could use up that lot in such a way that now it can no longer support a residence. And I think that is the thing that Andy was worried about, was that we were somehow going to erode our available housing sites. And
for
we've
that,
already been sued about that.
For that reason, I would like to see that RR5s continue to require a residence, but RR10, I think is a little different. They're large enough that there's probably going to be a home site, but this is where the suggestion was that an administrative permit be required to do certain things and maybe even have some of the infrastructure in place, but at least be reviewed. That was your thinking with the administrative permit?
Yeah, and the other thing is you have to, there's going to be smaller parcels. Even though you might have an RR10 piece of property, you could very well easily have just a 1 acre parcel of land. So you have to think about that. Do we want them to maintain a certain acreage if there's within a 10 acre zoning in order to be exempt from the housing requirement?
yeah, in my notes, I wrote down conforming RR5. It can't be an RR5 with a 2 acre, 2 acres in an RR5.
Right.
Didn't we discuss the possibility of a site plan as part of a way of making sure that you weren't taking a parcel and using up most of it?
And there would be one submitted with the permit application that we would review. I think with the RR10, and if you or even a 5, if you maintain a certain acreage, I don't see a problem with maintaining adequate area for residents, septic replacement area, all that kind of stuff. When you get anything below that, that's when we have problems, and where an administrative permit may be warranted. But other than that, I think that's a review that could happen through the permit process.
Mm-hmm.
So, related to the concern about having or limiting housing sites, we have a whole subdivision down here that's just sitting there. So is that a big issue for a while?
Is what a big issue?
If we eliminate housing requirement on RR5 and RR10, eliminate that requirement, are we going to run out of places to build houses when we have a whole subdivision down here that's empty?
The numbers always change.
Okay.
When we have to go through reviews, so that's a tough one to answer.
But aren't these smaller parcels, don't they tend to be in water districts? And, in other words, to have more of the underlying infrastructure that would support housing as opposed to some other use. And I think that is a legitimate worry. We really don't want just a house plunked on every acre throughout the county and, without the infrastructure to support it. And I think these residential neighborhoods may not have, a sewer district or something. They may be on septic, but they're somewhat organized and they have a community road and they have, some kind of drainage plan and they have electrical service to the area. They're not off grid, all those things that make it housing.
Well, the RR5s and RR10s that I'm aware of on the coast are all just a mishmash. They're on septic and well. They're not in districts.
Right.
So, Madam Chairman, can I make a suggestion?
Sure.
Let's take a vote.
Okay. What are we voting on?
So, I would like to know what the commission thinks about eliminating the requirement. Are they yes or no for eliminating the requirement on RR5 and RR10s?
You want to vote on RR5s and RR10s separately?
Is there anyone that dissents on RR5 other than me?
Me.
I don't understand what the question is.
Eliminating the house.
Are we going to continue to require housing on these parcels?
All right, so make it simpler. Are we going to require housing on RR10s?
No.
No.
No?
Everybody who says no, hands up.
All right.
No.
Okay, we're
Are
good.
we going to require housing on RR5s?
I don't,
No.
well, I can't vote on it because it's an incomplete question. Are we talking about the site? An available site on RR5 or a completed house? Because that would change my vote.
Okay, my vision was that we're talking about an RR, a legal conforming RR5 without a house, and somebody wants to grow marijuana on it. Are we gonna require a house? Everybody raise their hand that wants yes.
I guess, I mean, if,
I think so too for fives. I do. This is ridiculous. but
Okay, so we're gonna
I just
require
think
a
it's
house on
best.
RR5.
I would be okay.
Well, we're split with it. Let's give that to
Yeah.
the board. We're split with
Okay,
it.
all right.
That I am okay with requiring an available home site on an RR5. I don't necessarily need the house to be already completed. We had somebody, that made a comment today who, they can't afford to build their house yet, but they still maintain the site
Okay,
for housing, you know,
That
so.
satisfies me, yes.
all right, so the question would be, are we gonna require a, what'd you call it?
Site.
A site on RR5s, but not require a building?
I could agree to that.
I'll change my vote. I'll go yes for that. And that means that it would go through an administrative permit process. Is that correct?
The same as for the 10 further on in that same sentence, right?
And same for the tens.
I have a question on that. A question for staff. Does staff feel comfortable that, that a site can be defined when you're doing the administrative permit? I mean, what would you require? Because usually you do the soils test for septic and you don't know if septic is gonna work if all somebody turns in is a paper bag with a Crayola drawing on it
That's correct.
and says that, hey, here's my site, it's okay. It sounds to me like you got a real permitting problem if somebody's gonna have to prove that their site is on the parcel.
Well, then maybe we have to throw out the RR5s. I'm not sure that's really where I want to go, but I think we have to remember the long-term thing of, that we've already had trouble about having enough available housing sites.
Right.
And, you know, there are other things that happen in the county besides cannabis.
Yeah, and an RR5 could have such a tree canopy or slope that there really is one good place to grow, and it's the same place for the septic. I think maybe you do on an RR5. You need to know that everything that's gonna perk, and you need to know where it perks, and you need to know that there's gonna be water.
That's why it's been zoned as a residential
Right.
parcel, so that people can live there.
Right.
And so, Madam Chair,
Yes.
Chair, just thinking about the language we're already talking about regarding this, I think the paragraph that's right beneath this in the staff report, and it's also in the resolution, talks about findings for an administrative permit that would require that we can see the cultivation site as well as the infrastructure required for our house, and it even includes language regarding this. If you're on a septic, you may have to show your primary and reserve leach fields as well. So the permit would require some level of site planning to the satisfaction of planning and building to ensure there's the location for a house would remain. That's the language right now just for RR10, and I believe we would want to mimic that for RR5, if I'm hearing you correctly.
Yes. But will that administrative permit really determine that a septic is gonna perk and that there is a replacement site?
Right now, this is worded as a recommendation to the board to consider it, but we could certainly add language beyond what's there to say this may require essentially obtaining a EH permit if you want to have this site without a residence.
Because I would like that, and I think that it is helpful because it's still more expensive to build the house than it is to get the infrastructure in. We'd still be preserving the parcel for housing, but knowing that the owner was committed to putting housing on the lot. And that should it be sold, a future owner would know that they could have a residential site as well. So it would be important that that was there. And then I could go for the RR5.
Does that mean our vote stands?
Yeah.
As modified.
So what are we looking at?
Next.
Page 4.
We are looking at that when they go to get their administrative permit, they're going to have some kind of a site plan that shows where their leach fields and their house site would be.
And
like
they may
that.
be required to get the perk test.
Yeah, and they might be required to get the perk test.
But that bullet says require a residence.
And we're agreeing to modify that as long as there remains an available home site on that property, since it is residential zoned.
Could we then read how how we're proposing that to read? Maintain that parcels in the,
No, eliminate that parcels in require. Eliminate the requirement for, I guess we should say.
A residence.
So up on the screen, we're trying to keep track
Oh,
here.
good. Yeah.
So RR10, no dwelling requirement. RR5, you still want to maintain a legal conforming and we should put in parcel size.
Mhm.
Site required, but no dwelling required. Or and then RR5, RR10, administrative permit required for lack of dwelling, accompanied by site plan showing available building site. So,
So sorry, Vandy, can you minimize your document real quick? The paragraph on the screen is essentially
5 and 10 are the same, aren't they? Almost.
what's that?
Aren't 5 and 10 almost the same now? Or
That would
5
be, my suggestion would be to make the same, essentially the same paragraph for both RR5 and RR10.
Yeah.
And certainly once we're done going through the policy issues, I'll try and get the resolution with redlining showing what you're looking at adding today, and we can wordsmith that at that time.
Okay, great.
Well, you know, in reality, if you have to renew the permit annually, planting a garden out there just ties it up for 1 year, and it doesn't really preclude a home site. So you harvest the garden and then build the house. So you really haven't lost anything by not requiring a home site.
I agree. I just think we have to make sure that, it doesn't.
But it doesn't matter, you don't need both of them. Let's say you had a 5-acre parcel and you only have one place for a home and a septic, but that's where you do the garden. You haven't really eliminated a home site if you grow a garden for 1 year.
but there is the potential for a greenhouse.
There's what?
A greenhouse.
Well, yeah, but you could tear down the greenhouse and put up a house. I mean, it's
Build
true,
a
you could have a
building and tear it
greenhouse,
down.
but you haven't really eliminated a home site. It's not like you dug it up and hauled it away. It's still there. So if somebody had a greenhouse for 3 years and then sells the property and somebody else comes in and says, I want to build a house, they tear down the greenhouse and build the house.
I guess the theory is that if the profitability of gardens takes all the RR5s out, then they're not available for houses.
Well, yeah, but if you had an RR5 and you had a garden, or alternatively, you had a blank lot, it's bare and they don't build a house on it, you still don't have a house. Now, what you have to have is the person that's motivated to go build a house. And the garden wouldn't prevent him from doing that. And the greenhouse wouldn't prevent him from doing that. So until that person comes along, nothing is
What are you
lost
proposing exactly?
using the property for the garden.
So what exactly are you proposing?
Well, I think we should just say houses on R1 and R2, no houses on R5 and R10.
I think that's what we did, didn't we?
Yeah. Yeah, but we required a plan.
I don't think you need a plan on it.
So you're suggesting to do away with the requirement for the administrative permit?
Yes.
I don't have a good argument for you.
Yeah, I think I'd
I'm
like to
just
see it
worried
there.
that there's gonna be, people are gonna be living in under bridges because there's nowhere to build a house because it's all gardens, I mean,
Well, it's not gonna happen for a while till we build out this subdivision down south of town.
maybe.
By then, we can change the regulations.
Well, there's so much we don't know about how this is gonna work.
I know.
But we do know that we don't want to eliminate all the possible sites. And by eliminating for new grows RR2 and RR1, we need to give people something hopeful. Those that, maybe not having to build a house will help. So.
What are we gonna do, boss?
Well, we got something up here on the board. Is everybody agreeing with that? The RR1 to RR10 and the 3 bullet points under it?
With an administrative permit.
I agree.
I agree.
Still going back to the site plan required then.
Looks like we lost.
Yeah.
Not for, I'm in.
1, 2, 3, 4.
What were we voting on?
On whether to keep the 3rd bullet up there.
Third.
Well, the
Requiring
third,
an
second,
administrative
and the
permit.
third.
The 2nd and the 3rd.
For the RR10?
And 5.
And again, we're recommending this to the supervisors, so they can change it if they want, but.
All right.
All right, moving right along.
Oh, okay.
What was our vote? Because if nobody knew what we were voting on, maybe we should take another vote.
All right, well, everybody read the 3 bullet points up there under RR10,
1 to 10.
1 to 10. And I think that reflects our first straw vote. Does it still reflect our thinking?
But we only got 3 votes because people didn't know what they were voting for.
I know.
All right, so calling for the vote.
And maybe it's still the same.
Okay, next.
Yeah. Okay, we're good. Next thing. Do we have to do anything about these residential requirements? No. So now we're down to A, the administrative permit.
That's just informational for
Yeah.
the requirements for those
I don't see
permits.
anything we needed there.
So, I'm still on 4, the 3rd bullet. Does a permit go with the land or the person? And I thought we
Where is
agreed that it
4?
goes with
Where
the
are you?
person. Am I on the wrong
4?
page?
Yeah, we're headed to that point.
Oh, I'm too impatient,
we're
I'm
going.
sorry, I'm sorry.
Are we on page 4?
So we have the bullet point for RR
Well,
zones
we were
less than.
just establishing that this administrative permit language is not something we need to decide or make a recommendation about, that that's just informational.
Correct.
Moving to item 4 on page 4. It doesn't look like,
There's no bullet.
no bullets, not much to be done there.
I'm not sure about.
No, I don't know where you are.
I
We're
think
on
the next
staff
one-
report,
Page 4.
Page
Madam Chair.
4.
Page 4.
Are you
Or the
in
staff memo.
the new memo that we got from LACO? The red line?
No,
No.
I
Oh.
am, we're still working on Mary Lynn's memo
Oh, okay, yeah.
of
It's the
dated
same
the
one.
19th.
Original memo of
Okay.
January
I think we need more.
Okay, page 4, there we go.
This is one of the great truths of life.
Supervisors
Paper
made
is
us do
required,
this,
it
give
is
it back
always
to them, make them
provided.
do.
Okay, so, the only bullet point I see up there is in RR2 zone, or RR zones less than 2 acres, require that new cultivation sites be indoors or in greenhouses to reduce odor conflicts. So they're just asking us for clarification if that is our intent.
So this would be for existing grows.
Of less than 2 acre
less-
sites.
I agree with that.
I'm not sure I do. I think that I don't understand really how, we've heard both sides, that the requirement for a greenhouse doesn't change anything but the odor. The other worries are still there, and maybe changes the odor, but it's more expensive to put in. It uses much more energy. If the sites are small, because they're less than 2 acres, the maximum size in less than 2 acres is 2,500 feet in twos. But if we're going to require,
feet on the side, though, I mean, that's.
and if we're asking to eliminate growing on twos, it's moot.
Right.
It is moot except for the people that are grandfathered in.
Right.
Right now.
So if that's what we're talking about, yeah.
And so, the other option is, that we've talked about and heard about, is a sunset. So if you're in less than 2 acres, if you're in RR2, you're gonna have to move in 2 years.
So,
Should it,
excuse me.
That's all right.
Just a point of clarification. So the term new is used in this bullet here, and that implies January 1, 2020.
Thank you. In which case it's moot.
Because by then we aren't gonna be allowing it on R2s. Okay, moving right along.
Thank you. Read that one easy.
Provisional licenses. And I don't know, Chuck, would you like to talk to about how Humboldt County is doing this? It sounds like maybe you're the one who reviewed that.
Matt. Have been working with Deputy Counsel Matt Kedrowski on this. Sorry, Matt. And I would like him to pretty much cover that. The provisional
We would just like
license.
to hear your thoughts about provisional licenses and how that might be accomplished.
So we're still looking at less a provisional license per se. Having a license is provisional in the absence, but before we have an ordinance or after we have an ordinance, isn't something we're currently looking at recommending. But we are looking at the process that Humboldt County used, which was an affidavit. I know at least one of our speakers last month mentioned this, under which after someone applies for a permit, would have an affidavit that was signed saying they're going to abide by that ordinance, and they could possibly could cultivate under that until they got the issuance of their permit. We're still working on language and thinking about how that might look. Separately, we talked a little bit this morning about how this ordinance might look at how we call a public nuisance prior to having a permit. And so we're looking at language we'd present to the board for its consideration regarding this in-between time for those who do have permits, those who are applying for permits, and those who don't have permits, and how enforcement might work. So in the interim, having a stage where people who have applied for a permit, what enforcement might look like for them. But we're still working on that language right now.
And is it your understanding that what the supervisors are considering is that would be a phase one thing, and that in 2020, people will just be required to get a permit
So nothing,
for new grows?
nothing has been presented to the Board of Supervisors yet, so we're still working on language to do so. But ideally, we're looking at how enforcement might work going forward, starting from the present onward, not just post-2020.
So, my feeling is if it's feasible, if you find a way to do it, I would like to support the idea of having provisional permits.
So a provisional permit being separate from an affidavit where they're saying we're going to comply with the requirements of the ordinance prior to them being issued. You're looking at an actual permit, because how you've worked out that permit, what are we authorizing them doing, as opposed to people saying the affidavit would be them just saying certain things, including they're going to be complying with the provisions of the ordinance while they're waiting for their application.
I'm sorry.
I was just going to ask, was there a specific time frame for that compliance in Humboldt County example? I mean, did they have 2 years or 10 years or?
So Humboldt County isn't a perfect example because their program lasted for 1 year. Their ordinance always expired, if I'm correct, on December 31st, 2016. So I can't speak to how far they got, what that looked like. And in our situation, looking at how we might make sure people are ensuring that they are continuing to work on certain things. As has been noted, some of our referrals go to other agencies where they may have to have a longer process, for your lake and street bed permit, for instance. So we're still looking into exactly how that might take shape.
Well, I don't care what you call it. I don't really know the difference between a affidavit or permit, but give them a chance to accomplish the required permits and responsibilities.
Certainly, and we'll be presenting those. Any more detail we can get to the Board of Supervisors by the time we get this. But our office, Chuck's office, and planning have heard the request to do. What do we do in the meantime?
Mm-hmm.
We are working on that.
I think the reality is, whether there's a permit process in place or not, enforcement is only going to incur on those who stretch the law, so to speak. And that all the county needs to do is just establish a sanctuary garden and say, if you're conforming to the intent of the ordinance, we're not going to hassle you until we get this in place. I mean, to have an affidavit is like, I promise not to beat my wife.
But it is a sign that people are saying they'll be complying, and there'll be inspections in that time period as well. While that affidavit is there, we know they're under application, and they can. We'll have ag people out there as well, double checking that they are complying with that ordinance. That's the permit process.
I go back to wanting to have that compliance done before phase 3, when there is an expansion. If we can't get our existing cultivators into compliance, we have no business expanding this.
So when was the last time you worked with Fish and Game?
I never worked
Or
with
Corps of
Fish and Game.
Engineers, or water quality? It can take a long time.
Well, I don't know. My own feeling about this, I'm not sure if this is the meeting for it, but I think they have a time limit to do their thing that they say they need to do. And if they don't do it, then the county can just say, too late, too bad.
You're talking about fishing, or you're talking about the agencies?
Yeah, the state agencies, if they can't get around to this,
Okay.
I don't see it's fair to hold the citizens up. But I do
I agree.
think that we need to, try and get our existing growers into compliance before the expansion phase. And if we can't get them into compliance, I don't think getting a whole bunch of new people who don't want to be in compliance would be a very good idea.
So maybe the implementation of phase 3 will end up being put off because
Right.
of all the problems that are being discovered. And if so, then the provisional license would
Keep them
also
going.
be extended until phase 3 begins or something.
Well, I don't foresee that. What are we talking about? 1,500 permits total? I forget what the number was. 5,000?
I think that's an
okay,
unknown.
so pick a number. So I could imagine where you might have 20 or 30 people that haven't finished the process. Well, go ahead and move on with phase 3 in that case.
Yeah, I agree that if it's 1 or 2 people, but I think as a general principle, either we can get this right with our existing growers who want to comply, or we can't. And if we can't, we should not be expanding it to people who have no investment in the community and the desire to be compliant. So I'm willing to be very flexible with the current people, because they've freely entered into this process, but I'm not willing to just have provisional licenses going on past 2020 and we're hoping to get there someday, but we never quite get there. That doesn't work for me. So are we somewhat agreed about that?
Yeah, I'm feel good.
Okay. Do
So-
you feel like you have directions that the period of compliance would have to be before phase 3 expansion takes place?
So the Planning Commission would recommend that all applicants in the phase 1 must be dealt with prior to beginning phase 3.
kinda.
I mean, I think there's probably some room for, if people apply in 2019, and, it's still prior to 2020, as existing cultivators, maybe they have some problems that do require additional permitting. So I guess the issue would be, just because someone was here prior to that point in time and is applying later than others, not all in 17 or 18, to simply say, keep that cutoff and push it out indeterminately. And I don't know that I would like the alternative to say, just because they haven't gotten all agency sign-offs that are required under our program, that we're going to cut off their application and make them start over again. I think 2020 was chosen to give a certain amount of time for us to go through our existing sites and see what we could do, but precluding any further investment or work after that, which is already very difficult under the way the ordinance is written. Phase 3 is not easy. I don't know that I would want to do either of those. If people want to apply in 2020, they'll get into the hopper, and maybe their site just is an easier, better site than some people who had applied before 2020 under their existing site.
I hear ya. And again, I would say that maybe what we then need is a sunset on the provisional permit process. And so anybody can apply for a long-term permit whenever you open it up, but for people who need this provisional process, because we are in a learning curve here, maybe that process has to end in 2020 or 2025 or whenever, the supervisors deem it wise. But what I don't want is everybody to be able to say, yeah, one of these days I'm definitely going to do it.
And that's what any provisional licensing that we do look at, or the affidavit program, I think we'd have to have some kind of checkpoints to make sure that it isn't just them sitting on an application and waiting for nothing. If they're waiting for a certain permit, to try and show at a minimum attempts to continue that process to go, or have an update process. So I think and if that starts failing, then that's the fail-safe, is it's obvious that the person is not trying to keep their permit going and isn't obtaining all those sign-offs. That's when you would cut them off.
So we leave it up to staff?
Do you have enough sense of
Instead
where we are about this?
I think, at least from me, I can let Chuck and obviously anyone else talk, but I think we understand that the commission is generally supportive of some kind of provisional interim period for what's happening between now and when permits are getting issued.
Right. Okay. Does the permit go with the land or the person?
What about the single owner? The answer is yes to that.
Oh, sorry, I skipped that one. Can a single owner lease more than 2 permits?
I think we decided yes.
I think that's, okay.
So I'm confused about the wording lease. Are we leasing permits, or are we applying for permits, or can a single owner have more than 2 permits?
So permits are being issued to individuals that can prove prior cultivation, existing cultivation prior to 1/1/16. If that cultivator does not own the property, if they're leasing the property from some other property owner, so that's the relationship in that statement.
I got it. Thanks.
I don't guess I have an opinion about that.
I would say, my understanding is, yes, they can have more than one location as long as it doesn't exceed the acreage for that permit.
So individuals can be issued up to 2 cultivation permits, 1 permit per legal parcel.
Well, this is saying the staff position was that at least more than 2 permits, right?
I'm sorry?
It says here in answer to that bullet point we're talking about, as currently proposed, it would be possible for a single owner to lease more than 2 permits.
Well, if it's their land or they're leasing a neighbor's land, I don't have an issue with that.
I don't have a problem
as long
either. I was
as
just
all
wanting to
the
be sure we
permits
were
are
talking the same
compliant.
thing.
Sorry. This is a situation where a cultivator is leasing the property from the owner of that property. So the owner of the property is not the person who has the permit to cultivate. Does that help?
Even more, I
So
guess.
if-
I don't care.
Yes, thank you. Does that help?
Well, so therefore a speculator could buy a piece of land and lease it out for several years, making money off the garden that somebody else is cultivating while they work at their job and saving up for building a house, let's say. I mean, that sounds to me like quite a reasonable strategy.
There's a potential if an owner has multiple parcels, they could lease out to the permittee, the cultivator,
Yeah.
if that arrangement is, if that lease is let.
So in answer to, does it go with the land or the person, the answer is both, right? The lease goes with the land.
The lease is obviously a private agreement between the landowner and the cultivator. The cultivation permit goes with the
It has
cultivator.
nothing to do with the county.
person.
Right.
Right.
So I don't have issues about that, I
Not
guess.
normally.
I mean, that's
No.
correct.
So, in other words, it isn't just 2, it could be 5 permits, is that correct? Can a
But if
single owner
each
lease
one
more
of
than-
those permits is compliant, I don't really see what the issue would be.
That's what I mean, so why does it say 2? Why does it just say numerous?
Oh, it just says more than 2. Can one person have more than 2? And I'm okay with that, I don't.
Well, I'm not sure I understand this. It's saying, can a single owner lease more than 2 permits? Nobody's leasing a permit, are they?
Yes, it's a land
They're
arrangement.
leasing
It's-
the land.
Yes, there's
They're not
possibly
leasing the
confusion on
permit,
somebody's
right?
leasing a permit. That's a good point. So that's not the situation. 1 cultivation permit allowed per legal parcel, up to 2 cultivation permits per cultivator allowed, but every permit has to be on a separate legal parcel. If an individual has 4 parcels, they're not the cultivator, but they could potentially enter into a lease agreement with cultivators that otherwise have the valid right to have an application, submit an application, get a permit, cultivate cannabis. So it's, I think that's a point
So
well
if
taken.
somebody owned 4 legal parcels, they could lease those 4 parcels to somebody to get a permit for growing?
But I
So
think the
they've leased
question
4
here is, can
parcels?
one person lease all those 4 parcels?
One person can lease as many parcels as they want out to permit holders. There could be a permit holder for 40 pieces of legal parcels, and that permit holder is only allowed to have 2 permits. So they may lease 2 parcels from a property owner, and they only are allowed to have 1 permit per 1 grow site per legal parcel. You can't lease out a portion of a piece of property. You can lease out a legal parcel.
Well, then, what is the transferability of the permit for the lessee? Can they transfer that permit to somebody else?
Not the cultivation permit.
The
That's-
cultivator,
that's-
okay. That's
yeah.
issued to the person.
Exactly.
But they can take that permit to a different legal parcel.
There is an ability to transfer, yes. It's written into the ordinances.
So I guess we've answered the question of, does the permit go with the land or the person? The cultivation permit goes with the person.
Correct.
We've already talked about the R1 and R2 zones. That is the next bullet point.
So, Madam Chair,
Yes?
I'm sorry, this is Matt Kodrowski.
Hello.
On RR2, I guess I lost the direction on that. Was there direction to not allow new permits in RR2?
Yes.
Yes.
Okay.
RR1 and RR2.
Yeah, so how would the sunset work? did I steal your question?
You
I'm sorry.
Well, and
I'm sorry.
I don't know, do we have to answer that, or do the supervisors? I mean, let's see, it's 4:25, people. Do we need to settle that?
On the
Or
final
does-
lap, let's not get into anything heavier.
I mean, I guess whatever, I think a 2 or 3 year sunset period would be fine. But I don't care what the supervisors do about that. I think we're advising them that we don't think it's appropriate in RR1 and RR2, and how they want to make that transition. I'm not sure it's a planning function really to do that.
Well, just as an opinion, I would like to see growers in RR1, RR2 zones or other small zonings have a sunset where they have to move to a different location in a allotted period of time, whether it's 2 years or 3 years. I think I'd prefer 2. They have to take their permit and go somewhere else to an RR5 or upland residential or agricultural, some other approved zoning.
Right.
Some other approved zoning, yeah.
Including those parcels, or those sites that might be current and therefore could get permitted and have been in, say, suburban residential. Because we've heard there are a few.
There's R1, SR, RC, yeah, those would all be grandfathered in, so if you're doing this in the RR1 and the RR2, is this something you want to propose for those other zoning districts that would not be allowed for new grows?
Yeah, I'd like to see it eventually moved out of residential areas
The small,
into more
yeah.
appropriate, larger parcels.
Yeah,
I agree with that.
and maybe it's even 5 years, but
Right, I mean, I think that's up to the supervisors. I don't think we have to settle that, but I do think that people are entitled to have a neighborhood free of home invasion. Okay.
So can we, can we just take out the look at and put eliminate all? I mean, looking at, we just looked at it.
Yes.
Yeah,
I'll look it up, I'll eliminate it.
okay. So we'll eliminate that. That works for me. Does everybody agree with that?
No, I'm not
No.
sure you understood. It says, look at eliminating cultivation sites, et cetera.
Well, are we
Take-
gonna be eliminating the other zonings like SR? I was thinking maybe we could put like an acreage limitation, saying that any zoning under 2 acres or under would qualify for this, instead of R1, R2, because
That actually sounds
Right.
good.
you've got the other zonings, SRs.
So eliminate all cultivation sites less than 2 acres with some sort of a reasonable sunset provision.
2 acres
Yeah,
or
I'd
less.
say 2 acres or less.
Yeah.
2 acres or less.
So are you talking, when you say all parcels less than 2 acres, are you talking to specific zonings or all zonings? We have to be specific here.
Well, I suppose you could have a commercial or industrial zone, 2 acres, so we should say some kind of residential.
So I think we should be specific to, if you want to do RR1, RR2,
List them all.
R1, yes, list them all.
Could we
Suburban
list?
residential,
And
R1.
planning can, well, staff can take care of that, but if that's
Yeah,
your
that's okay.
direction,
Yeah.
we could.
They should all be listed then.
Eventually, this should move to bigger commercial areas.
So to follow up, we're looking at not disallowing permits for existing grows in those areas, but just providing a certain sunset period. Do you have any direction on that time frame, or is it just leave that up to the discretion? Well, and it's all to the discretion of the board, but
Yeah, I think,
Okay.
and I'm okay with that. Go ahead.
Okay, all right, well, I'm thinking 2 years, but.
okay.
And I
I'm
think
flexible.
2 years, I keep wanting to have us understand how this industry works in our county before we start expanding it. That's my thing. And I keep coming back to it, that I would really like to see us figure all this out before we implement phase 3. That's
So-
my own thing.
Okay, so we're looking at a sunset provision for all residential zonings for existing cultivation, and then disallowing, based on the tables we have, striking RR2 from those tables is the recommendation.
So, taking the uniqueness of Laytonville,
Yeah.
That's the next bullet.
that is going to pose a problem.
So are we still talking about an overlay for areas
Well, if we
such
go to
as
the
Oak-
next
Laytonville?
bullet and say that there's a methodology for individual communities to apply for an exemption from that sunset, then okay, but
I'm really comfortable with that. I would like the communities who want to do this to be able to, either through their max or through a direct appeal to the Board of Supervisors, to say, no, we've got this worked out in our neighborhood and we want to stay in. That's fine, but I do want to protect those people like Regina Heights and stuff who just had people move in.
could we simply, in our recommendation to the board, without going into language, just simply recommend that the board consider a method for exclusion from that limitation based on community petition or, some process that the board can develop, where a community could ask for
Add to that.
clemency.
What would it take to create a new zone, as someone had mentioned in one of the letters? Would that be a whole general plan amendment? Is that what it would be?
Yes, most likely.
So that's something that could be considered in the long run,
Yes.
but in the short term, we could do an overlay. I have no idea
Well,
what an overlay is.
it's not really
but-
an overlay. It would just be, I think, if you, and correct me if I'm wrong, if you do this, talking about the sunset, if a community then came in and they kind of have to work through their board member to get there because of money is involved in developing this, then they would come in, whether it's a MAC or just a community group, and maybe when they do come to the table, then that sunset phase, then they can maybe extend it until they get their plan in place. I mean, that's can be worked out in the details, but so that's really not an overlay.
Okay. I
And
just heard
yes,
it.
a new zoning could be developed through a possible general plan process.
And Madam Chair, and just also thinking about the sunset, this may tie into comment that we've heard about trying to establish a destination, a preferred destination location to mitigate numbers of these things. And this is another element, because if we're sunsetting people out, we're basically, they're done unless they can go somewhere else. So the
Rangeland.
seems like the logical thing would be to maybe pursue that more preferred destination for those sites that need to move.
Mm-hmm.
So, do we need another bullet in here addressing Commissioner Little's question?
He's got it.
I think, yeah.
Oh,
We're
all right.
recommending that the board is, develop a community exemption, and they can.
Mm-hmm.
Well, all of them. I mean, it's not just for Laytonville. It would be for any community that's a cultivating community that wants an exception from that sunsetting because their parcels are smaller. That works for me.
Laytonville's only the poster child.
Yeah.
Right. Yeah, it could also be Simpson Lane or Highway 20 in Fort Bragg area,
Camchi or, wherever.
wherever there's a lot of RR2.
Okay, so are we agreeable on that?
We're done.
Mm-hmm.
Agreed.
Okay. So are we, the last bullet point, believe it or not, is are we encouraging outdoor cultivation sites in RR zones by requiring a higher level of discretionary review for indoor sites versus outdoor sites?
So that generated a question for me, and I'm showing my ignorance. But I'm assuming that if you're growing in a hothouse, you can grow all year round. So are the economic advantages for being in for growing in greenhouses, would they offset the cost of the requirement?
Don't know.
Who knows?
Just,
I mean, you know, if they can make more money, then I don't feel so bad about it.
just more general knowledge on my part and comment, if you will. The industry seems to be going to a more light depth environment where they can cycle 3 or 4 crops a year depending on temperature and things like that. So, you know, 365. So there's an economy to that. There's a very solid market as well for the outdoor grown crop as well. So it's balanced, if you will. Not sure what percentage is on which side, but the information I have is that the industry is moving more towards a light deprivation and controlled environment where they can cycle continuous crops, and that cost and revenue obviously associated with the production.
So it'd be fair to say probably not. We're probably not encouraging higher cultivation sites in RR zones. I'd just leave it alone.
Yeah, I'm good with it. I think PG&E is their penalty.
Yeah.
We bypassed. I think we had to refer to the table. Are we deleting RR2 on page 5 out of that table then?
We're recommending.
Yeah,
Yes.
yes. What is the question?
Are we eliminating RR2?
Are we done?
We are eliminating RR2.
In that table, so we need to do that as well.
Okay, so is everybody okay with that?
Recommending it, yes.
Yes. Okay, and is there any other items in this or in any of the other stuff that we want to talk about? Yes.
I have one.
I have a question.
Keep it simple.
This actually was a question from the audience, but an interesting one. Can you confirm that in Table 2 on the proposed ordinance, that the zoning requirements for new medical cannabis cultivation would require the elimination of rangeland from that table?
So for the initial study and that mitigation measure, yes, it would remove rangeland from new grow sites also. Table 2.
Okay, good. Yes, sir.
Are you ready for more questions?
Yes.
In December 15th memorandum, the subject is cannabis ordinance response to comments in the initial study from 12/1. Looks like this.
Yeah. What page you on?
I'm looking at page 4, paragraph 3. And it's related to exemptions for qualified patients. And, you know, that's often going to be, or the possibility of being in a residential neighborhood. And do we need to do anything about the odor? Are they gonna be, you know, if there's a number of complaints, are they gonna be asked to filter the air?
Anybody on the staff care to respond to that?
The odor element that's currently in the cultivation ordinance is copy across language, if you will. It's been in 9.31 since inception, since 2008. This wording was put into the draft ordinance at the time, back in when it was during the ad hoc process. So the enforcement at the end of the day will probably parallel exactly what has been occurring since 2008 as far as odor complaints are concerned.
So if they're creating a nuisance, there'll be some solution for the neighbors?
We hope a solution. Part of it will be tied hopefully to the added enforcement language that we're looking at. Obviously the greenhouse or indoor environment with the proposed mitigation as well as far as filtering requirement for odors, that would be a more desirable situation in a tighter environment in my mind. But I think your question was how would it be dealt with, and the same process will prevail.
All right. So we've considered a solution.
So, going back to the R1, not RR1, but R1 areas, R2 areas, where there are grow houses that are more than 6 plants, so, or 12 if they have 2 permits, I guess. How is that enforced? And I'm thinking specifically of the Regina, El Dorado, Deerwood areas where they have this going on in the R1 areas. How is that being enforced? How can that be controlled?
So it's probably complaint driven, and right now there'd be complaints most likely to the sheriff's office.
And we discussed this numerous times about enforcement being the biggest problem with this whole thing.
Right, and you heard today with new enforcement regulations from legal counsel, so, we're working on it, we're getting there. Do I have an answer for you right now, other than what I just told you? No.
Okay.
Then could I suggest one more recommendation we could make to the supervisors? And that would be that they are anticipating using the money from these permits for enforcement, but they had 4 goals. I think it was, human resources, there were other goals. But maybe we could recommend to them that in the first 3 years of this process, that they devote as much of that revenue as it takes to a vigorous enforcement effort up front. I think it will pay off in the long run, weed out the bad apples, and and then they can take this money and use it for other things as well. But it would really be nice, especially since there is a revenue stream, to encourage them to really pound on enforcement at first.
I think Matt has a question.
And then ease up.
We can add that to the recommendation list.
And it is just a recommendation.
I've been working on changes to the resolution to reflect what we've been talking about. That being said, we did just talk not too long ago about having this interim period where people are applying and we're still figuring these things out. So the issue of enforcement and how much money and how hard to be in the initial years is still complicated.
Well, it is, but I think as a recommendation to the Board of Supervisors, they could at least know that we are concerned about those areas where there are existing bad actors, and that using those funds to clean that up early seems worthwhile to me. I guess my own thinking is that we can create a culture around this in our whole county. That's what we want. And part of that is at the beginning saying, no, you're not doing it our way, move along. And that works for me.
And I think in the R1 areas, it's not legal to grow that much anyway, is it? So it's really just a matter of enforcement.
I thought we were talking about six plants.
Correct.
Would be legal if it was
Greater than
personal
6
use.
plants,
Okay.
or 12 if there's 2 permits.
Well, there wouldn't be anything for 6 plants wouldn't require a permit. That's the exemption to register with the ag department, but that's all that's required. So, but in R1, you would not be able to get any kind of as of right now, as it's presented to the board, R1 existing would be able to at least apply for a permit under as recommended by the Planning Commission. It would be to not consider existing cultivation sites in any, or sunset any existing sites in an R1 zone. All that would be left would be the qualified patient or caregiver exemption in those areas.
Yeah, I thought we were looking at RR1 in everything here, and now I'm asking about R1.
So I believe the direction was any residential zoning would have a sunset provision, so existing sites could remain for whatever period of time we think about sunsetting those. And so that would include R1, suburban residential, RR1.
Well, if
any of
it's
those
not
districts.
legal now in R1, I guess my concern is it needs to be enforced. Not RR1, but R1.
So right now under 9.31, there's no zoning issue whatsoever when there's an allowance for 25 plants, as long as you're meeting certain setback requirements. So in going forward, there'd be no permitting in an R1 zone. There would be the chance that an existing cultivator in an R1 zoning district who meets our standards under the Planning Commission recommendation would then be able to get a permit for a certain amount of years, with the recommendation that that permit sunset and that person move their cultivation to a different parcel, different zoning district.
But how about those that don't get the permit and still want to stay?
So if after the ordinance is adopted, a person who's cultivating larger than the exempted amount does not seek a permit, then those people would not be in compliance with our ordinances.
And it's not the ag commissioner that has to monitor and enforce that, that's the sheriff's department. Is that correct?
Exactly how that's going to go forward in terms of code enforcement. I'm not sure that's been sorted out. Currently, that has been with the sheriff's department in terms of enforcing 9.31 and setbacks.
So, I'm looking at this pack of pages right here.
Figures?
The first is, my question is on the second half, chapter 20, 242. And in the
This is the figures page from LACO, or the figures packet from LACO.
Figures.
And so I'm in section.
Page 34, I believe, right?
No.
No.
I'm in the second part, it's page 8.
So the code section would help, that way we can all get there.
Yeah, it's chapter 20, 242.
And then inside of that,
it's after a couple tables. It says section 242.08. It's under D, minor use permit. Number 4.
D, minor use permit, number 4. Got it.
And it's for new medical cannabis cultivation after 2020. And that is not located in industrial zoning. Submitted MCCO permit application contains evidence and demonstrates 1, 2, and number 2 is the cultivation site has received a CW 404 permit from the Corps of Engineers or a CWA 401 permit from the North Coast Regional Water Quality Control Board. My question is, as applicable. So, does that mean that growers will only have to get these permits if there's an issue, if it's applicable? Or are they going to have to go to the Corps of Engineers and the Water Quality Board regardless?
So I believe if I'm reading it as a planner, I'm going to say that the only time it would, to determine if it's applicable, it would have to be that agency that makes that determination. Planning staff could not make it. They would have to go there, get that determination from them. Am I correct? This is what? It should occur during a referral process.
All right. So how does it work? Do they have to decide if it's applicable? Is there a referral to, let's say,
So
the,
there's a
Corps of
referral,
Engineers?
there's a referral to them, and then depending on their comments back, if the permit's needed, then they would.
Okay, which is very similar to what we discussed earlier. It's not dark yet. I'm a farmer. So now, if I can get organized, I'm looking at December 15th memorandum.
He can respond to him
It's like this.
Bandy,
when it gets to the board.
December 15th memo.
Which one? There were two of them.
A Mary Lynn's memo.
This is Mary Lynn's memo.
Not the one about the Williamson Act, but the other one.
Okay.
This is December 15th. Does it say from staff or does it say from Mary Lynn?
Mary
It
Lynn.
says from
Mary
Mary
Lynn.
Lynn.
All right, so that's the next one. That's December 15th. How about the first, is it the staff report? Go there.
It says
There it is.
memorandum on
There it
the
is.
back.
There it is. Okay. Where are we at now?
So I think we already answered my first question.
Okay.
We've answered my second question.
Keep going.
Yeah, the sunset's coming up here soon. I'm looking at page 7. Existing cultivation sites located in unlisted zoning districts.
Okay. In phase 1,
In phase 1, yeah.
existing
Okay,
cultivation.
last sentence. In addition to the expansion prohibition, these sites may not be transferred to another location, nor may these sites resume operation if they have been abandoned. And I thought that we had discussed that it could be transferred.
This is, so this, say this again? This is coming from the board?
What the heck?
These conditions were put forward by the board on October 18th, I believe. This was the notwithstanding the D portion under Table 1 in the zoning, and the same for the cottage element, all 3 cottage permits inside the cultivation ordinance. That captures these elements here, but this verbiage is capturing the board's input on October 18th.
What
So-
is an unlisted
So is
zoning
this,
district?
this is gonna be a part,
Is
is
that
this
earlier?
is this old news? Is that what you're
Yeah,
saying?
earlier iteration.
Is this old news? Maybe I don't need to have an answer.
So this direction from the board came on October 18th. It was put into both the 20.242, the planning or zoning element, and that is that item D, I think, that we identified right under Table 1.
Mm-hmm.
It lays out in detail all of the conditions for parcels in other zoning districts not listed in the table above. And then
Okay, not listed in the
Not
table,
listed.
unlisted.
Like
right,
RR1.
and so that's what this paragraph is addressing, and the same information was also inserted into the 10A.17 document for the the cottage permits, because that was one of the limitations placed here.
That helps me, thank you.
Yes.
So I'm on page 8, phase 3, it says up the top, permit requirement. And about 2/3 of the way down, there's a 2 dash. That's where I'm at. It reads, finally, Table 2 also shows that small cultivation sites will be subject to a 2-acre minimal parcel. Is that now 5 acres, now that we've eliminated RR2?
So again, the 2-acre requirement for, again, new cultivation sites is current board policy. So I believe one of the recommendations from today is to potentially eliminate that, so.
Yes, no, okay. All right, we already answered that one. So on page 10, the last paragraph, Air 1, So, is this different than what conventional agriculture has to live with? Because I don't recognize it. Yeah, Air One, down at the bottom of page 10.
10. Not exactly the last page.
Oh, yeah, the bottom, bottom of the page, I misspoke.
So this element was inserted, or mitigation rather, proposed in response to the Air Quality Management District's response to the project.
So is that basically if there's major grading?
Well,
They have to have a permit from the air quality?
They cover an array of things, naturally occurring asbestos, if they happen to have diesel generators at a certain horsepower, and things of that nature, particulate emissions and different things. So that was where this referral to them keyed in.
Okay, so basically this just requires a referral.
Yes.
They look at the paperwork and decide whether they have to take further action. It's not that the permittee actually has to go get a permit every time.
It's structured as a referral at this point.
When they go for their permit.
When they apply, fill out an application,
All right,
yes.
okay. And so we touched on this one, and I read where you had some cost analysis, but I guess my main question is that the Ag Commissioner is going to assess what it costs to give out these permits. Is that cost going to be covered, or is that permit going to cover the cost from the planning department as well? Is the county, I'm asking, is the county going to be in the hole based upon, the implementation of this ordinance, or are 99% of the cost going to be covered by the permittees, the applicants?
The cost recovery system for the county is usually driven by department. So a department assesses its costs, sees if its fee structure is appropriate or inappropriate, and would possibly come forward to the board and seek an adjustment on the fees.
And that pardon?
I'm sorry. So this being a brand new program, I projected costs for individuals and services and supplies, et cetera, benefits for the individuals that are going to be staffing this program, and as the Department of Agriculture. So I think your question was more, is planning and building going to recover their costs, or air quality, or whomever else? And it's not my arena, if you will, to try and make their internal departmental assessments on their costs associated with their part in this program, and how they might recoup that.
So Mary Lynn, is the planning department going to be asking for fees?
So we were just discussing that. For a zoning compliance, just a straight zoning review, I'm thinking that we probably will, because right now we have a process if somebody wants something in writing with regards to zoning and all that, we do charge it. And it's a little over $100, somewhere around there. Administrative permit, use permit, yes, there are fees involved with that.
All right, so most of our costs will be covered.
We hope.
Yeah. So the third question I forwarded to you is about rangeland, permitting grows in rangeland. And I'm just wondering if there isn't some mechanism, planning mechanism. I was thinking of the Laytonville overlay, and now I understand it's not an overlay, but is there some planning tool where we could allow grows in rangeland and mitigate the possibility of subdivision, like no grading or some kind of overlay? And we've talked a lot about where grows are not going to be allowed and where they're going to be phased out of. My concern is where they're going to go, and it's going to force the price of vineyard land up to the point where conventional growers can't make a living.
Thank you. Good point. And, you know, this could certainly be something similar to what you were talking about doing in Laytonville. I mean, right now, you know, the direction is to remove the rangeland because of mitigation. If we do some kind of review, that, you know, there'd definitely be a CEQA analysis of how this is going to be affected. So there's that potential.
Yeah, so maybe I skipped a question. My other question is, has there been an analysis of what these ordinances are going to do to the rest of agriculture?
No, not that I'm aware of.
And
I should look to Beth.
yeah.
So I know.
I think the analysis under CEQA is a little bit probably different than you're thinking. For example, we pulled out the residential uses in agricultural because our CEQA concern is that we're converting to a non-agricultural use. So from a CEQA perspective, if we're considering cannabis an agricultural use, then it's not really a conversion, albeit it could still have some of these impacts you're discussing. So I think it might go back to what I think one of the speakers was saying, but just there's sort of these social impacts versus CEQA impacts, and they're all very valid, but the CEQA analysis doesn't quite get us there.
So I guess, you know, what I'd ask the commission is, can we ask the Board of Supervisors to ask the staff, not immediately, not for this particular ordinance, to look into some mitigating measures to allow leasing, maybe leasing only in rangeland, that have mitigating measures which would discourage subdivision. Because, I mean, I don't want to see our large parcels broken up more than anybody else. But I do think there are some good reasons for allowing a limited amount of cultivation, cannabis cultivation in rangeland, if for nothing else, to be a relief valve to prevent the cost of conventional agriculture of going outpricing conventional agriculture.
Weren't there, though, some other impacts in the discussion in the initial study besides just the subdivision aspect, although that was the major one? I mean, there are other impacts from uses on rangeland, and we don't know the pressure that's going to be on the county from people coming in phase 3. I'd be real reluctant to change it now.
I would too, and I think when we look at that, say after 2020, which is after all 3 years away now, it's not the distant future, I think we have not had enough discussion about slope of land and those kind of things, and I think even amongst rangeland, all rangeland is not the same, and for some it is appropriate, for some it is way too steep or too friable or too whatever, or slip prone or earthquake prone or whatever it is. I think that to go to rangeland eventually, which I agree that eventually that may make better sense than RR1, that's for sure. I just don't think all rangeland is the same, and I think we need a clearer process of delineating what rangeland would be acceptable, because I don't think 30-40% slope land is, you know, you could get some idiot in the city to lease that, and they might actually try and drive some big trucks up there, and you know what I mean. It could really be bad.
Well, those are the limiting factors that I didn't detail them, but those are the limiting factors that I think we'd have to look at. You know, maybe one of the limiting factor was you can't do any grading. You know, if you find a flat spot and it already has a road, you can lease that portion. If you're going to go beyond that, it's not acceptable.
I think if we try and change it before phase 3, we are going to be back to CEQA.
Well, you know, I'm just asking to suggest to the board that we look at it. I'm not saying that we should do it right now.
I think you have the same issue with TPZ and FL, where you've got a small timberland owner and he wants to have a garden to get some supplemental income. Maybe he's got to harvest every 30 years or so. There's a real need to have some supplemental income. So I agree with the concept, But I think we need to get this thing on the street and find out how it's gonna work. And then look at that kind of an issue as something totally separate, because it's gotta really be looked at, slope and everything else. But for our work today, I think we should postpone that for the future.
Yeah, I wouldn't agree, I wouldn't
But I-
disagree. wouldn't
but I think it
disagree
should be
with you.
pursued.
I do agree with you, but I'm just hoping we can put it in there so that it's on, you know, their
On the
agenda
record.
to consider. Mhm.
Well, I would support that.
Yes.
All
We're
right.
gonna take a 5-minute break. Get some back teeth to wash here.
So where are we going with this? We're not getting anywhere.
So I think what we're gonna try and do now is, we're not abandoning all questions.
Can we address that last question?
Sure.
Just take a vote on it.
Which, I forget the question.
Can we ask the Board of Supervisors to investigate the possibility of grows on rangeland with stipulations, and not for this particular legislation, but just to get it on the record?
I'd like to add TPZ and FL to that.
But what do we do about certificates of compliance? Because you can't disallow them, can you? Like you can a subdivision?
I'm just asking staff if there's a way to do it so that we don't encourage subdivision. Or so we can discourage the certificates of compliance and yet allow maybe leasing only. You know, I don't know what the answer is.
Well, I don't have any objection to them looking at it, but I would have a lot of objections to including it in what we're doing right now.
Yeah,
I tried to make
So
that,
I
I
am
tried to make
good.
that clear that
Yeah.
I'm not, my intent isn't to include it in this legislation.
I'm
So-
afraid it kind of weakens it though, so I probably will vote no.
So-
I-
You wanna table it?
Yeah, I think we can bring it up again, and I guess what I would substitute as possibly a resolution that or an intent that we transmit to the Board of Supervisors is that we know that this isn't the last we're gonna look at this. And that we need to be flexible, go on our lessons learned, look at these other questions that have cropped up as time goes on, but I'd kinda like to stick to what we got.
There hasn't been any analysis of what this is gonna do to the rest of agriculture.
I agree with that, and I think that's part of why we can't
And that's a problem.
decide this is gonna get set in stone right now.
Oh, I don't think anybody expects that.
Right.
But it will be reflected in the minutes, and the board maybe will read part of the minutes, most of them.
And we have a board
So-
member sitting back there, so.
Yeah, I don't know what the exact parliamentary procedure is, but I'd like to call for a vote.
Okay,
Make a motion.
yeah, make a motion.
I would move that we ask the supervisors at a later date to investigate the possibility of allowing cannabis growing on rangeland with limitations. Is that clear?
Did-
And, sorry, Roger, I left you out. Yes. Well,
So.
I'm gonna
which-
second it so we can get on with discussion.
Okay, so when you say in the future, what's your vision about that?
I don't want to include it in
Phase one?
phase one. Yeah.
Okay. I could support it a lot better in phase one. I think it's still iffy, but.
Can we move with a vote?
Yeah. So all in favor of Commissioner Nelson's suggestion as a recommendation? I'll look at it.
One opposed.
Opposed.
Oh, I
Opposed?
voted for it.
Two opposed. So they can hear that there's some divided support for that. Okay, staff has asked if we could get to editing the actual resolution and take a vote on it so we can all go home. And they're gonna put it up on the board for us.
So you watch Matt type. We're watching.
Where did Matt go? He was the one who wanted.
Matt's hiding
Oh, there he
behind
is.
the box.
I was gonna say, God, we lost one.
Matt, when you're done, can you make the print?
Or you can turn around.
Hello. And this is only a couple pages, it's not enormous.
All right. So I've been working on revisions to the ordinance that was part of your packet during the meeting. I don't believe there's many changes on page 1. I caught several of the typos, one of which was that we were looking at Bio 1 for this mitigation measure, not Bio 2. One of the typo we had looked at was in D, and this the change here that has cultivation plants, making that cannabis plants instead of cultivation. Some of the staff report included changes to the air quality sections of the initial study. So one of which was deleting the words during the flowering phase from the end of the first sentence of the first paragraph, and deleting the second paragraph of that section in its entirety. And everything in this section of the resolution is looking at recommending the board consider the adoption of the initial study and mitigated neg deck in the form attached to the resolution as Exhibit A. That form has been with the Planning Commission for 2 meetings with these changes. The second section is the recommendation regarding the Williamson Act contracts, and I just made that so that recommend the board consider revising the policies and procedures as shown in the form attached to Exhibit B. That document was in front of you today. Section 3 is recommending the board consider the adoption of the ordinance with certain changes. I don't believe we have any changes to the ordinance language per se, beyond what's already laid out here. This includes the very first one, revising the ordinance pursuant to the mitigation measures of the initial study, which would include the rangeland language we've been talking about. Section 4 is this further recommendation the board consider following additional changes to the overall regulation scheme. First, I believe, is eliminate the dwelling unit requirement for parcels in the UR zoning district and to allow new cultivation permits consistent with any future oak woodland protection ordinance or grading ordinance. That was the language in the staff report. The red line shows that the grading ordinance wasn't in the reso, but what did read like that in the staff report. B is regarding the dwelling unit requirement for what's now RR5 and RR10. And it's clarifying that it would be an exception for legal conforming parcels, so over those acreage minimums in these 2 zoning districts, and limiting a typo. It was in the language that was presented to the commission for today's packet. So this is requiring this administrative permit still that may even include setting aside land for primary and reserve leach fields.
May I interrupt before we leave that one? Matt, would you mind?
Please.
I'm assuming that it would be clear to staff in reviewing and to applicants that, say, an RR6 zone, even though it might be in an RR10 neighborhood.
So a 6-acre parcel in an RR10?
Yes, that's right. would qualify for the exemption of a house?
So that would not be a conforming parcel.
It would have to be the full 10 acres in a 10 acre.
5 acre and 10 acre, yep.
Okay.
And next we get into what I believe are additions, and please feel free to correct me if I'm getting these incorrect regarding our discussion today. C is where I think the commission ended up with permits in residential zoning districts. So it would be to allow cultivation permits for existing cultivation sites in all residential zoning districts, but provide a sunset period, after which the cultivator must relocate to a new cultivation site. Not allow cultivation permits for new cultivation sites in the RR2 zoning district. And then consider creating a community-based exemption process from these requirements for certain areas of the county, or developing community-based plans that allow for cultivation in residential zoning districts. With that last sentence being to address potentially certain areas like Laytonville.
No, I'm sorry, go back to that. I'm still having a problem with that.
Okay.
I'm still having a problem with the R1, RR1.
So the first sentence is saying existing cultivation sites in all residential zoning districts. That would include even R1 as they stand. But those sites would be sunsetted after a certain amount of time. I don't know that the commission had a specific time that it was recommending.
I think we were discussing in the 2-year area, something before 2020.
I thought that was RR1 and 2, but I'd still like to move up R1. I don't.
Move up R1.
Well,
So this is just speaking to RR2, because right now we're allowing RR2 to have existing sites. R1, SR, those are not allowed. But this, by this statement, it's saying that any residential zonings then would be subject to a sunset.
Including R1 then.
Right.
Correct.
Right.
But it's not legal in R1. I'm struggling with
So
this.
as the ordinance is currently written, there's this, in the ag ordinance, it's a notwithstanding clause, and there's a whole paragraph D of, I think it's 050, of the zoning ordinance that says, if there's an existing site that was consistent with the requirements under 9.31, so because 9.31 didn't have any kind of zoning requirement, it just allowed 25 plants as long as you met your setbacks, and that may in and of itself have excluded many parcels from compliance with that ordinance. So if there was an R1 parcel that had an existing cultivation site that met all those requirements, as stated in the zoning code, they would be allowed to get a cultivation permit under the ordinance as written.
And continue.
But moving...
Till sunset?
Well, the sunsetting
That's what this
is
is telling
recommendation
us.
by Planning Commission as of today. There has been no sunset in the existing ordinance as written.
So there's no way to move that period up to a year or whatever.
Well, the Planning Commission can recommend a sunset period for that. As of right now, there's no requirement that it end.
But in R1, it's already not allowed. It's more a case of getting the enforcement to make them stop.
Well, R1 would be if it was a
It's allowed
site
for
consistent with our the previous rules, then this is the exception that for existing cultivation sites. So yes, under the ordinance as prepared, an R1 site that was consistent with the 9.31 rules, and there's other factors in the ordinance, if they met all those requirements, they could get a cultivation permit.
And continue.
That's the ordinance as written. That's why there's two different sentences. One's for existing cultivation sites, one's for new cultivation sites.
Well,
So the addition by the Planning Commission would be calling for a sunset period for any existing cultivation sites in any residential zoning district. So within X number of years.
1 year.
I hear you.
Is that a motion?
What's the motion?
1 year.
Oh,
In an R1? They shouldn't be there in the first
Oh,
place.
in an R1?
Not R1.
Yeah, I mean, this is so broad that to make it work in the R1.
All right,
it
I'm gonna
has-
second the motion.
Okay, how does everybody feel about that one?
Everybody?
I don't think 1 year's fair to somebody who is prepared, has been permitted and is prepared to go through this new process. They're not the bad guy.
Please note, this doesn't mean they had a permit under 9.31. It meant they were in compliance with the 25 plant limitation and any other overall rules.
Right, prior, right. I mean, I would hope that enforcement for those that do not comply with a permit and get a permit would be swift. And
So what do you think is fair?
till 2020,
2 years?
or maybe even 3 and maybe 4. Because I think that these people, the ones that are going to want to comply, won't be the problem as much as what they've seen in the past. And maybe I'm wrong, maybe some of these people, some of the grow sites now in R1 are of people who are going to try to get a permit, but they're going to be visited, they're going to be inspected, they're
I'd amend my second for 2 years.
If we get buy-in from everybody, all right. I'll amend it to 2 years.
All right, call for the
All right.
question.
Point of clarification of the can, is this just for R1 or for any residential zone?
there's also SR.
Well, I mean, I think we have to either decide to line out a period for each residential zoning, or we have to say all of them in 2 years.
I would like to say all of them in 2 years.
Does that work for you?
Yes, it does.
I don't know, that's an awful tight timeline, but it's not too tight for the ones that aren't gonna come into the program anyway. Of course not. But for those that might, but then they're awfully small parcels, so. I don't know.
I don't hear any objections.
So, all in favor of the motion on the floor?
Okay.
All opposed? Okay. Okay, moving right along.
So next I have the overarching require adoption of an oak woodland protection ordinance and an expanded grading ordinance prior to issuing new cultivation permits starting in January 1, 2020.
I'll be voting against the whole thing because of that.
Because of what?
Because of that statement, I'm gonna vote against it. I can't vote for that.
Flesh out why there's a D and an E.
What's that?
We're choosing between D and E.
No, this isn't a lettered list underneath an overarching. The Planning Commission further recommends the board consider these following changes. So A was regarding the UR zoning district and its dwelling unit requirement. B was regarding dwelling unit requirement in RR5 and RR10. C is regarding cultivation permits in residential areas. D then is any requiring a new oak woodland protection ordinance. And if I'm wrong on direction, please let me know. E then would be requiring all permit applicants and permittees to obtain a grading permit pursuant to Chapter 18.70 where required by 18.70. Is that sufficient?
Yeah. Yeah, I can support that.
Well, I support the D because of the oak woodlands, and I think we need to have something about these upland slopes. I do. I think we need to change our grading ordinance. Terrible. So, I don't know, I think we only need to vote now if we want to alter the language. We're gonna vote on the whole resolution at the end. So does that work for everybody? Okay. Moving right along.
F would be prior to adoption of an oak woodland protection ordinance, the county shall not approve any cannabis cultivation permit under which any oak tree species would be cut down or otherwise harmed. And I was trying to get to Commissioner Little's language with that. G is create a general requirement that agencies being referred cultivation permit applications from the Department of Agriculture respond within 30 days for comments to be considered. And I would just note, along with what Beth Burke said, to the extent that substantive comments do come in, we may or may not want to still be thinking about those if the permit hasn't been issued. I'm not sure we just want to disregard comments at some point in time from a state agency. That's my caveat. H, provide for vigorous enforcement of the county's ordinances regarding marijuana cultivation. And I, consider future amendments to the cultivation ordinance to allow cultivation with limits in rangeland, TPZ, and forest land.
You got a hand up.
Yes.
Relative to letter H, do I recall that discussion being in the context of revenue?
Yes.
Coming in, so does that need to be
Well, I don't know that
clarified?
we need to decide how they allocate their pennies, but we do know there's a revenue stream there, so that it would not be an acceptable reason to not enforce.
Well, it catches my eye because that's what my department will be involved in, obviously. So we'll be doing enforcement. So the question, I think the context was potentially using some of those other resources as well, and I might have that wrong too. So
I think that was my comment, and mine was that I would like to see as much of that revenue as is needed in the first few years to mount a vigorous enforcement, create a compliant culture in our county, and then after that, it can go to all the other uses it's been designated for.
Perhaps H wants something that identifies what you've just done. Never mind.
Maybe just say provide for funding. Provide funding for vigorous.
So potential suggested language or food for thought, provide for additional funding for enforcement of the county's ordinances.
Whatever works for you
Well-
works for me in there. I want the idea in there that this should be a really big priority early on, and I think it will save us a lot of money down the line. So how would you provide funding? Okay, so what does everybody think of H?
Fine.
Okay, and I
I think it's a good idea.
So are we ready to vote on this resolution? Guess we need a motion. We have a motion, do we have a second?
I'll second.
Okay. All in favor?
Roll call.
Roll call on this one.
Yes, for sure.
Commissioner Kruger?
Yes.
Commissioner Ogle?
Yes.
Commissioner Little?
No.
Commissioner Nelson?
No.
Commissioner Warner?
Yes.
Commissioner Hall?
Yes.
Chair Holtcamp?
Yes.
Passes.
Okay.
I didn't hear your,
Yeah, I voted.
I was asleep.
Voted first.
Okay, do we have any other things we want to do on this item before we move to the rest of our agenda?
No, except that I hope it works for everybody I hope the board approves it as it is, and I hope it works for everybody.
I can't
So
even.
we don't need to discuss these, but I wanted to make sure that staff noted them. Track and trade, county versus the state.
Yes, thanks for bringing that up. I had made some notes to myself real quickly when those comments were being received. So I believe it was Ms. Oswald talked about the track and trace and why is the county moving forward with the track and trace when the state's going to bring one in, and we understand that the track and trace at the state level is now with the California Information Services Program. It's outside of CDFA's control now. So it's it's years down the road. And the concept for us was to get the cultivators used to this, because it will eventually be a requirement, whatever the state program, track and trace program ends up looking like. And at that point, once the state program comes in, they've talked about not being able to interface with local programs. They don't want to try and tackle that headache. So we would just sunset our local track and trace, because cultivators that get their state licenses will be required in that regard. The other track and trace question was about monthly fees, et cetera. Yes, there are fees to be in track and trace, and the industry has used track and trace for years. The dispensaries and large grow operations and things like that for inventory control and things like that. There's very sophisticated track and trace already out there, mostly for the industry. It's just starting for the regulatory side, but there are monthly fees for that. It's a pretty intensive inventory control program, and there will be fees for that. There was one other, not track and trace related, but I wrote down a note. The zip ties, there was a question about, it was repeated that they were voluntary, and as the ordinance is written now, they are voluntary for the patients and caregivers, and they don't have to go get a zip tie with the Sheriff's Department. As was mentioned earlier, patients, caregivers, they'll come in and register very first thing with us, and then we're done. They're not in the permitting program side of things. Purely as a tool to allow the Sheriff's Department to understand, if they roll up on a grow site, they can very quickly determine, oh, this individual is registered as a patient or caregiver, these plants right here are in the system, and they may or may not have gotten a zip tie. If they get it, people are very accustomed to the zip ties and are for better or worse, are accustomed to them, and it could add that extra layer of reassurance, if you will, to the patient or the caregiver that's doing that cultivation. But again, it's completely voluntary, it's not a requirement, but we're throwing it out there as just an added level of communication between enforcement and the patient and caregiver side.
So the other question, and again, I'm not necessarily looking for an answer, but I had some sympathy for the unpermitted grower. He didn't get in under the deadline, and just wondering if he couldn't perhaps become I want to say provisional, get some provisional license. I don't know if that's feasible. The last one is, how can we encourage leasing as an incentive to move gardens out of restricted zoning? I don't know if that needs any work or not, but we want to motivate these people to move out of the neighborhoods, basically. And finally, Frost mentioned wine tank. It's a real issue. In 2008, we lost wines, and we had to do a lot of extra work to make the wines drinkable because of the smoke taint. I think marijuana taint is going to be also a problem when we move it into agricultural areas, or I'm worried that it's going to be a problem. That's all I have to say.
Why can't it be composted?
What's it called?
Taint, it's when it picks up the odor.
No, if you've got a marijuana plant growing right next to a vineyard, it can affect the flavor of the grapes, not the smoke.
Oh, okay.
But smoke taint was an example of wine grape taint from odors.
Well, I think those would be things to look at down the line. I agree with that.
Might have some lawsuits.
I can see these two aspects of agriculture are going to be at loggerheads.
Not
one of these
necessarily,
days.
if everybody's respectable, or respectable.
Any other
That's all I got.
things on this topic? If not, we could move on to matters from staff, if any.
No, nothing.
Matters from commission.
Just one blank, did you?
Any matters from commission? Then we have approval of the November 3rd minutes as our last item.
Two, actually.
Oh, and 17th, yes.
I did submit corrections. Matt, do I need to read each one of? Yes.
Technically, the whole point is to have this reviewed at the end of the meeting. If we could do a brief review of them, or we can continue that to the next meeting.
Is there a lot?
I could do a brief review.
Good.
November 3rd, page 3 of 4.
First time I've ever been.
Top sentence, Chair Warner confirmed the location is approximately 1/2 mile up, and add the word A-N, access road. You already have this, don't you? So I'll just read it for everyone else. Okay, third paragraph, Mrs. Pena informed the commission that the other parcel is located in a different area of Willits than is the current ranch location, and it, so we're adding than and we're adding it. Under matters from staff, Andy Gustafson, the last sentence, they have as a group, has, I guess everybody knows. He thanked the commission for the work they have done as a group and has fond memories of the trust in the planning staff. It's really wordsmithing. Down in 1, 2, 3, 4, 5. Number 6, Mr. Gustafson, begins with Mr. Gustafson. The last sentence, leave out the word but and a capital T for the planning commission. Oops, I guess I have one that was. And then I just kind of had a wordsmithing to make it sound better. Let's see, this would be on number 8, last paragraph. Oh, Fort Bragg and Ukiah really depend on my. Okay, Juliana Cherry and Robert DOSTALEK are planners 3. Mr. Dunnicliff assured the commission that planning will be okay taking the hit of losing Mr. Gustafson, and Nash, whom many commissioners have already worked with, will be in our office periodically to help. So I just kind of wordsmith that one. That's all I had.
And November 17th?
17th. Page 4 of 7, top paragraph, changing the last Sheila Rogers at the last sentence, and felt that the committee plans were the key rather than they key. Let's see, page 5. Yeah, there's kind of an incomplete sentence. Mr. Nash Gonzalez commented that the community plan process was based on public input and would like time to develop and put, and I'm adding put into place, for lack of something better. Third paragraph from the bottom just needs a correction on for purpose of this chapter, any structures built. I believe that's supposed to be after, correct, Adrian? 9/22/15?
Yes.
Okay. Rather than at. Page 6, third paragraph, Mr. Gustafson, know the planning commission would need to express a desire instead of expression. That's it. Sorry, but at least it's over with.
Do we have a motion?
Where'd everybody go?
Yes. I move that we approve both sets of minutes
Okay, and do we have
With
a
corrections.
with the corrections.
Thank you.
Aye.
Aye. And then I think we are to a motion to adjourn.
Can I just go back to the staff comments? I just want to commend all of you for the time and effort you put into getting to this stage. I mean, that was a lot of information, and I think you all really did a really good job on giving back to us. And I thought working with the public was just excellent. I think you guys did a really great job, so we appreciate it. Thank you.
Thank you for all your hard work.
Yes, same. You guys were great. You could help answer questions. You're flexible. It's wonderful.
So I move to adjourn.
Second.
Second.
All opposed, duck.
I gotta get home and plant my garden.